The custody evaluator turned out to be having an affair with the children's father. I discovered the supposedly neutral custody evaluator, assigned to determine my children's living arrangements, was having a secret affair with my ex-husband, deliberately biasing her evaluation to give him full custody. I'm 42 years old, recently divorced after discovering my husband Marcus's affair with a coworker. We have 3 children: Emma, 14, Jacob, 11, and Sophie, 8. The divorce was contentious, and when we couldn't agree on custody arrangements, the court appointed Dr. Patricia Morrison, a licensed psychologist, to conduct an independent custody evaluation and make recommendations to the judge. Dr. Morrison's role was crucial. As a neutral, third-party expert, she would interview both parents, observe us with the children, review home environments, and provide the court with professional recommendations about what custody arrangement would serve the children's best interests. Her evaluation would heavily influence the judge's final decision. I was nervous but confident. I'm a dedicated mother. I've been the primary parent throughout our marriage, managing school schedules, doctor appointments, homework, extracurriculars, and daily care. Marcus traveled frequently for work and was often absent. The children have strong bonds with me, and I assumed any objective evaluation would reflect that. Dr. Morrison began her evaluation 3 months ago. She conducted lengthy interviews with both Marcus and me separately, observed us each spending time with the children, visited both our homes, and reviewed extensive documentation about our parenting histories. During my interviews with Dr. Morrison, she seemed skeptical of everything I said. When I described my close relationship with the children, she questioned whether I was over-involved. When I mentioned concerns about Marcus's frequent absences during the marriage, she suggested I was alienating the children from their father. When I provided examples of my consistent parenting, she framed it as controlling behavior. Meanwhile, Marcus seemed unusually confident about the evaluation outcome. "Dr. Morrison is very thorough," he'd say when we coordinated child exchanges. "I think she's really seeing the full picture." 2 weeks ago, Dr. Morrison submitted her final report to the court. I received a copy through my attorney. The recommendations were shocking. She recommended Marcus receive primary physical custody, with me having limited supervised visitation only on weekends. Her report painted me as emotionally unstable, overly controlling, unable to co-parent effectively, and potentially engaging in parental alienation. It described Marcus as stable, child-focused, and able to provide appropriate structure. This was the opposite of reality. I'd been the stable, consistent parent for 14 years. Marcus had been absent and uninvolved. The report read like it described 2 completely different parents than the ones who actually existed. My attorney was baffled. "This doesn't match any of the documentation we provided. Her conclusions seem disconnected from the actual evidence. Something's very wrong here." I was devastated. A biased evaluation from a court-appointed expert could cost me custody of my children based on lies and distortions. Last week, I was at a restaurant with a friend when I saw Dr. Morrison at a corner table. She was with Marcus. They were holding hands, leaning close, clearly intimate. I watched them kiss before leaving together. The supposedly neutral custody evaluator was having an affair with my ex-husband. She'd deliberately written a biased report to give him custody, not based on the children's best interests or objective evaluation, but because she was sleeping with him and wanted to help her lover win. The evidence of Dr. Morrison's affair with Marcus and her biased custody evaluation became my immediate focus. I documented everything I could and began investigating how long their relationship had been ongoing. I hired a private investigator who confirmed the affair within days. Dr. Morrison and Marcus had been seeing each other for at least 4 months, the entire duration of the custody evaluation. The PI documented hotel visits. Dr. Morrison and Marcus meeting at hotels twice weekly during the evaluation period. Credit card records showed Marcus paying for the rooms. Restaurant dates. Multiple intimate dinners at restaurants outside our city, clearly attempting to avoid being seen by anyone who knew them. Overnight stays. Dr. Morrison's car parked overnight at Marcus's apartment at least 6 times during the 3 months she was supposedly conducting an objective evaluation. Text messages. Through legal discovery, we obtained text exchanges between Dr. Morrison and Marcus discussing their relationship and the custody evaluation. Marcus: when will your report be finished? Dr. Morrison: next week. Don't worry, I'm recommending you for primary custody. Marcus: you're sure the report will hold up? Dr. Morrison: I'm the expert. The judge will follow my recommendations. You'll have the kids. Marcus: thank you. Can't wait to celebrate together when this is over. Dr. Morrison: your ex won't know what hit her. I made sure to describe her as unstable and controlling. They'd been coordinating the biased evaluation. Dr. Morrison had deliberately skewed her professional assessment to benefit her lover, violating every ethical standard of her profession. More text messages revealed they'd started the affair before the evaluation even began. Marcus: the court appointed Dr. Morrison as custody evaluator. I looked her up. Attractive. My type. Friend: you're going to try to sleep with your custody evaluator? Marcus: why not? If it helps me win custody, worth a shot. Within 2 weeks of her appointment, Marcus had approached Dr. Morrison at a professional networking event. They'd begun the affair shortly after, with Dr. Morrison fully aware she was evaluating his custody case. Her conflict of interest was absolute. Yet she'd proceeded with the evaluation, submitted a report to the court, and recommended custody arrangements that benefited her lover, all while presenting herself as a neutral expert serving the children's best interests. I compiled comprehensive evidence: PI photographs and surveillance logs, hotel records, text messages discussing the affair and biased evaluation, timeline showing the relationship began during the evaluation period, and witness statements from people who'd seen them together. My attorney filed an emergency motion to vacate Dr. Morrison's evaluation and disqualify her as custody evaluator. We submitted all evidence to the court, showing the affair and demonstrating her report was the product of bias and conflict of interest rather than professional assessment. The family court judge was furious when reviewing the evidence. Dr. Morrison conducted a custody evaluation while having a sexual relationship with one of the parents? This is outrageous professional misconduct. The judge immediately disqualified Dr. Morrison, vacated her evaluation entirely, and ordered a new custody evaluation with a different psychologist. Marcus's attempt to gain custody through Dr. Morrison's biased report failed completely. But the damage went beyond just our custody case. Dr. Morrison's conduct raised questions about all her previous evaluations. How many other custody cases had she influenced through bias, conflicts of interest, or personal relationships? I reported Dr. Morrison to the State Psychology Licensing Board with all evidence, filed formal ethics complaint detailing the affair, the biased evaluation, the conflict of interest, and the harm to children whose custody placement depended on her supposed objectivity. The licensing board investigated immediately. If these allegations are true, Dr. Morrison has committed severe professional misconduct. Custody evaluations must be objective and free from conflicts of interest. I also reported to the Family Court Administration. The court had a list of approved custody evaluators. Dr. Morrison was on that list, trusted by judges to provide unbiased expert opinions. Her conduct betrayed that trust. The consequences for both Dr. Morrison and Marcus unfolded rapidly across multiple fronts: professional, legal, and personal. The State Psychology Licensing Board held formal disciplinary hearings. Dr. Morrison was charged with multiple ethical violations: conflict of interest, conducting custody evaluation while having sexual relationship with one parent; bias, allowing personal relationship to influence professional assessment and recommendations. Deception, presenting herself as neutral expert while secretly coordinating with one parent. Harm to children, recommending custody arrangements based on personal interest rather than children's welfare. Professional misconduct, violating fundamental ethics of forensic psychology practice. Dr. Morrison attempted to defend herself. My personal relationship with Marcus didn't affect my professional judgment. My evaluation was based on objective observations. The licensing board reviewed her report alongside evidence of the affair. The timeline was damning. Every interview with Marcus occurred shortly before or after their hotel meetings. Her most critical assessments of me were written the same days she had overnight stays at Marcus's apartment. One board member confronted her directly. You recommended limited supervised visitation for a mother with no history of abuse or neglect. You described her as emotionally unstable, without clinical evidence. Meanwhile, you were sleeping with the father and texting him assurances you'd give him custody. How is that objective? Dr. Morrison had no credible response. The board unanimously voted to revoke her psychology license permanently. The decision stated, Dr. Morrison's conduct represents the most egregious violation of professional ethics. She exploited her position as court-appointed expert to benefit her sexual partner, causing immeasurable harm to children and undermining public trust in custody evaluations. The family court system took additional action. The presiding judge issued a scathing order. Dr. Morrison violated the fundamental trust placed in court-appointed custody evaluators. Her actions were not merely unprofessional, they were fraudulent. This court relied on her supposed expertise to make decisions affecting children's welfare. She betrayed that trust for personal romantic interest. Dr. Morrison is permanently banned from serving as custody evaluator or expert witness in this jurisdiction. The court administrator launched a review of all custody cases where Dr. Morrison had served as evaluator in the past 5 years. Dozens of families were notified that their cases might have been affected by biased evaluations. Several families filed motions to revisit custody arrangements that had been based on Dr. Morrison's recommendations. Some discovered troubling patterns. Cases where she'd recommended custody to fathers she later dated or had relationships with. Criminal charges followed. The district attorney prosecuted Dr. Morrison for fraud, accepting payment for professional services while concealing disqualifying conflicts of interest. She'd been paid thousands of dollars by the court to provide objective evaluations while secretly coordinating with one parent. Marcus faced consequences as well. The family court judge sanctioned him for fraud and misconduct. Mr. Marcus initiated and maintained a sexual relationship with the court-appointed evaluator for the explicit purpose of obtaining favorable custody recommendations. This is fraud upon the court. Marcus's custody petition was denied, with prejudice. The judge's order stated, given Mr. Marcus's willingness to corrupt the custody evaluation process through sexual relationship with the evaluator, this court has serious concerns about his judgment and character. Primary custody is awarded to the mother. I received primary physical custody of Emma, Jacob, and Sophie. Marcus was granted supervised visitation only, with requirement to complete parenting classes and therapy before any custody expansion would be considered. The new custody evaluator, thoroughly vetted and monitored, conducted a genuinely objective assessment. Her report confirmed what I'd known all along. I was the primary attachment figure for all 3 children, provided stable and appropriate care, and should maintain primary custody. Emma, Jacob, and Sophie live with me full-time now. They see Marcus on supervised visits twice a month. The children were relieved when the custody stayed with me. They'd been terrified by the idea of moving to Marcus's apartment and having limited time with me. I was so scared when Dad said we'd have to live with him, Emma told me. I didn't understand why. You're our mom. You've always taken care of us. Professional organizations in psychology condemned Dr. Morrison's conduct. The American Psychological Association published ethics guidelines using her case as an example of catastrophic professional failure. Custody evaluators nationwide received additional ethics training on conflicts of interest, with Dr. Morrison's case used as cautionary tale of destroyed career and harmed children. Dr. Morrison lost everything: her license, her career, her professional reputation, her income. She faces criminal fraud charges and civil lawsuits from families whose custody cases she corrupted. Marcus lost his custody bid and his relationship with Dr. Morrison, which ended immediately after her license revocation. The affair had been transactional for both of them. Once it failed to deliver custody, neither maintained interest in the relationship. Do I forgive either of them? Never. They tried to take my children from me through fraud and professional corruption. My children are home with me where they belong. Marcus sees them occasionally under supervision. Dr. Morrison is gone from their lives entirely. Her corrupted evaluation thrown out, her professional career destroyed. Some betrayals involve weaponizing professional systems. Dr. Morrison and Marcus's was one of them. They're paying for it. Revoked license, lost custody, criminal charges, destroyed reputation. I paid for it too. Months of stress, fear of losing my children, legal costs, trauma. But I won. My children are with me. The custody they tried to steal through corruption remains with their mother. That's enough. Not what I wanted. I wanted a fair evaluation from the start. But it's what Dr. Morrison and Marcus earned through their affair and fraud. They wanted to use professional corruption to steal my children. Failed completely. I wanted my children safe with me. Have that. Permanently now. Dr. Morrison wanted to help her lover win custody. Destroyed her career instead. Marcus wanted primary custody through corrupted evaluation. Got supervised visitation instead. Fair outcomes, just consequences, appropriate results. Emma, Jacob, and Sophie are home. That's all that matters. Everything else, Dr. Morrison's destroyed career, Marcus's lost custody, is just the natural result of their choices. They corrupted a custody evaluation, lost everything. I kept my children. That's justice for attempted parental theft through professional fraud. When adult children secretly had me declared legally incompetent to control medical decisions. I discovered my adult children had successfully petitioned a court to declare me legally incompetent and appointed themselves as my legal guardians without my knowledge, giving them control over my medical decisions and personal autonomy. I'm 53 years old, healthy, cognitively sound, and working full-time as a college professor. I have 2 adult children, Marcus, 31, and Olivia, 28. I've been a single parent since their father died when they were young, raising them while building my career and maintaining my independence. 3 months ago, I was diagnosed with early-stage breast cancer. The prognosis was excellent, highly treatable with surgery and radiation, 95% 5-year survival rate. My oncologist recommended a lumpectomy followed by targeted radiation therapy, a standard treatment protocol with minimal impact on quality of life and excellent outcomes. Marcus and Olivia had different ideas. They pushed aggressively for a double mastectomy, removal of both breasts, despite cancer being present in only one and being early stage. You need the most aggressive treatment possible, Marcus insisted. Double mastectomy eliminates all risk of recurrence. Dr. Patterson says a lumpectomy is the appropriate treatment for my stage and type of cancer. A double mastectomy would be medically unnecessary given my diagnosis. Olivia was equally insistent. We're thinking about your long-term survival, Mom. We want you to have the most aggressive possible treatment. I appreciate your concern, but this is my body and my medical decision. I'm following my oncologist's recommendation. They were unhappy with my choice, but I thought they'd accepted it. I scheduled the lumpectomy for 6 weeks out, continued working, and prepared for a relatively straightforward treatment plan. 2 weeks ago, I went to my pre-surgical appointment. The surgical coordinator pulled up my file and frowned. There's a note here that all medical decisions require approval from your legal guardians, Marcus and Olivia. They'll need to sign consent forms for any procedures. What? I don't have legal guardians. I'm 53 years old and fully competent. The coordinator showed me the documentation in my medical file. A court order dated 1 month ago, declaring me legally incompetent due to diminished mental capacity, and appointing Marcus and Olivia as co-guardians with authority over my medical decisions, financial matters, and living arrangements. This is impossible. I never attended any competency hearing. No one evaluated me. How can I have been declared incompetent without my knowledge? I immediately contacted an attorney who pulled the court records. The guardianship petition filed by Marcus and Olivia claimed I was experiencing early-onset dementia, making irrational medical decisions, and unable to care for myself safely. They'd submitted affidavits from a doctor I'd never heard of, claiming to have evaluated me and found me incompetent. The hearing had been scheduled at 8 a.m. on a weekday when I was teaching. Neither Marcus nor Olivia had told me about it. A guardian ad litem was appointed to represent my interests, but never contacted me. The judge, presented with uncontested medical evidence of my supposed incompetence and no appearance by me to defend myself, granted the guardianship petition. Marcus and Olivia now legally controlled my medical decisions, my finances, and could make decisions about where I lived and how I spent my time. They'd essentially taken away my legal autonomy as an adult, and they'd done it to force me to undergo the double mastectomy I'd refused. When I confronted them, Marcus was unapologetic. We had to do this for your own good. You were making a dangerous medical decision. As your guardians, we can now approve the appropriate treatment, the double mastectomy. They'd taken away my legal rights as an adult to control my own medical treatment for breast cancer. The full scope of what Marcus and Olivia had done became clear through my attorney's investigation. They'd orchestrated a fraudulent guardianship proceeding to seize control of my life because I'd refused their preferred cancer treatment. The guardianship petition contained fabricated evidence, false medical evaluation. The doctor who'd supposedly evaluated me and declared me incompetent didn't exist. Dr. Robert Mitchell had no medical license in our state, no practice, no verifiable credentials. Marcus and Olivia had invented a doctor and created fake medical reports claiming I had early-onset dementia and was unable to make rational decisions. Forged statements. The petition included statements supposedly from colleagues at the university where I teach, claiming I'd been showing memory problems and confusion at work. My department chair confirmed these statements were fabrications. I'd received excellent performance reviews and showed no signs of cognitive impairment. Manipulated hearing. Marcus and Olivia had scheduled the guardianship hearing at a time they knew I'd be teaching, ensuring I wouldn't appear. They'd told the court I'd been properly notified, but refused to attend, presenting my absence as evidence of my incompetence rather than lack of notice. Guardian ad litem failure. The attorney appointed to represent my interests had never contacted me, never investigated the claims, and had simply accepted Marcus and Olivia's evidence as truthful. He'd recommended the guardianship be granted without ever speaking to the person he was supposed to represent. The court order gave Marcus and Olivia sweeping powers. Medical decisions. All healthcare decisions required their approval. I couldn't consent to my own medical treatment. Financial control. They had authority to manage my bank accounts, access my funds, and make financial decisions on my behalf. Living arrangements. They could decide where I lived and whether I could live independently. Personal autonomy. They could make decisions about my daily activities, social interactions, and personal choices. Text messages between Marcus and Olivia revealed their motivation. Marcus: the guardianship petition was approved. We're legally her guardians now. Olivia: so we can force the double mastectomy? Marcus: exactly. Mom can't refuse treatment anymore. As her guardians, we consent to the procedure on her behalf. Olivia. She's going to be furious when she finds out. Marcus. She'll get over it. This is for her own good. We know what medical treatment she needs better than she does. They'd literally taken away my legal rights as an adult to force me to undergo surgery I'd refused. A medically unnecessary double mastectomy for early-stage cancer that could be treated with less aggressive procedures. More messages showed they'd planned this for weeks. Olivia. What if Mom finds out about the guardianship hearing and shows up? Marcus. I scheduled it for 8 a.m. Tuesday. She teaches at 8 a.m. Tuesdays. She'll never know about the hearing until after it's granted. Olivia. And the fake doctor report? Marcus. I created all the documentation. Looks legitimate. Court won't verify it if we present it officially. They deliberately committed fraud, inventing a doctor, creating false medical reports, lying to the court, and manipulating the hearing schedule to prevent my participation. My attorney filed emergency motions to vacate the guardianship. Motion to set aside order, arguing the guardianship was procured through fraud, with fabricated medical evidence and without proper notice. Motion for immediate termination, requesting instant restoration of my legal rights given the fraudulent nature of the guardianship. Motion for sanctions, requesting penalties against Marcus and Olivia for fraud on the court. We also filed criminal complaints for fraud, forgery, creating fake medical documents, and conspiracy. The emergency hearing was scheduled within 48 hours. I appeared personally, along with my oncologist, my department chair, and a court-appointed psychologist who'd evaluated me. The court's response to Marcus and Olivia's fraudulent guardianship was swift and severe. The emergency hearing exposed the complete fabrication of evidence and the violation of my fundamental rights. The judge was furious. The petitioners obtained guardianship through wholesale fraud. They invented a doctor, created false medical reports, manipulated the hearing schedule, and lied about providing notice. This is one of the most egregious abuses of the guardianship system I've encountered. My oncologist testified. This patient has early-stage breast cancer with excellent prognosis. A lumpectomy is the medically appropriate treatment. She's fully competent to make this decision. There's no medical basis for guardianship. The court-appointed psychologist who'd evaluated me testified. I conducted comprehensive cognitive testing. This woman has no cognitive impairment, no dementia, no mental health issues affecting decision-making capacity. She's fully competent. My department chair testified. Professor has no performance issues, memory problems, or signs of cognitive decline. She's an excellent teacher and researcher. The statements in the guardianship petition claiming otherwise are false. The forensic document examiner testified. The medical reports, supposedly from Dr. Robert Mitchell, are forgeries. Dr. Mitchell doesn't exist. These documents were created by the petitioners, not by any medical professional. The judge reviewed all evidence and rendered immediate ruling. The guardianship is vacated in its entirety. All rights are restored to the respondent immediately. The petitioners engaged in fraud on this court and will face consequences. The guardianship was terminated. My legal rights, medical autonomy, financial control, personal freedom were fully restored. Marcus and Olivia lost all authority they'd fraudulently obtained, but the judge didn't stop there. This court takes guardianship fraud seriously. The petitioners will be reported to the district attorney for criminal prosecution. They're also sanctioned $50,000 each for fraud on the court. Criminal charges followed quickly. Fraud, obtaining guardianship through false pretenses and fabricated evidence. Forgery, creating fake medical documents and doctor credentials. Identity theft, using invented doctor's identity to create fraudulent medical reports. Conspiracy, planning and executing the fraudulent guardianship scheme together. The prosecutor emphasized the violation. The defendants stripped their mother of legal rights as an adult, her medical autonomy, financial control, and personal freedom through systematic fraud. They invented a doctor, forged medical reports, lied to the court, and manipulated the hearing process. The motive was forcing their mother to undergo surgery she'd refused. Marcus and Olivia pled guilty to reduced charges, fraud and conspiracy, avoiding trial. Both received 18 months in prison, 5 years probation, restitution for my legal fees, and permanent restraining orders. The guardian ad litem who'd failed to contact me or investigate the claims faced disciplinary proceedings from the state bar. You were appointed to protect the alleged incapacitated person's interests. You never contacted her, never investigated whether the claims were true, and recommended guardianship without any independent verification. This is complete failure of your duties. He was suspended from guardian ad litem appointments pending investigation. Court administration launched review of all recent guardianship cases to identify other potential fraud. If this happened once, it may have happened in other cases where the alleged incapacitated person didn't have resources to fight back. I proceeded with my chosen treatment, lumpectomy followed by radiation, exactly as my oncologist recommended. The surgery was successful. Cancer was completely removed, no additional treatment needed beyond radiation. I remained in control of my own medical decisions throughout. Marcus and Olivia's relationship with me is permanently destroyed. You took away my legal rights as an adult, tried to force me to undergo surgery I didn't want, committed fraud to control my medical decisions. That's unforgivable. Extended family was horrified. They had their mother declared incompetent? Through fraud? To force a double mastectomy she'd refused? That's insane. Medical advocacy groups used the case to highlight patient autonomy. Competent adults have the right to make their own medical decisions. Family members who disagree can't simply seize control through fraudulent guardianship. Guardianship reform advocates cited the case. This demonstrates how guardianship systems can be abused. Stronger safeguards are needed to prevent fraud and protect alleged incapacitated persons' rights. Do I forgive Marcus and Olivia? No. They stripped me of fundamental rights to force their medical preferences. Can our relationship recover? No. They proved they'll commit fraud and violate my autonomy when they disagree with my choices. I'm cancer-free now. Treatment successful. Medical decisions made by me, not by children who'd fraudulently seized control. Some betrayals involve stealing legal autonomy. Marcus and Olivia's was one of them. They're in prison. I'm free, legally and medically. Fair outcome, just consequence, appropriate result. My body, my decisions, my rights, restored despite their fraud. They wanted control through guardianship, got criminal records instead. I wanted medical autonomy. Have it. Never lost it legitimately, only through fraud that was overturned. Cancer's gone. Treatment successful. Rights intact. Children imprisoned for trying to take those rights. That's where we are, where their choices led. Some parents can't accept adult children's medical decisions. Marcus and Olivia proved that. But courts can restore rights taken through fraud. I proved that. They're paying for guardianship fraud. I'm exercising restored autonomy. Fair trade, just ending. Appropriate conclusion. Living life on my terms, making my own medical decisions, controlling my own body. Everything they tried to take, everything I kept or recovered. That's enough. That's victory. That's justice. Despite them, beyond them, without them. Free, autonomous, healthy, rights intact. Perfect ending to their failed control scheme. Adult son was sabotaging pacemaker settings during medical appointments to induce heart failure. I discovered my adult son, a cardiac device technician, had been remotely accessing and reprogramming my pacemaker for 7 months to cause dangerous heart rhythms and accelerate heart failure, planning to eventually suggest I sign a DNR order. I'm 54 years old, living with a heart condition that requires a pacemaker, an implanted device that regulates my heartbeat and keeps my heart functioning properly. I've had the pacemaker for 3 years, and it's given me a normal, active life after years of dangerous arrhythmias. My son Derek is 29, works as a cardiac device technician at a major hospital, and has the technical expertise to program and troubleshoot pacemakers and defibrillators. Derek lives about an hour away but visits regularly, ostensibly to check on my health. He's always been interested in my pacemaker, asking about settings, discussing how it's programmed, offering to review my device interrogation reports from my cardiologist. I appreciated his professional interest and concern. 7 months ago, I started experiencing symptoms I hadn't had since before the pacemaker. Dizziness, extreme fatigue, episodes of rapid heartbeat, and occasional chest discomfort. My cardiologist checked the pacemaker at my regular appointment. "Your device is functioning normally. Settings are appropriate. I'm not sure why you're experiencing these symptoms. Could the pacemaker need adjustment? The programming looks optimal for your condition. Let me run more tests." The test showed my heart wasn't responding to the pacemaker as efficiently as it had been. My cardiologist adjusted settings, but the symptoms persisted. Over the following months, my heart function gradually declined, despite the pacemaker supposedly working correctly. "I'm concerned," my cardiologist said during a follow-up. "Your pacemaker is programmed appropriately, but your heart isn't maintaining proper rhythm. We may need to consider more aggressive interventions, possibly upgrading to a biventricular pacemaker or discussing heart transplant evaluation if function continues declining." Derek was present at several of these appointments, using his professional credentials to sit in on consultations. "I can review Mom's device settings if that would help," he'd offer to my cardiologist. "I work with these systems daily and might spot something subtle." My cardiologist appreciated the offer. Having another expert review the programming could be valuable. Derek would stay after appointments, connecting his programmer device to my pacemaker, reviewing settings and making what he claimed were minor optimizations to help with my symptoms. Each time he'd assure me, "Just fine-tuning things, should help with the dizziness." But the symptoms got worse, not better. My heart function continued declining. My quality of life deteriorated. I was too tired to work full-time, too dizzy to drive safely, too weak to do normal activities. Doctors discussed advanced directives and end-of-life planning. Derek started bringing up DNR orders. "Mom, with your heart function declining this much, have you considered a do not resuscitate order? If your heart stops, resuscitation might cause more harm than good at this stage." "I'm only 54. I'm not ready to give up on treatment. I'm just saying you should think about quality of life versus prolonging suffering. A DNR might be the compassionate choice." Last month, my pacemaker suddenly malfunctioned during the night, completely stopped pacing, causing my heart to go into dangerous irregular rhythm. I woke, gasping for breath, heart racing chaotically. Derek happened to be staying over that night and called 911. EMTs stabilized me and rushed me to the hospital, where emergency cardiac team had to override the pacemaker and manually regulate my heart rhythm. The hospital's device specialist examined my pacemaker the next day. "Something's very wrong here. Your pacemaker settings have been repeatedly modified, changed from optimal settings to parameters that would actually worsen your heart function. These aren't adjustments a cardiologist would make. Someone with programmer access has been sabotaging your device." Investigation revealed Derek had been remotely accessing my pacemaker using his hospital credentials and programmer device, systematically changing settings to cause the symptoms and heart function decline I'd experienced for 7 months. The device specialist's discovery that my pacemaker had been systematically reprogrammed to harmful settings led to immediate investigation by hospital administration, pacemaker manufacturer security, and law enforcement. The evidence of Derek's sabotage was preserved in the device's internal memory. Pacemaker devices maintain detailed logs of every programming change: date, time, what settings were modified, and which programmer device made the changes. My pacemaker's log showed 27 unauthorized programming sessions over 7 months. Derek had accessed my pacemaker remotely using his hospital's programmer system, each time making changes that worsened my heart function. Systematic sabotage pattern. Derek would lower pacing thresholds, making pacemaker less responsive, reduce rate response settings, preventing appropriate heart rate increases with activity, and modify sensing parameters, causing device to misinterpret heart signals. Each change was individually subtle, but collectively caused severe deterioration. Timing correlation. Programming changes occurred during or immediately after my cardiology appointments when Derek was reviewing settings to help. He'd claimed to be optimizing my device while actually sabotaging it. Progressive worsening. The modifications became more aggressive over time, each adjustment causing greater heart dysfunction, demonstrating deliberate escalation toward life-threatening outcomes. The device specialist showed me the evidence. Someone with your son's credentials accessed your pacemaker 27 times in 7 months. Each time, they made changes that would cause symptoms and worsen heart function. This wasn't optimization. This was systematic sabotage designed to induce heart failure. Why would Derek destroy my heart function? Further investigation revealed Derek's motive through communications on his work computer and personal devices. Text messages with his wife showed financial stress and discussions about inheritance. Derek's wife. We can't keep living paycheck to paycheck. When will things get easier? Derek. Working on it. Mom's heart is getting worse. Once she passes, we'll inherit the house and can finally get ahead financially. Wife. I thought her pacemaker was helping. Derek. Pacemakers can fail. Heart disease progresses. These things happen. More messages showed Derek had been researching how to make pacemaker sabotage appear like natural device failure or disease progression. Derek to colleague. Hypothetically, if someone wanted to make a pacemaker less effective without being obvious, what settings would they modify? Colleague. That's a weird question. Why would anyone want to do that? Derek. Just curious about failure modes. Professional interest. He'd been gathering information about how to kill me slowly through pacemaker sabotage, while making it appear my heart disease was naturally progressing despite treatment. Searches on Derek's devices showed, how long can someone live with declining heart function? Pacemaker settings that reduce cardiac output. DNR order versus full code for heart failure patients. Inheritance laws when parent dies with pacemaker. The DNR conversations took on sinister meaning. Derek had been trying to convince me to sign a do not resuscitate order so that when his pacemaker sabotage eventually caused cardiac arrest, medical staff wouldn't revive me. Medical records showed the correlation. My heart function had been excellent before Derek started modifying settings, then declined steadily with each sabotage session, reaching near failure levels after 7 months of systematic programming changes. Cardiologists reviewed my treatment timeline. This patient's heart function declined dramatically over 7 months, despite appropriate medical care and supposedly optimal pacemaker settings. We were preparing for transplant evaluation. Learning the pacemaker was being sabotaged explains everything. Her heart wasn't failing naturally. It was being actively harmed by malicious programming. The manufacturer's security team testified. Pacemaker programmers are supposed to be used only by authorized medical personnel for legitimate patient care. The defendant used his professional access to repeatedly modify his mother's device in ways designed to cause heart failure. This is unprecedented abuse of medical device security. I filed police reports, and Derek was arrested. Criminal charges: attempted murder, systematically sabotaging life-sustaining medical device with intent to cause death; assault with deadly weapon, using pacemaker programmer as weapon to cause bodily harm; computer fraud, unauthorized access to medical device systems; abuse of professional credentials, misusing hospital access to commit crimes. The prosecution proceeded on all charges with overwhelming evidence from pacemaker logs, Derek's communications, and medical testimony. The case highlighted unprecedented abuse of medical technology by someone who should have been protecting patients. Derek's trial revealed the calculated nature of his plan. The prosecutor. The defendant used his professional expertise as cardiac device technician to systematically sabotage his mother's pacemaker over 7 months. He made 27 unauthorized programming changes designed to worsen her heart function, cause symptoms, and accelerate toward heart failure. His motive was financial. He wanted to inherit her assets. His method was using medical technology as a murder weapon. Device security experts testified, every pacemaker programming change is logged with timestamp, settings modified, and programmer ID. We traced all 27 sabotage sessions to the defendant's hospital credentials and programmer device. He abused his professional access to attempt murder. Cardiologists testified. The victim's heart function declined from stable to near failure over 7 months due to pacemaker settings being changed from optimal to harmful. Settings were modified to reduce pacing support, worsen rate response, and cause the device to misinterpret heart signals. Without proper pacing support, her heart deteriorated rapidly. Medical device ethicists testified. Patients trust that medical professionals will use their expertise and access to help, not harm. The defendant violated fundamental medical ethics by weaponizing technology he was trained to use for healing. My testimony described the experience. I went from active, healthy pacemaker patient to near heart failure in 7 months. I trusted my son's medical expertise when he offered to review my device settings. He was using that access to slowly kill me. Derek's text messages about inheritance and DNR orders showed premeditation and motive. The jury heard him discuss my declining heart as pathway to getting ahead financially and researching pacemaker sabotage methods. Derek's defense claimed he was trying to optimize my device, and changes were well-intentioned medical adjustments. My client used his professional knowledge to try to help his mother. The programming changes were attempts at optimization, not sabotage. Medical experts destroyed this defense. These weren't optimization attempts. The changes systematically worsened function. No competent device technician would make these modifications thinking they'd help. The defendant knew exactly what he was doing, causing heart failure through pacemaker sabotage. Manufacturer representatives testified. Our security logs show the defendant accessed the victim's device remotely multiple times without authorization. He wasn't present at medical appointments for many of these programming sessions. He was secretly modifying her pacemaker without her or her doctor's knowledge. The jury convicted on all counts. Derek received 20 years in prison for attempted murder using medical device, permanent revocation of medical credentials, and lifetime ban from working with medical technology. My pacemaker was completely reprogrammed by trustworthy specialists. Settings returned to optimal parameters. Within weeks, symptoms resolved and heart function began improving. Follow-up testing 6 months later. Your heart function has returned to pre-sabotage levels. The pacemaker is working beautifully. You should have normal life expectancy. The 7 months of deterioration reversed once the device was programmed correctly again. Derek's sabotage had caused temporary damage, but not permanent heart failure. Extended family was horrified. Derek sabotaged your pacemaker for 7 months, trying to cause heart failure so he could inherit? That's monstrous. Medical device industry implemented new security protocols, enhanced authentication for remote programmer access, alerts when settings are changed outside normal parameters, and better tracking of who modifies devices. Professional licensing boards used the case in ethics training. This defendant abused professional credentials and medical technology to attempt murder. It demonstrates why strict access controls and ethical oversight matter. Patient advocacy groups. Trust your body. If symptoms suddenly worsen despite treatment, question everything, including whether medical devices are functioning as intended. Do I forgive Derek? Never. He tried to kill me slowly, using technology he was trained to use for healing. Can our relationship recover? No. He spent 7 months destroying my heart function to profit from my death. Derek's in prison, pacemaker properly programmed, heart function restored, life reclaimed from his sabotage. Some betrayals involve weaponizing medical technology. Derek's was one of them. 20 years he'll serve. 7 months he sabotaged my pacemaker. 54 years I've lived, nearly lost to his greed. Numbers that tell the story. Prison time that equals justice. Years I'm reclaiming. Living with verified pacemaker settings. Trusting new device technicians. Rebuilding health Derek tried to destroy. Heart function restored. Professional credentials revoked. Son imprisoned. Everything he tried to take. Everything I recovered. That's enough. Finding out an adult son had been impersonating a dead twin for insurance fraud. I discovered my adult son had been impersonating his deceased twin brother for 3 years to collect disability benefits, while working full-time under his own identity. I'm 52 years old, mother to identical twin sons. Or I was. Nathan died in a car accident 3 years ago at age 27. His twin brother Evan survived. Losing Nathan devastated our family. As identical twins, Evan and Nathan had been inseparable their entire lives. Nathan's death felt like Evan lost half of himself. After Nathan's death, Evan struggled with grief and depression. He'd moved back home temporarily to process the loss. I supported him through the darkest period, watching my surviving son grieve his twin in ways that broke my heart. Eventually, Evan seemed to recover. He got his own apartment, resumed work, started rebuilding his life without his brother. Nathan had been receiving disability benefits before his death. He'd suffered a serious back injury 2 years before the accident and qualified for permanent disability payments. After his death, I notified Social Security Administration and the private disability insurance company. The benefits stopped, as they should have. Or so I thought. 6 months ago, I received a strange call from Nathan's former disability insurance company. We're conducting a routine verification check on Nathan's continued disability status. Can you confirm his current address and employment status? Nathan passed away 3 years ago. I notified your company immediately after his death. His benefits should have been terminated. Long pause. Ma'am, we have no record of Nathan's death being reported. His benefits have continued uninterrupted. In fact, we have documentation of his ongoing medical appointments and reevaluations confirming continued disability. That's impossible. Nathan died in a car accident 3 years ago. I have the death certificate. The insurance investigator became very interested in this discrepancy. Within a week, they'd launched a formal investigation. What they discovered was shocking. Someone had been impersonating Nathan, attending medical appointments under his identity, submitting documentation to maintain disability benefits, and collecting monthly payments for 3 years. The investigation focused on who could successfully impersonate Nathan. As an identical twin, Evan was the obvious suspect. The insurance company reviewed medical appointment records. All appointments for Nathan's disability reevaluations had occurred in the city where Evan lived, not where Nathan had lived before his death. Surveillance footage from medical offices showed Evan arriving for appointments, but signing in as Nathan, using Nathan's social security number and insurance information. Banking records revealed Nathan's disability payments were being deposited into an account opened after his death. An account with only Evan's signature on file, but using Nathan's personal information. When confronted by insurance investigators, Evan initially denied everything. But the evidence was overwhelming. Video footage, handwriting analysis, banking records, testimony from medical providers who'd examined Nathan without realizing they were seeing Evan. Eventually, Evan admitted it. He'd been impersonating his dead twin brother for 3 years to fraudulently collect disability benefits while working full-time under his own identity, essentially maintaining 2 identities and 2 income streams. The fraud totaled over $110,000 in disability benefits that should have stopped when Nathan died. But the fraud went deeper than just the benefits. Evan had been living a double life, attending medical appointments as Nathan, maintaining Nathan's disability claim, collecting benefits in Nathan's name, all while working his own full-time job as Evan. "Why?" I asked when I confronted him. "Why would you do this? You're desecrating your brother's memory." "I needed the income. The benefits were just sitting there. Nathan didn't need them anymore. It seemed like a waste to let them end." He'd turned his twins' death into a financial opportunity, exploiting their identical appearance to commit fraud using his dead brother's identity. The full scope of Evan's fraud became clear through the insurance investigation and subsequent criminal inquiry. He hadn't just collected benefits. He'd created an entire false identity for his deceased twin to maintain the fraud long-term. The insurance company's investigative report detailed the systematic deception. Medical appointments. Evan had attended 26 medical reevaluation appointments over 3 years under Nathan's identity. He'd memorized Nathan's medical history, described symptoms consistent with Nathan's back injury, and convinced doctors he was Nathan, receiving ongoing disability treatment. Documentation fraud. Evan forged Nathan's signature on countless forms: benefit verification documents, medical consent forms, banking paperwork. Handwriting experts confirmed the signatures were Evan's attempting to replicate Nathan's. Identity maintenance. Evan kept Nathan's driver's license. They were identical twins, so the photo worked for both. Nathan's social security card, and other identification documents. He used these to prove Nathan's identity at appointments and banks. Financial fraud. The disability benefits were deposited into an account Evan opened using Nathan's information, but with his own signature. He'd walk into banks as Nathan, using his twin's ID, then access the same accounts as Evan. Bank staff never questioned why Nathan and Evan looked identical, assuming they'd noticed at all. Dual income streams. Evan worked full-time as himself, earning approximately $65,000 annually, while simultaneously collecting $36,000 yearly in disability benefits as Nathan. His total annual income was over $100,000, half of it fraudulent. Text messages between Evan and a friend revealed how he rationalized the fraud. Evan: "Went to another medical appointment as Nathan today. They still think I'm him." Friend: "Dude, you're committing fraud. This is insane." Evan: "Nathan's dead. The benefits don't help him anymore. Why should they go to waste when I can use them?" Friend: "Because they're not yours. This is identity theft of your dead brother." Evan: "We're identical twins. His identity is basically my identity. I'm just continuing what would have been his if he'd lived." He'd convinced himself that as an identical twin, he had some right to assume Nathan's identity and benefits after death. More messages showed his awareness of the criminal nature. Friend: "What happens when they catch you?" Evan: "They won't. Who's going to question whether I'm Nathan or Evan? We looked exactly alike. Medical providers see patients for 15 minutes. They'll never know they're seeing the wrong twin." Friend: "Your mom knows Nathan died. What if she finds out?" Evan: "She won't. She thinks Nathan's benefits ended years ago. She has no reason to question anything." The deception extended beyond just collecting benefits. Evan had been maintaining Nathan's presence in bureaucratic systems, filing tax returns in Nathan's name, keeping Nathan's cell phone number active, even posting occasional updates on Nathan's social media accounts to create the appearance Nathan was alive if anyone checked. When Social Security Administration learned of the fraud, they joined the investigation. Evan had been collecting Social Security disability benefits in addition to the private insurance, another $20,000 annually. The total fraud exceeded $180,000 over 3 years. I was devastated by the discovery. You've been pretending to be your dead brother? For 3 years? Going to doctors as Nathan? Collecting his benefits? What about his memory, his dignity? Nathan's gone, Mom. He doesn't care about dignity anymore. The benefits were available. I used them. You used your identical twin status to commit fraud using your dead brother's identity. That's not using benefits. That's desecration. Lily, Evan's younger sister, and Nathan's, was equally horrified. You've been impersonating Nathan? We've been grieving him for 3 years while you've been playing pretend as him for money. I wasn't playing pretend. I was being practical. The benefits existed. Why waste them? His complete lack of remorse was chilling. He viewed the fraud as clever resource management rather than criminal exploitation of his dead twin's identity. The criminal prosecution proceeded on multiple charges: identity theft, Social Security fraud, insurance fraud, wire fraud, electronic benefit transfers, and falsifying medical records. The prosecutor emphasized the particularly egregious nature. The defendant used his status as identical twin to impersonate his deceased brother for 3 years. He attended medical appointments claiming to be his dead twin, forged signatures, maintained false identities, and collected over $180,000 in benefits to which he had no entitlement. Insurance fraud investigators testified about the deception. The defendant successfully convinced 26 different medical providers over 3 years that he was his deceased twin. He used their identical appearance and his knowledge of his brother's medical history to maintain disability status in his brother's name. Medical providers who'd examined Nathan testified about feeling violated. I trusted that my patient was who he claimed to be. Learning I was actually examining his identical twin who was impersonating him, it's a profound violation of medical ethics and patient trust. Video footage from medical offices showed Evan signing in as Nathan, presenting Nathan's insurance cards and ID, being called back as Nathan, and completing appointments under his dead brother's identity. Banking experts testified about the account fraud. The defendant opened accounts using his deceased brother's Social Security number, but with his own signature and control. He deposited disability benefits into these accounts, then accessed them as himself, essentially creating a pipeline from his brother's identity to his own finances. Tax fraud specialists testified. The defendant filed tax returns in his deceased brother's name for 3 years, reporting disability income. This created false records showing Nathan was alive and receiving benefits when he'd been deceased the entire time. Social Security Administration investigators detailed the scope. The defendant collected $60,000 in Social Security disability benefits over 3 years by falsely maintaining his deceased brother's claim. Every benefit payment was fraud. Evan's defense attempted to argue diminished capacity due to grief. The defendant was traumatized by his identical twin's death. His impersonation began as grief-driven confusion about identity and evolved into the fraud. The prosecutor destroyed this. The defendant didn't confuse his identity with his brother's due to grief. Text messages show he knew exactly what he was doing, deliberately impersonating his deceased twin to collect benefits while working full-time under his own identity. This was calculated fraud, not grief-induced confusion. Psychological experts testified. While losing an identical twin can create profound identity issues, the defendant's behavior shows clear awareness and intent. He maintained separate identities deliberately, worked as Evan, collected disability as Nathan. This isn't confused grief, it's purposeful fraud. The jury convicted on all counts. Evan received 4 years in federal prison for the combined fraud charges, restitution of $180,000 plus interest, and permanent prohibition from accessing any government benefits. Social Security Administration and the insurance companies flagged Nathan's identity permanently to prevent any future fraudulent claims. His death was confirmed in all official systems, with notes about the impersonation fraud to protect against recurrence. My relationship with Evan is destroyed. You exploited Nathan's death, used your identical appearance to steal his identity. How am I supposed to forgive that? I didn't hurt Nathan. He was already dead. You hurt his memory. You turned his disability benefits into your fraud scheme. You attended medical appointments pretending to be him. You filed taxes as him. You kept him alive in systems for your own profit. Lily won't speak to Evan. We buried Nathan, grieved him, moved forward with his loss. You were using his identity for fraud the whole time. That's unforgivable. Extended family reacted with horror. Evan impersonated his dead twin? For benefits? That's sick. The identical twin community was particularly disturbed. Twin bonds are sacred. Using identical appearance to commit fraud using a deceased twin's identity violates everything that bond represents. Fraud investigators used the case in training. Identical twins present unique fraud risks. When one twin dies, the surviving twin has the physical appearance to assume the deceased twin's identity. Verification must go beyond physical appearance. Medical providers implemented new protocols for identity verification, especially for patients with identical twins. Do I forgive Evan? I don't know if I can. He didn't just commit fraud. He desecrated his brother's memory by using Nathan's identity as a tool for financial gain. Nathan's grave still receives flowers. His memory remains with family who loved him. But Evan tainted that memory by using Nathan's identity for 3 years of fraud. Some betrayals involve exploiting death and identical appearance. Evan's was one of them. He's in prison. Nathan's identity is finally at rest, no longer being fraudulently maintained by his living twin. Restitution will take decades. Relationships are permanently damaged. Nathan's memory will always carry the stain of Evan's fraud. That's what Evan chose. Prison, debt, family exile, all for $180,000 from his dead brother's benefits. Was it worth it? He'll have 4 years in federal prison to consider that question. Nathan's identity is finally truly deceased, buried properly this time, without Evan keeping it alive for fraud. Some twins share everything in life. Evan decided to share Nathan's identity in death. The courts disagreed. So did I. So does everyone who loved Nathan. Evan's alone now. Nathan truly gone. No more impersonation. No more fraud. Just consequences. Deserved, appropriate, complete. Nathan rests in peace finally. Evan serves his time for disturbing that peace. That's where we are. Not where we should be, but where Evan's choices led. Fair ending, just outcome, appropriate conclusion. Finding out an adult son had been impersonating a dead twin for insurance fraud. I discovered my adult son had been impersonating his deceased twin brother for 3 years to collect disability benefits while working full-time under his own identity. I'm 52 years old, mother to identical twin sons. Or I was. Nathan died in a car accident 3 years ago at age 27. His twin brother Evan survived. Losing Nathan devastated our family. As identical twins, Evan and Nathan had been inseparable their entire lives. Nathan's death felt like Evan lost half of himself. After Nathan's death, Evan struggled with grief and depression. He'd moved back home temporarily to process the loss. I supported him through the darkest period, watching my surviving son grieve his twin in ways that broke my heart. Eventually, Evan seemed to recover. He got his own apartment, resumed work, started rebuilding his life without his brother. Nathan had been receiving disability benefits before his death. He'd suffered a serious back injury 2 years before the accident and qualified for permanent disability payments. After his death, I notified Social Security Administration and the private disability insurance company. The benefits stopped, as they should have. Or so I thought. 6 months ago, I received a strange call from Nathan's former disability insurance company. We're conducting a routine verification check on Nathan's continued disability status. Can you confirm his current address and employment status? Nathan passed away 3 years ago. I notified your company immediately after his death. His benefits should have been terminated. Long pause. Ma'am, we have no record of Nathan's death being reported. His benefits have continued uninterrupted. In fact, we have documentation of his ongoing medical appointments and reevaluations confirming continued disability. That's impossible. Nathan died in a car accident 3 years ago. I have the death certificate. The insurance investigator became very interested in this discrepancy. Within a week, they'd launched a formal investigation. What they discovered was shocking. Someone had been impersonating Nathan, attending medical appointments under his identity, submitting documentation to maintain disability benefits, and collecting monthly payments for 3 years. The investigation focused on who could successfully impersonate Nathan. As an identical twin, Evan was the obvious suspect. The insurance company reviewed medical appointment records. All appointments for Nathan's disability reevaluations had occurred in the city where Evan lived, not where Nathan had lived before his death. Surveillance footage from medical offices showed Evan arriving for appointments but signing in as Nathan, using Nathan's social security number and insurance information. Banking records revealed Nathan's disability payments were being deposited into an account opened after his death, an account with only Evan's signature on file but using Nathan's personal information. When confronted by insurance investigators, Evan initially denied everything. But the evidence was overwhelming. Video footage, handwriting analysis, banking records, testimony from medical providers who'd examined Nathan without realizing they were seeing Evan. Eventually, Evan admitted it. He'd been impersonating his dead twin brother for 3 years to fraudulently collect disability benefits while working full-time under his own identity, essentially maintaining 2 identities and 2 income streams. The fraud totaled over $110,000 in disability benefits that should have stopped when Nathan died. But the fraud went deeper than just the benefits. Evan had been living a double life, attending medical appointments as Nathan, maintaining Nathan's disability claim, collecting benefits in Nathan's name, all while working his own full-time job as Evan. "Why?" I asked when I confronted him. "Why would you do this? You're desecrating your brother's memory." "I needed the income. The benefits were just sitting there. Nathan didn't need them anymore. It seemed like a waste to let them end." He'd turned his twin's death into a financial opportunity, exploiting their identical appearance to commit fraud using his dead brother's identity. The full scope of Evan's fraud became clear through the insurance investigation and subsequent criminal inquiry. He hadn't just collected benefits. He'd created an entire false identity for his deceased twin to maintain the fraud long-term. The insurance company's investigative report detailed the systematic deception. Medical appointments. Evan had attended 26 medical reevaluation appointments over 3 years under Nathan's identity. He'd memorized Nathan's medical history, described symptoms consistent with Nathan's back injury, and convinced doctors he was Nathan, receiving ongoing disability treatment. Documentation fraud. Evan forged Nathan's signature on countless forms: benefit verification documents, medical consent forms, banking paperwork. Handwriting experts confirmed the signatures were Evan's, attempting to replicate Nathan's. Identity maintenance. Evan kept Nathan's driver's license. They were identical twins, so the photo worked for both. Nathan's social security card, and other identification documents. He used these to prove Nathan's identity at appointments and banks. Financial fraud. The disability benefits were deposited into an account Evan opened using Nathan's information, but with his own signature. He'd walk into banks as Nathan, using his twin's ID, then access the same accounts as Evan. Bank staff never questioned why Nathan and Evan looked identical, assuming they'd noticed at all. Dual income streams. Evan worked full-time as himself, earning approximately $65,000 annually, while simultaneously collecting $36,000 yearly in disability benefits as Nathan. His total annual income was over $100,000, half of it fraudulent. Text messages between Evan and a friend revealed how he rationalized the fraud. Evan: went to another medical appointment as Nathan today. They still think I'm him. Friend: dude, you're committing fraud. This is insane. Evan: Nathan's dead. The benefits don't help him anymore. Why should they go to waste when I can use them? Friend: because they're not yours. This is identity theft of your dead brother. Evan: we're identical twins. His identity is basically my identity. I'm just continuing what would have been his if he'd lived. He'd convinced himself that as an identical twin, he had some right to assume Nathan's identity and benefits after death. More messages showed his awareness of the criminal nature. Friend: what happens when they catch you? Evan: they won't. Who's going to question whether I'm Nathan or Evan? We looked exactly alike. Medical providers see patients for 15 minutes. They'll never know they're seeing the wrong twin. Friend: your mom knows Nathan died. What if she finds out? Evan: she won't. She thinks Nathan's benefits ended years ago. She has no reason to question anything. The deception extended beyond just collecting benefits. Evan had been maintaining Nathan's presence in bureaucratic systems, filing tax returns in Nathan's name, keeping Nathan's cell phone number active, even posting occasional updates on Nathan's social media accounts to create the appearance Nathan was alive if anyone checked. When Social Security Administration learned of the fraud, they joined the investigation. Evan had been collecting Social Security disability benefits in addition to the private insurance, another $20,000 annually. The total fraud exceeded $180,000 over 3 years. I was devastated by the discovery. You've been pretending to be your dead brother? For 3 years? Going to doctors as Nathan? Collecting his benefits? What about his memory, his dignity? Nathan's gone, Mom. He doesn't care about dignity anymore. The benefits were available. I used them. You used your identical twin status to commit fraud using your dead brother's identity. That's not using benefits, that's desecration. Lily, Evan's younger sister, and Nathan's, was equally horrified. You've been impersonating Nathan? We've been grieving him for 3 years while you've been playing pretend as him for money? I wasn't playing pretend. I was being practical. The benefits existed. Why waste them? His complete lack of remorse was chilling. He viewed the fraud as clever resource management rather than criminal exploitation of his dead twin's identity. The criminal prosecution proceeded on multiple charges: identity theft, Social Security fraud, insurance fraud, wire fraud, electronic benefit transfers, and falsifying medical records. The prosecutor emphasized the particularly egregious nature. The defendant used his status as identical twin to impersonate his deceased brother. For 3 years. He attended medical appointments claiming to be his dead twin, forged signatures, maintained false identities, and collected over $180,000 in benefits to which he had no entitlement. Insurance fraud investigators testified about the deception. The defendant successfully convinced 26 different medical providers over 3 years that he was his deceased twin. He used their identical appearance and his knowledge of his brother's medical history to maintain disability status in his brother's name. Medical providers who'd examined Nathan testified about feeling violated. I trusted that my patient was who he claimed to be. Learning I was actually examining his identical twin who was impersonating him, it's a profound violation of medical ethics and patient trust. Video footage from medical offices showed Evan signing in as Nathan, presenting Nathan's insurance cards and ID, being called back as Nathan, and completing appointments under his dead brother's identity. Banking experts testified about the account fraud. The defendant opened accounts using his deceased brother's Social Security number, but with his own signature and control. He deposited disability benefits into these accounts, then accessed them as himself, essentially creating a pipeline from his brother's identity to his own finances. Tax fraud specialists testified. The defendant filed tax returns in his deceased brother's name for 3 years, reporting disability income. This created false records showing Nathan was alive and receiving benefits when he'd been deceased the entire time. Social Security Administration investigators detailed the scope. The defendant collected $60,000 in Social Security disability benefits over 3 years by falsely maintaining his deceased brother's claim. Every benefit payment was fraud. Evan's defense attempted to argue diminished capacity due to grief. The defendant was traumatized by his identical twin's death. His impersonation began as grief-driven confusion about identity and evolved into the fraud. The prosecutor destroyed this. The defendant didn't confuse his identity with his brother's due to grief. Text messages show he knew exactly what he was doing, deliberately impersonating his deceased twin to collect benefits while working full-time under his own identity. This was calculated fraud, not grief-induced confusion. Psychological experts testified, while losing an identical twin can create profound identity issues, the defendant's behavior shows clear awareness and intent. He maintained separate identities deliberately, worked as Evan, collected disability as Nathan. This isn't confused grief, it's purposeful fraud. The jury convicted on all counts. Evan received 4 years in federal prison for the combined fraud charges, restitution of $180,000 plus interest, and permanent prohibition from accessing any government benefits. Social Security Administration and the insurance companies flagged Nathan's identity permanently to prevent any future fraudulent claims. His death was confirmed in all official systems, with notes about the impersonation fraud to protect against recurrence. My relationship with Evan is destroyed. You exploited Nathan's death, used your identical appearance to steal his identity. How am I supposed to forgive that? I didn't hurt Nathan. He was already dead. You hurt his memory. You turned his disability benefits into your fraud scheme. You attended medical appointments pretending to be him. You filed taxes as him. You kept him alive in systems for your own profit. Lily won't speak to Evan. We buried Nathan, grieved him, moved forward with his loss. You were using his identity for fraud the whole time. That's unforgivable. Extended family reacted with horror. Evan impersonated his dead twin? For benefits? That's sick. The identical twin community was particularly disturbed. Twin bonds are sacred. Using identical appearance to commit fraud using a deceased twin's identity violates everything that bond represents. Fraud investigators used the case in training. Identical twins present unique fraud risks. When one twin dies, the surviving twin has the physical appearance to assume the deceased twin's identity. Verification must go beyond physical appearance. Medical providers implemented new protocols for identity verification, especially for patients with identical twins. Do I forgive Evan? I don't know if I can. He didn't just commit fraud, he desecrated his brother's memory by using Nathan's identity as a tool for financial gain. Nathan's grave still receives flowers. His memory remains with family who loved him. But Evan tainted that memory by using Nathan's identity for 3 years of fraud. Some betrayals involve exploiting death and identical appearance. Evan's was one of them. He's in prison. Nathan's identity is finally at rest, no longer being fraudulently maintained by his living twin. Restitution will take decades. Relationships are permanently damaged. Nathan's memory will always carry the stain of Evan's fraud. That's what Evan chose. Prison, debt, family exile, all for $180,000 from his dead brother's benefits. Was it worth it? He'll have 4 years in federal prison to consider that question. Nathan's identity is finally truly deceased, buried properly this time, without Evan keeping it alive for fraud. Some twins share everything in life. Evan decided to share Nathan's identity in death. The courts disagreed. So did I. So does everyone who loved Nathan. Evan's alone now, Nathan truly gone. No more impersonation. no more fraud. Just consequences. Deserved, appropriate, complete. Nathan rests in peace finally. Evan serves his time for disturbing that peace. That's where we are. Not where we should be, but where Evan's choices led. Fair ending, just outcome, appropriate conclusion. After years of sobriety, discovering someone had been secretly adding alcohol to food, I discovered my spouse had been systematically putting alcohol in my meals for 8 months to sabotage my sobriety and make me appear to be drinking again. I'm 45 years old, sober alcoholic with 7 years of recovery. I stopped drinking when my daughter Lily was 10. My alcoholism had nearly destroyed my marriage and relationship with my child. Through AA, therapy, and immense personal work, I rebuilt my life and maintained strict sobriety. My husband Derek and daughter Lily, now 17, supported my recovery throughout. Sobriety wasn't just about not drinking. It was about rebuilding trust, proving I could be the parent and partner my family deserved. 7 years sober represented thousands of decisions to choose recovery over temptation. My sobriety counter was a source of pride. 2,555 days without alcohol. 6 months ago, I started experiencing strange symptoms after meals Derek prepared. Slight dizziness, warmth spreading through my body, mild disorientation, sensations I recognized from my drinking days but couldn't explain. I'd eat dinner Derek made, then within 30 minutes feel unmistakably like I'd consumed alcohol. "You seem tipsy," Lily said one evening after Derek's pot roast dinner. "Are you okay, Mom?" "I feel strange, lightheaded, but I haven't had anything to drink." Derek looked concerned. "Maybe you're coming down with something. You should rest." The episodes continued. After Derek's pasta dinners, his stir-fry meals, his casseroles, always the same pattern. I'd feel the familiar alcohol warmth, the slight cognitive fuzz, the physical sensations I'd worked 7 years to leave behind. I started questioning my sobriety. Had I unknowingly consumed alcohol somehow? Was I relapsing without realizing it? The guilt and fear were overwhelming. My AA sponsor suggested I take random breathalyzer tests at home to ease my mind. I bought a personal breathalyzer device. After one of Derek's dinners, when I felt the familiar alcohol sensation, I tested myself. The reading showed 0.04% BAC, below legal intoxication, but definitively showing alcohol in my system. I was devastated. Somehow, I was consuming alcohol despite my vigilance. But how? I started documenting everything I ate and drank, searching for the source. The pattern became clear. I only tested positive for alcohol after eating meals Derek prepared. Never after food I made myself, restaurant meals, or items from sealed packages. Derek was putting alcohol in my food. Last week, I pretended to eat dinner Derek made, but secretly fed it to our dog under the table. Small amounts to test, nothing harmful. 30 minutes later, I breathalyzer tested myself. 0.00% BAC. No alcohol in my system because I hadn't actually eaten Derek's food. Then, I installed a hidden camera in our kitchen. The footage from the next evening was devastating. Derek cooking dinner, opening the wine cabinet, measuring out wine and adding it to the sauce, then vodka into the marinade, then whiskey into the gravy, carefully calculating amounts, enough to produce alcohol absorption but disguised by cooking and strong flavors. He'd been systematically spiking my meals with alcohol for months, breaking my sobriety without my knowledge or consent, while I agonized over unknowingly relapsing. I saved the video evidence and confronted Derek with everything: the breathalyzer results, the timeline showing positive tests only after his meals, and the camera footage of him adding alcohol to my food. "Why?" I demanded. "Why would you sabotage my sobriety? 7 years of recovery, you've been destroying that?" His answer was worse than I imagined. "You've been insufferable sober, Everything's about AA meetings, recovery talks, being the perfect sober mom. I wanted my wife back, the fun, relaxed person you were when you drank. He'd been trying to make me start drinking again because he preferred me as an alcoholic. The realization that Derek had been deliberately sabotaging 7 years of sobriety was devastating, but the evidence was irrefutable. I documented everything methodically before taking action, knowing I'd need comprehensive proof of what he'd done. I collected all evidence, breathalyzer records, 3 months of readings showing BAC levels of 0.03 to 0.05% exclusively after eating Derek's meals, never after food from other sources. Food journal, detailed log correlating every instance of feeling alcohol effects with consuming Derek's cooking. Video footage, multiple recordings of Derek adding wine, vodka, whiskey, and other alcohol to meals he prepared for me. The footage showed him being careful about amounts, enough to produce noticeable effects, but disguised within food. Timeline: 8 months of this pattern, starting shortly after my 7-year sobriety anniversary when I'd received recognition from my AA group. I consulted with a lawyer specializing in domestic abuse before confronting Derek formally. Your husband has been poisoning you with alcohol for 8 months? That's assault. Potentially attempted murder given your alcoholism history, and definitely domestic abuse. Can he be prosecuted? Absolutely. You have video evidence, medical evidence via breathalyzer, and clear harm. He knowingly gave an alcoholic alcohol without consent. That's criminal. I also spoke with my AA sponsor and therapist about what Derek had done. Both were horrified. My sponsor: he's been spiking your food? Breaking your sobriety deliberately? That's not just betrayal, that's attempted destruction of your recovery. My therapist: this is severe abuse. He exploited your vulnerability as a recovering alcoholic to force alcohol consumption. The psychological implications are profound. I gathered more evidence by continuing to document. Derek's routine was consistent. He'd cook dinner 4 to 5 nights per week, adding alcohol to my portions while keeping his alcohol free. Text messages with a friend revealed his mindset. Derek: she's been sober 7 years. It's ruined our marriage. She's so focused on recovery, meetings, being the perfect sober person. There's no fun anymore. Friend: so what are you doing about it? Derek: working on it. She's starting to relax a little, getting some of her old self back. Friend: you're not actually... Derek: just helping her remember life is better with a drink. Small amounts. She doesn't even realize. He'd been viewing the forced alcohol consumption as helping me relax, rather than recognizing it as assault on a recovering alcoholic. More texts showed his awareness of the harm. Friend: dude, she's in AA. She works so hard at sobriety. This is messed up. Derek: she was more fun when she drank. Better wife, more relaxed parent. I want that person back. Friend: by secretly making her consume alcohol? That's abuse, man. Derek: it's just wine and pasta sauce, vodka and marinades, nothing dramatic. She's fine. He'd rationalized months of deliberately breaking my sobriety as acceptable because he preferred me as an active alcoholic over a sober, recovery-focused person. I told Lily what I'd discovered. She was 17, old enough to understand the full implications. Dad's been putting alcohol in your food? On purpose? To make you drink again? Yes, for 8 months. Every time I felt like I'd consumed alcohol, I had, because he put it in my meals. Lily was furious. You've worked so hard at sobriety. I remember what it was like before you got sober. Dad wants you to go back to that? Apparently he thinks I was better when I was drinking. That's insane. You were a mess. We all were. Your sobriety saved our family. Her support was crucial. Derek had betrayed both of us. Me by sabotaging my recovery, her by trying to return me to active alcoholism when she remembered how damaging that had been. I filed police reports for assault, administering substances without consent, poisoning, and domestic abuse. Provided all evidence, videos, breathalyzer records, text messages, expert statements from my addiction counselor about the harm. I also filed for immediate divorce and full custody of Lily, citing Derek's deliberate sabotage of my sobriety and danger to our daughter's well-being. The criminal case against Derek proceeded quickly, given the video evidence and clear documentation of deliberate alcohol administration to a known recovering alcoholic. Derek was charged with assault, administering alcohol without consent, reckless endangerment, giving alcohol to someone with documented alcoholism, and domestic abuse through substance manipulation. The prosecutor emphasized the calculated nature. The defendant systematically added alcohol to his wife's meals for 8 months. He knew she was a recovering alcoholic with 7 years sobriety. He deliberately broke her sobriety without her knowledge or consent because he preferred her as an active alcoholic. Medical experts testified about the harm. Alcohol administered to a recovering alcoholic without their knowledge is severe abuse. The defendant triggered physical alcohol absorption, created psychological trauma about potential relapse, and attempted to restart addiction in someone who'd achieved long-term recovery. My addiction counselor testified. This patient worked intensely for 7 years to maintain sobriety. The defendant's actions didn't just give her alcohol. They attacked her recovery identity, her trust in herself, and her confidence in sobriety maintenance. The video evidence showed Derek deliberately adding measured amounts of alcohol to my food while keeping his own portions alcohol-free. The jury watched him open the wine cabinet, pour wine into sauce while I was out of the room, stir it in, then serve me the spiked portion. Breathalyzer records correlated perfectly with Derek's cooking schedule. Positive BAC readings only occurred after consuming his meals. Text messages with his friends showed Derek's awareness he was harming me and his rationalization that I was better as an alcoholic. Derek's defense attempted to claim the alcohol cooked off and I wasn't actually consuming it. Expert witnesses destroyed this. Alcohol doesn't completely cook off in food preparation. Significant amounts remain depending on cooking method and time. The defendant's wife's breathalyzer readings confirm she was absorbing alcohol from the food. Derek's defense also claimed I was overreacting to small amounts of alcohol. Cooking wine in pasta sauce is common. The defendant wasn't trying to make his wife drunk. The prosecutor demolished this argument. The defendant's wife is a recovering alcoholic with 7 years sobriety. She has zero tolerance for alcohol consumption. It's not about quantity. It's about any alcohol entering her system without consent. The defendant knew this and deliberately caused it. The jury convicted on all counts. Derek received 18 months in prison for assault and domestic abuse, probation, mandatory domestic violence and substance abuse counseling, and a permanent restraining order. The divorce was uncontested. Derek had no defense against the evidence. I received full custody of Lily. Derek was granted supervised visitation only after completing his sentence and counseling, with conditions that he never prepare food for me or Lily. Lily chose not to have contact with Derek during his imprisonment. He tried to turn Mom back into an alcoholic. I can't forgive that. My AA community rallied around me. Fellow members were horrified. Your spouse sabotaged 7 years of sobriety by spiking your food? That's unthinkable. The recovery community used my case to highlight the vulnerability of people in recovery. Family members may sabotage sobriety for various reasons. This case shows the severe harm and criminal nature of such actions. Addiction specialists incorporated my experience into training. Recovering addicts can be vulnerable to deliberate substance exposure by people who knew them during active addiction and preferred that version of them. Do I forgive Derek? No. He attacked the foundation of my recovery, exploited my vulnerability as a recovering alcoholic, and tried to restart my addiction because he liked me better as an alcoholic. My sobriety counter reset. After 7 years, 2,555 days, I had to start over because of alcohol Derek forced into my system. That loss is profound. But I'm sober again. Day 47 of new sobriety. Working my program, attending meetings, rebuilding. The forced alcohol consumption didn't restart my addiction. I didn't choose to drink, didn't relapse mentally. Once I knew Derek was the source, I eliminated it immediately. My sobriety mindset remained intact, even while alcohol was unknowingly entering my system. My sponsor helped me process this. Your sobriety wasn't truly broken. You didn't choose to drink. Your recovery remained strong. Derek attacked it from outside, but your commitment to sobriety held. Still, the counter reset. 7 years became 0. That's Derek's legacy, stealing 2,555 days of counted sobriety. I'm rebuilding. Lily is with me full-time. Derek is in prison for trying to turn his wife back into an alcoholic. Some betrayals involve forcing someone to consume the substance they've fought years to avoid. Derek's was one of them. He's paying for it. Prison, lost family, destroyed marriage. I paid for it too. Reset sobriety counter. Months of unknowingly consuming alcohol. Trauma. But I survived. Still sober, still recovering, still building the life Derek tried to destroy. That's enough. Not what I wanted, but what Derek's choices left me. He wanted me drinking again. I'm sober instead, and he's imprisoned. Fair outcome. Just consequence. Appropriate result. Day 47 of new sobriety. Counting up again. Derek can't sabotage that anymore. He's gone. I'm sober. Lily's safe. That's what matters. Everything else, his sentence, his regret, his ruined life, is just the natural result of trying to force alcohol on a recovering alcoholic. Some people can't be forgiven. Derek's one of them. But I can keep recovering. That's all I need to do. One day at a time, like always. Despite Derek's attempts to destroy that, sober today, that's enough. Ex-wife had been faking our teenage son's terminal illness for 3 years to control custody. I discovered my ex-wife had been fabricating our son's terminal cancer diagnosis for 3 years, falsifying medical records and coaching him to fake symptoms to maintain sole custody and prevent my involvement in his life. I'm 47 years old, divorced from my ex-wife Amanda for 6 years. We share custody of our son Connor, who is now 16. The divorce was contentious. Amanda fought aggressively for primary custody and child support, painting me as an absent, negligent father, despite my consistent involvement in Connor's life. We eventually settled on joint custody, with Connor spending equal time at both households. 3 years ago, Amanda called me with devastating news. Connor had been diagnosed with acute lymphoblastic leukemia, an aggressive blood cancer requiring immediate intensive treatment. The oncologist says his prognosis is guarded. He'll need chemotherapy, possibly bone marrow transplant. The next few years will be focused entirely on fighting this cancer. I was shattered. My 13-year-old son had cancer. I want to be involved in all medical decisions. I'll take time off work to be at appointments and treatments. The oncologist says Connor needs stability and minimal stress. Too many people at appointments will overwhelm him. I'll handle the medical care. You can visit when he's feeling well enough. Amanda filed emergency motion to modify custody, citing Connor's terminal illness. Given the intensive medical treatment required and need for consistent caregiving, Connor should reside primarily with me. The father can have supervised visitation when medical condition permits. The judge granted Amanda primary custody. Given the child's serious medical condition requiring extensive treatment and care coordination, it's in his best interest to have one primary residence. Father will have liberal visitation, subject to the child's medical needs. I saw Connor less frequently. Amanda would cancel visits, claiming he was too sick from chemotherapy or immune system too compromised for visitors. When I did see him, he looked tired and thin, which Amanda attributed to cancer treatment. He'd mentioned doctor appointments, medication side effects, and feeling weak from chemo. I offered repeatedly to attend medical appointments. I want to talk to his oncologist, understand his treatment plan, be there for him. The oncologist says too many people in appointments confuses the treatment team. I'm his primary caregiver. I coordinate with doctors. You just complicate things. Over 3 years, I received regular updates about Connor's cancer battle. Rounds of chemotherapy that made him sick. Hospitalizations for infections. Scans showing mixed results. Discussions about experimental treatments. Amanda sent photos of Connor looking ill, thin, exhausted, appearing exactly like a child fighting cancer. His 5-year survival rate is only 60%, Amanda would tell me. We're doing everything we can, but it's day by day. He might not make it to adulthood. I lived with the terror of losing my son to cancer, grieving the childhood stolen by disease, and feeling helpless watching from the sidelines while Amanda controlled all medical decisions. 2 months ago, I ran into Connor at a movie theater with friends. He looked healthy, not the frail, sick child I'd seen during our limited visits. He had normal weight, healthy color, was active and energetic. When I approached, he seemed startled and uncomfortable. "Connor, you look great. Is the treatment working? You seem so much healthier." Yeah, having a good day." "What did your oncologist say at your last appointment?" I don't remember. Mom handles all that." Something felt wrong. A child battling cancer for 3 years would know details about his own treatment. Connor seemed evasive, almost guilty when I asked about his health. I started investigating, requested Connor's medical records from the children's hospital where Amanda claimed he was being treated. The hospital had no record of Connor as a patient, no oncology appointments, no chemotherapy treatments, no cancer diagnosis. I contacted the oncologist Amanda had named multiple times, Dr. Sarah Patterson. Dr. Patterson's office confirmed, "We have no patient named Connor in our system. Dr. Patterson has never diagnosed or treated a child with that name." Connor didn't have cancer. He'd never had cancer. Amanda had fabricated the entire diagnosis for 3 years. The realization that Connor's cancer was completely fabricated led me to investigate how Amanda had maintained the deception for 3 years and what evidence existed of the fraud. I hired a private investigator and attorney specializing in custody fraud. Investigation revealed the extent of Amanda's elaborate scheme. Falsified medical records. Amanda had created fake medical documents, diagnosis letters, treatment plans, lab results, oncology reports, all fabricated with forged doctor signatures and letterheads. She'd shown me these documents dozens of times over 3 years to prove Connor's cancer was real. Coached symptoms. Text messages between Amanda and Connor showed she'd been coaching him to fake illness symptoms during my visits. "Remember to act tired and weak when you see your dad. Tell him the chemo made you nauseous. Don't let him see you eating normally or playing sports." Fake chemotherapy. Photos Amanda sent of Connor during treatment showed him with IV attached to his arm. Investigation revealed these were staged photos. Amanda would attach saline IV bags at home and photograph Connor, creating appearance of chemotherapy sessions that never occurred. Hair shaving. Connor's thinning hair, which I'd attributed to chemo, was actually from Amanda making him keep his hair very short and using makeup to make his scalp look patchy, mimicking chemo-related hair loss. Weight manipulation. Amanda had controlled Connor's diet during periods before my visits, keeping him slightly underweight to maintain appearance of illness. Between my visits, he ate normally and maintained healthy weight. Isolation from doctors. Amanda never actually took Connor to oncology appointments because there were no appointments. The treatment schedule she described was fiction. By controlling all medical access and claiming I'd complicate treatment by attending, she prevented me from discovering the truth. Financial exploitation. Medical bills Amanda claimed to pay for Connor's treatment were fake. She'd submitted expenses to me for reimbursement, thousands for chemotherapy, hospital stays, specialist consultations, all fabricated. I'd paid her tens of thousands for medical costs that never existed. Text messages between Amanda and her sister revealed motive. Amanda: Connor's cancer has been perfect excuse to keep his father out of our lives. Court gave me primary custody, and he can't question medical decisions. Sister: How long can you keep this up? Amanda: As long as I need to. I tell him Connor's cancer is in remission, then relapses whenever I want to limit his dad's involvement. Perfect control. Sister: What if someone figures out Connor isn't actually sick? Amanda: Who's going to question a mother caring for a child with cancer? Society gives me automatic sympathy and trust. His dad would look like a monster if he challenged me about it. More messages showed Amanda had researched childhood cancer extensively to make the fake diagnosis believable. Amanda: Been reading about all symptoms and treatment protocols. Need to make sure my story stays consistent. Sister: You've been faking Connor's cancer for 3 years. Aren't you worried about getting caught? Amanda: The fake medical records look legitimate. Connor does what I tell him. His dad believes everything. This is working perfectly. Connor, now 16, was old enough to be interviewed separately. With child advocate present, he broke down. Mom made me pretend to have cancer since I was 13. She'd tell me what symptoms to fake, how to act sick, what to say to Dad. She said it was necessary to protect me from him, that Dad was dangerous and we needed the court to keep him away. Did you understand what you were doing? At first, no. I was 13 and believed Mom when she said it was protecting me. As I got older, I realized Dad wasn't dangerous and Mom was lying about everything. But she said if I told the truth, both of us would get in trouble. I was scared. Child psychologist evaluated Connor. This child has been psychologically abused. His mother manipulated him into participating in an elaborate fraud, coached him to deceive his father, and isolated him from a parent who loves him. The trauma of maintaining this deception for 3 years is significant. I filed emergency motions, immediate custody modification, fraud charges, contempt of court, Amanda lied to court about medical condition, and abuse charges for psychological harm to Connor. The legal and criminal response was swift and severe. Amanda faced consequences across family court, criminal court, and professional licensing boards. Family court hearing came first. The judge was furious when presented with evidence. You fabricated a terminal cancer diagnosis for 3 years? Submitted false medical records to this court? Used fake illness to gain custody advantage? This is unconscionable fraud. Evidence presented. Hospital records. Confirmed Connor was never a patient, never treated for cancer, never diagnosed with leukemia. Dr. Patterson testimony. I've never met or treated this child. My name and credentials were forged on fake medical documents. Fake medical records. Forensic document examiner confirmed letters, lab results, and treatment plans were fabrications. Wrong formats, forged signatures, fictitious data. Text messages showed Amanda coaching Connor to fake symptoms and discussing how cancer gave her custody control. Connor's testimony. Mom made me pretend to have cancer. She told me what to say, how to act, what symptoms to fake. Financial fraud. Documentation showing I'd paid Amanda over $45,000 for fake medical expenses. The judge vacated the custody order based on fraudulent medical claims. This custody arrangement was procured through deliberate, systematic fraud. The mother fabricated terminal illness to gain custody advantage. Connor never had cancer. The entire medical crisis was fiction. Immediate custody change. I received primary custody. Amanda granted supervised visitation only, pending criminal case outcome. Criminal charges followed. Fraud on the court. submitting false medical evidence to obtain favorable custody ruling. Forgery, creating fake medical documents with forged doctor signatures. Child abuse, psychologically harming Connor by forcing participation in fraud. Medical identity theft, using doctor's identity without authorization. Financial fraud, obtaining money through fake medical claims. Conspiracy, involving Connor in the deception. Prosecutor emphasized calculated nature. The defendant fabricated terminal cancer diagnosis for her son, maintained the deception for 3 years, and used it to control custody and exclude the father from the child's life. She coached her teenage son to fake illness, created elaborate fake medical records, and lied to courts and family. This is systematic fraud and child abuse. Child welfare experts testified. Forcing a child to pretend he has terminal cancer for 3 years is severe psychological abuse. This child lived with false identity as cancer patient, had to maintain elaborate deception, and was isolated from his father through manufactured illness. Medical fraud experts. Creating fake cancer. Diagnosis is particularly heinous. Real cancer patients and families suffer genuine trauma. The defendant exploited public sympathy for childhood cancer to commit fraud. Connor's therapist. This teenager experienced trauma from being forced to fake terminal illness for years. He felt guilty deceiving his father, feared discovery, and struggled with identity confusion. Was he sick or healthy? His mother's manipulation caused significant psychological harm. Amanda's defense claimed she believed Connor had cancer based on symptoms. My client genuinely thought her son was ill and acted on medical concerns. Prosecutor destroyed this. The defendant never took Connor to actual doctors. She created fake medical records herself. Text messages show she knew it was fraud and deliberately maintained deception. She researched cancer symptoms to make lies convincing. This wasn't medical concern. This was calculated fraud. Medical professionals testified. No legitimate parent would fake hospital records rather than take genuinely sick child to actual doctors. The defendant's behavior shows she knew Connor wasn't sick. Jury convicted on all counts. Amanda received 8 years in prison for fraud and child abuse, restitution for fraudulent medical expenses, permanent loss of custody, and supervised visitation only upon release. Connor lives with me now. Full custody, stable home, honest relationship. He's in intensive therapy processing 3 years of forced deception and manipulation. Extended family horrified. Amanda faked Connor's cancer? For 3 years? To control custody? Made him participate in the fraud? That's monstrous. Child advocacy groups used case. Parental alienation can take extreme forms, including fabricating terminal illness. This case shows how children can be manipulated into participating in their own custody fraud. Medical community. Fake cancer diagnoses exploit public sympathy and waste resources. Always verify unusual medical claims, especially in custody disputes. Connor's healing. I don't have to pretend anymore. No more faking symptoms, lying to dad, maintaining mom's story. I can just be myself, healthy, normal, not a cancer patient who never had cancer. Amanda's in prison. Connor's healthy, never was sick. Our relationship rebuilding after years of her manufactured illness. Some betrayals involve faking terminal childhood cancer. Amanda's was one of them. 8 years she'll serve. 3 years she faked Connor's illness. 16 years Connor has lived. 3 of them pretending to be dying. Numbers that tell the story. Prison time that equals justice. Years Connor's reclaiming as healthy teenager. Living honestly now. No fake cancer. No coached symptoms. No manufactured illness. Everything she fabricated. Everything we're recovering from. Enough. Discovering that son-in-law was secretly drugging me to prevent babysitting my grandchildren. I discovered my son-in-law had been putting sedatives in my coffee for 6 months to make me too drowsy to safely babysit my grandchildren, eliminating me as childcare competition with his mother. I'm 49 years old, energetic and healthy, mother to my daughter Rachel, 26, and grandmother to twins Harper and Jackson, 3 years old. Rachel and her husband Connor both work full-time and needed reliable childcare for the twins. I'd been their primary babysitter since the twins were born, watching them 3 days a week, building close bonds, and loving every moment with my grandchildren. 6 months ago, Connor's mother Patricia moved to our city. Patricia had been living across the country, but retired and relocated specifically to be near her grandchildren. She immediately pushed to become the twins' primary caregiver. "I'm retired now. I have unlimited availability. Let me take over the childcare." Rachel wanted to maintain our existing arrangement. "Mom's been watching the twins for 3 years. They're attached to her. I don't want to disrupt their routine." Connor disagreed. "My mother just moved here to be close to the kids. We should let her be more involved. Your mom can still see them on weekends." They compromised. I'd continue watching the twins Mondays and Wednesdays. Patricia would take Tuesdays and Thursdays, and they'd use daycare on Fridays. Neither grandmother was happy with the split, but it seemed fair. Then I started experiencing strange symptoms on the mornings I was scheduled to babysit. Severe drowsiness about an hour after arriving at Rachel and Connor's house. Overwhelming fatigue that made it difficult to stay awake. Cognitive fog that made it hard to focus on the active 3-year-olds. I'd have to call Rachel at work. "I'm so sorry, but I'm feeling really unwell. I can't safely watch the twins today." This happened 6 times over 3 months. Always on days I was scheduled to babysit, never on other days. Rachel would have to leave work early, or Connor would call his mother Patricia to take over emergency childcare. Connor started suggesting I might be too old to handle the twins. "You're almost 50. Maybe watching active toddlers is too much for you anymore. My mother's younger and has more energy." I was baffled. I'm 49, healthy, exercise regularly, and have no medical conditions that would cause sudden severe drowsiness. But the pattern was undeniable. I'd feel fine until about an hour after arriving at their house, then become dangerously sleepy while responsible for 2 3-year-olds. My doctor ran tests, but found nothing wrong. "Your blood work is perfect. You're in excellent health. I can't explain the episodic drowsiness you're describing." The symptoms only occurred at Rachel and Connor's house on babysitting days. Never at my own home. Never when I wasn't scheduled to watch the twins. The pattern was specific and baffling. Last week, I arrived at their house for Wednesday babysitting. Connor was still home, running late for work. He made coffee like always. "Here you go, fresh pot. I'm heading out. Twins are watching cartoons." I took the coffee, but didn't drink it immediately. I was helping Harper find her favorite toy. 15 minutes later, I went to drink the now lukewarm coffee and noticed a faint, chalky residue at the bottom of the mug that hadn't fully dissolved. I dumped the coffee into a container, took it home, and had it tested at a private lab. The results showed Zolpidem, a prescription sleep medication, in significant doses. Someone had been putting sleeping pills in my coffee on mornings I was scheduled to babysit. Connor was the only person who made coffee on those mornings. He'd been drugging me to make me too drowsy to safely watch the twins, creating the appearance I was too old or unwell to handle childcare, so his mother could take over as primary babysitter. The evidence of what Connor had been doing was irrefutable, but I needed to confirm the pattern before confronting Rachel. I documented everything methodically, knowing this accusation would be devastating to my daughter. I collected additional evidence over the next 2 weeks. Coffee sample testing. I saved samples from 3 different babysitting mornings. All tested positive for Zolpidem in doses of 10 to 15 milligrams, enough to cause significant drowsiness and cognitive impairment, but not enough to be obviously dangerous. Timeline correlation. Every instance of my mysterious drowsiness occurred exactly 45 to 60 minutes after drinking coffee Connor had prepared. The timing matched zolpidem's onset perfectly. Prescription investigation. I hired a private investigator who discovered Connor had prescriptions for zolpidem filled monthly for the past 8 months, claiming insomnia. However, pharmacy records showed he was filling prescriptions far more frequently than a standard insomnia patient would need. Video evidence. On my final test, I wore a small camera disguised as a necklace. The footage showed Connor preparing coffee in the kitchen while I was occupied with the twins, opening a pill bottle, crushing a pill with a spoon, and stirring it into my specific coffee mug, the one with "World's Best Grandma" that Rachel had given me. Patricia's increased babysitting. Records showed that every time I had to cancel due to drowsiness, Patricia immediately became available and took over. She'd gone from scheduled 2 days a week to effectively 4 or 5 days by being the emergency backup when I was too drowsy to safely watch the twins. Text messages between Connor and Patricia revealed the full scope. Connor: "Put the sleeping pill in her coffee again this morning. She should be calling to cancel in about an hour." Patricia: "Good. I'll be ready to come watch my grandchildren. She's too old for this anyway." Connor: "Few more months of this, and Rachel will agree to make you the primary babysitter. Her mom can't be reliable if she keeps getting too drowsy to watch the kids safely." Patricia: "This was brilliant, making it look like she's too old and tired to handle 3-year-olds. Natural age-related decline rather than you drugging her." They'd been conspiring together, Connor drugging me, Patricia positioning herself as the younger, more reliable alternative, both working to eliminate me from childcare to give Patricia exclusive access to the twins. More messages showed they'd planned this before Patricia even moved to our city. Patricia: "I'm moving there in 2 months. We need a plan to get Rachel's mother out of the childcare arrangement so I can be their primary grandmother." Connor: "Can't just ask Rachel to cut her mom out. She won't agree." Patricia: "Make it look like her mom can't handle it anymore. Create incidents that make her seem unreliable or too old. Then Rachel will have to choose me instead." Connor: "What kind of incidents?" Patricia: "I don't know. You're creative. Make her seem drowsy or forgetful when she's watching the kids. Safety concerns will force Rachel to use me instead." Connor had implemented this plan by drugging my coffee with sleeping pills, creating safety concerns that would justify replacing me with his mother. I was horrified by the betrayal, but also terrified by the danger. Connor had been giving me sedatives without my knowledge while I was responsible for 2 toddlers. What if I'd fallen asleep while they were in my care? What if Harper or Jackson had gotten hurt because their grandmother was drugged and unable to supervise them properly? I gathered all evidence and met with Rachel privately, without Connor present. I showed her everything: the lab results showing zolpidem in my coffee, the video of Connor crushing pills and adding them to my mug, the text messages between Connor and Patricia planning to drug me, and the timeline showing every drowsy incident correlated with Connor's coffee preparation. Rachel's reaction moved through disbelief, horror, and rage in seconds. "Connor's been drugging you? To make you too sleepy to watch the twins? So his mother could take over babysitting?" "Yes, for 6 months. Every time I mysteriously became too drowsy to safely watch Harper and Jackson, it was Connor putting sleeping pills in my coffee. He could have hurt you. He could have hurt the twins if you'd fallen asleep while watching them. What if you'd been driving home and the medication hit while you were on the road? All real dangers. He prioritized his mother's access to the twins over everyone's safety." Rachel confronted Connor immediately. His initial denials crumbled when she showed him the video evidence of him crushing pills into my coffee and the text messages with Patricia planning the drugging scheme. "You've been drugging my mother? For 6 months? While she was responsible for our children?" Connor tried to minimize. "It was just a small amount, just to make her a little tired. My mom is more capable of watching the twins full-time anyway." "You gave her sleep medication without her knowledge or consent. while she was caring for 3-year-olds. You could have killed her. You could have gotten our children hurt if she'd fallen asleep while they were in her care. I was careful about the dosage. Nothing dangerous happened. Because Mom was careful enough to call me when she felt too drowsy. Despite you drugging her. What if she hadn't? What if she'd tried to push through and fallen asleep while Harper and Jackson were running around? Rachel moved out with the twins that day, came to stay with me while she processed the betrayal and filed for divorce. She also filed police reports for assault, administering drugs without consent, reckless endangerment, drugging someone caring for children, and conspiracy with Patricia. Connor was arrested and charged with multiple felonies. Assault, administering controlled substances without knowledge or consent. Reckless endangerment, drugging a caregiver responsible for minor children. Child endangerment, creating dangerous situation for Harper and Jackson by incapacitating their supervisor. Conspiracy, planning and executing the drugging scheme with Patricia. Patricia was charged as co-conspirator on all counts. The text messages showed she'd planned the scheme with Connor and encouraged the drugging. The prosecutor emphasized the severity. The defendant systematically drugged his children's grandmother for 6 months while she was providing childcare. He created dangerous situations for both the grandmother and the children in her care. His motive was eliminating childcare competition so his mother could have exclusive access to the grandchildren. Medical experts testified about the danger. Zolpidem causes significant drowsiness, cognitive impairment, and can cause falls or loss of consciousness. Giving this to someone caring for active toddlers without their knowledge created life-threatening risks for everyone involved. Toxicology reports confirmed I'd been consuming sedatives for months, explaining not just the drowsiness, but also why I'd had balance issues, memory fog, and difficulty concentrating during those episodes. Video evidence showed Connor's deliberate drugging routine, crushing pills, adding them to my specific mug, serving me the drugged coffee while acting concerned about my health issues. Text messages between Connor and Patricia proved premeditation and conspiracy. The jury heard Patricia encouraging Connor to continue drugging me and positioning herself to take over full-time childcare. Connor's defense claimed the drugging was misguided, but not malicious. My client was trying to help transition childcare to his mother in a way that wouldn't hurt his mother-in-law's feelings. His methods were wrong, but his intent wasn't harmful. The prosecutor destroyed this argument. The defendant didn't hurt feelings. He drugged someone for 6 months while they cared for his children. There's no benign interpretation of systematically giving someone sedatives without their knowledge. The jury convicted Connor on all counts. He received 3 years in prison for assault and child endangerment, probation, and permanent restraining orders from me and from having unsupervised access to Harper and Jackson. Patricia received 18 months for conspiracy, probation, and restraining orders from me and supervised-only access to her grandchildren. Rachel divorced Connor while he was awaiting sentencing. You drugged my mother to win a grandparent competition. You endangered our children. There's no coming back from that. Custody arrangement gave Rachel primary physical custody, with Connor having supervised visitation after his prison release. His drugging conviction made unsupervised custody impossible. Harper and Jackson live with Rachel at my house currently, while she finds her own place. I'm their primary caregiver again, without anyone drugging my coffee. The twins don't understand why Daddy lives somewhere else now, but they're resilient. Rachel processes the betrayal in therapy. I married someone who drugged my mother to help his mother win babysitting competition. What does that say about my judgment? It says Connor hid his true character. This isn't your fault. Extended family reacted with horror. Connor drugged you? While you watched the twins? Patricia helped plan it? That's psychotic. Childcare experts used the case in safety training. Family members may sabotage each other for childcare access. This case shows the extreme, and dangerous measures some will take. Medical privacy groups highlighted the drugging. Administering medication without consent is assault. Doing it to someone caring for children compounds the danger exponentially. Do I forgive Connor and Patricia? Never. They risked my life and my grandchildren's safety for babysitting competition. Can I trust anyone else to make my coffee? Not easily. The violation of having my drinks drugged for months has created lasting paranoia. Rachel, the twins, and I are rebuilding. Family unit without Connor and Patricia. Healing from their betrayal. Harper and Jackson thrive despite everything. They don't know their father drugged their grandmother. They know Grandma watches them, keeps them safe, loves them. That's what matters. Safe childcare, honest relationships, no sedatives in coffee. Connor's in prison. Patricia's banned from unsupervised contact. I'm watching my grandchildren without being drugged. Fair outcome, just consequence, appropriate result. Some betrayals involve literal drugging. Connor and Patricia's was one of them. They wanted babysitting control, got criminal records and family exile instead. I wanted time with grandchildren. Have it now, safely, without sedatives. That's enough. More than enough. Everything they tried to take and failed to keep. Harper and Jackson playing safely. Grandma watching alertly. No drugged coffee anywhere. That's victory. That's justice. That's where we are. Despite them, because we survived them. Beyond them now. Safe. Alert. Together. Undrugged. Perfect ending to their failed scheme. The teenagers convinced their father he had early-onset dementia to cover their drug-dealing operation. I discovered my teenage children had been systematically gaslighting me into believing I was developing early-onset Alzheimer's to prevent me from discovering they were dealing drugs from our home. I'm 47 years old, single father raising 3 teenagers after my wife passed away from cancer 4 years ago. Tyler is 17, Madison is 16, and Ethan is 14. Since their mother's death, I've worked hard to provide stability, be present despite my demanding job, and maintain open communication with them. 6 months ago, I started experiencing what seemed like serious memory problems. I'd find items moved around the house, my car keys in the refrigerator, my wallet in the bathroom, important documents in random drawers. I'd have conversations with the kids that they'd later claim never happened. I'd forget plans we'd supposedly made together. At 47, these symptoms terrified me. My mother had developed early-onset Alzheimer's at 52, and the genetic risk haunted me. Tyler first suggested I see a doctor about the memory issues. "Dad, you're forgetting a lot lately. You told me 3 times today that you'd pick me up from practice, then forgot you said it. That's concerning." "I don't remember saying it 3 times. I only remember once." "Exactly. That's the problem. You're forgetting conversations immediately after having them." Madison chimed in. "Dad's been leaving the stove on too. Last week I came home and found it on with nothing cooking. Dad didn't remember using it." I had no memory of leaving the stove on. The gaps in my memory were becoming frightening. Ethan mentioned finding my reading glasses in bizarre places. "Found them in the garage yesterday, Dad. You said you'd been looking for them everywhere. Don't you remember putting them there?" I didn't. I couldn't explain how my belongings ended up in places I'd never put them. The kids encouraged me to see a neurologist. "Dad, Mom had early Alzheimer's. You might have the genetic risk. Better to know early so we can plan." I made an appointment with Dr. Harrison, a neurologist specializing in dementia. Underwent comprehensive cognitive testing, brain scans, genetic screening. The results came back concerning. I showed markers associated with increased Alzheimer's risk, though no definitive diagnosis yet. Dr. Harrison recommended monitoring closely and starting preventive medications. "Your children are right to be concerned," Dr. Harrison said. With family history and some of the symptoms you're describing, we should be proactive. The kids became my memory keepers. They'd remind me of conversations I forgot, point out instances of my confusion, help me find items I'd misplaced. I became dependent on them to navigate my own life. Tyler took over more household responsibilities. Dad, you can't be trusted to remember everything. Let me handle grocery shopping, paying bills, managing the house. You focus on work and taking your medication. I was grateful for their support while terrified about my declining mental state at only 47 years old. Last week I came home early from work due to a canceled meeting. The house should have been empty. The kids were supposedly at after-school activities. Instead, I found Tyler, Madison, and several of their friends in our basement. Large quantities of what appeared to be marijuana, scales, small plastic bags, and significant amounts of cash spread across tables. They were clearly packaging and distributing drugs. Tyler saw me and panicked. "Dad, what are you doing home?" "What is all this?" "Nothing. We're just studying." But it clearly wasn't studying. This was a drug-dealing operation running out of my basement. My children weren't supporting me through early-onset dementia. They'd been creating fake symptoms to keep me confused and unaware of their criminal activities in my home. The realization hit me with devastating clarity. The memory problems weren't medical, they were manufactured. Every missing item, every forgotten conversation, every instance of my supposed confusion had been deliberately created by my own children to gaslight me into believing I had early-onset Alzheimer's. I didn't confront them immediately. Instead, I left the house as if I'd seen nothing, then called a trusted friend who's a private investigator. Within 24 hours, he helped me install hidden cameras throughout the house and confirmed my terrible suspicion. The footage revealed everything. Tyler moving my belongings. Video showed him taking my car keys from the hook by the door at 2 a.m., placing them in the refrigerator, then finding them the next morning and expressing concern about my memory. Madison staging conversations. She'd ask me questions while I was distracted or on my phone. I'd give distracted responses. Then later she'd claim I'd said completely different things and act worried when I didn't remember. Ethan hiding my glasses. Footage showed him taking my reading glasses from my nightstand, putting them in the garage, then discovering them there the next day while expressing concern about my cognitive state. All three coordinating. Text messages between the kids revealed the systematic plan. Tyler, need to keep Dad confused this week. I've got a big delivery coming. Madison, I'll move his wallet to the bathroom again. He'll think he's losing it. Ethan, already hid his glasses. This is working perfectly. They'd been deliberately creating evidence of memory problems and cognitive decline to prevent me from noticing their drug operation. A confused, sick father wouldn't pay attention to basement activities or question their behaviors. More messages revealed the scope of their operation. Tyler, we've made $15,000 this month dealing from the basement. Dad's so convinced he has dementia, he doesn't notice anything. Madison, the fake Alzheimer's thing was genius. He's completely focused on his symptoms instead of what we're doing. Ethan, how long can we keep this going? Tyler, as long as we need. He actually went to a neurologist. They're monitoring him for early dementia now. This is perfect cover. My children had weaponized my fear of my mother's disease, used my genetic vulnerability and grief over possibly facing the same fate to create a smokescreen for criminal activity. The neurologist visit had even been real. I genuinely had some genetic markers for increased Alzheimer's risk. But the symptoms that prompted the visit had all been manufactured. The doctor was treating me for a condition I didn't have, prescribing preventive medications I didn't need, all because my children had systematically convinced everyone I was showing early dementia symptoms. I reviewed 6 months of camera footage and documented their drug dealing operation. Regular customers. teenagers and young adults arriving at specific times, going to the basement, leaving with small packages. Large deliveries, suppliers bringing bulk quantities of marijuana monthly, Tyler coordinating and paying in cash. Packaging operations. All three children working together to divide drugs into smaller amounts, bag them, price them. Revenue tracking. Tyler maintained detailed records on his laptop of sales, customers, inventory. They'd built a substantial operation. They'd been running a drug dealing business from my home for at least 6 months, using fake dementia symptoms to keep me oblivious. I contacted an attorney who specialized in both criminal defense and family law. I needed to report my children's criminal activity while protecting myself. I hadn't known about it, but it was occurring in my home. The attorney advised immediate action. You need to report this to police before they're caught another way. If law enforcement discovers this operation and you knew about it, you could face charges for allowing drug dealing in your home. I gathered all evidence: camera footage of the drug operation, text messages showing the gaslighting plan, documentation of the fake dementia symptoms, and my neurologist's records showing I'd been medically evaluated based on manufactured symptoms. Then, I called the police. The police investigation and juvenile justice system moved quickly once I provided comprehensive evidence. Detectives were shocked by the scope, both the drug operation and the psychological abuse used to conceal it. Tyler, as the 17-year-old ringleader, faced the most serious charges: possession with intent to distribute, maintaining a drug house, contributing to delinquency of minors, and elder abuse through psychological manipulation. I was under 50, but the deliberate fake dementia creation qualified as abuse. Madison and Ethan faced charges as accomplices: possession, conspiracy to distribute, and participation in the psychological abuse scheme. The detective handling the case was particularly disturbed by the gaslighting aspect. I've seen a lot of things, but children systematically convincing their father he has early onset Alzheimer's to hide drug dealing? That's a new level of manipulation. Prosecutors charged all 3 juveniles, though the court system handled them differently based on ages. Tyler would be tried as an adult due to his age, the severity of charges, and his leadership role. He faced potential adult prison time. Madison and Ethan remained in juvenile system but faced serious consequences, including juvenile detention and mandatory rehabilitation. The family court also got involved. Given the psychological abuse and my children's criminal activities, Child Protective Services evaluated whether I could maintain custody, even though I was the victim. Your children manipulated you, committed crimes in your home, and created an elaborate scheme to prevent discovery, the CPS worker explained. But you acted appropriately once you discovered the truth. You reported it immediately and cooperated fully. That demonstrates you can provide appropriate supervision going forward. The psychological evaluation I underwent as part of the criminal case confirmed what I'd begun to suspect. I didn't have early onset Alzheimer's. My actual cognitive function was normal. All the symptoms had been created by my children moving items, lying about conversations, and gaslighting me about my own memory. Dr. Harrison, my neurologist, was mortified when he learned the truth. Your children created false symptoms? I based my evaluation and treatment recommendations on reported symptoms that were fabricated? This is unprecedented. They used my genetic risk and fear of my mother's disease against me, I explained. They knew I'd be terrified of developing early dementia. That fear made me believe their manufactured evidence. The revelation meant I'd been taking preventive Alzheimer's medications I didn't need for 6 months. Dr. Harrison discontinued all medications and conducted new baseline testing to establish my actual cognitive function, which was completely normal. My children's trial revealed the extent of their operation and manipulation. Tyler had recruited Madison and Ethan into drug dealing 6 months after my wife's death, exploiting my grief and distraction. When I started becoming more attentive to household activities, They'd implemented the fake dementia plan to redirect my focus. Text messages presented at trial showed their callousness. Tyler: Dad's getting too nosy about our schedules. We need to distract him. Madison: What if we make him think he's getting sick like Grandma? He's always worried about that. Tyler: Make him think he has dementia? That's genius. He'll be too focused on that to notice anything else. They deliberately exploited my grief over my mother's Alzheimer's and my wife's recent death to facilitate their criminal enterprise. The court convicted all three. Tyler received 3 years in adult prison for drug dealing and elder abuse, eligible for parole after 18 months. Madison received 18 months in juvenile detention plus mandatory drug counseling and probation. Ethan received 12 months in juvenile detention plus intensive counseling and probation. Upon release, all three faced strict probation conditions, including random drug testing, GPS monitoring, mandatory counseling, and restrictions on association with each other. Family relationships were shattered. Tyler showed no remorse. You wouldn't have understood. We needed the income after Mom died. So you convinced me I had Alzheimer's? Exploited my worst fear? It worked, didn't it? You were so worried about your memory you never noticed what was actually happening. Madison showed more guilt. I'm sorry, Dad. It started small, just moving your keys as a prank. Then Tyler turned it into the whole fake dementia thing. I went along with it. Ethan cried during sentencing. I just wanted Tyler and Madison to like me. I didn't want to be left out. Extended family was horrified when they learned the truth. My brother: Your own children gaslighted you about having early Alzheimer's. While dealing drugs from your basement? That's sociopathic. Support groups for parents of troubled teens provided some comfort, though none had experienced quite this combination of psychological abuse and criminal activity. The drug treatment community where my children were mandated to receive counseling used their case as an example of how drug involvement can corrupt family relationships. These juveniles didn't just sell drugs. They psychologically abused their father to hide it. Mental health professionals who evaluated me confirmed the trauma. You experienced months of believing you were developing a devastating degenerative disease. That fear was deliberately created by your children. The psychological impact is profound. Do I forgive my children? I don't know yet. They're serving their sentences. I visit Madison and Ethan occasionally. They're minors, still my children despite everything. I haven't visited Tyler. His lack of remorse makes contact impossible. Will our family recover? Unknown. The betrayal runs deep. They didn't just commit crimes. They attacked my sense of reality and exploited my genetic vulnerability. I'm rebuilding my life without the fake dementia symptoms. Knowing my memory is fine, my cognitive function normal, brings relief. But the trauma of months spent believing I was losing my mind remains. The house has been searched by police, cleared of all drugs, and returned to me. Walking through it now feels different. Every room holds memories of their deception. Some betrayals involve making a parent doubt their own mind. Tyler, Madison, and Ethan's was one of them. They're serving time. I'm recovering from psychological abuse they inflicted. Fair outcome? They earned their consequences. I didn't earn their betrayal. But that's what happened. Children who dealt drugs by convincing their father he had dementia. They're imprisoned. I'm free from fake symptoms and real fear. That's where we are. Not where any of us should be, but where their choices led. Every day my memory works normally is proof their gaslighting failed long term. Every day they spend in detention is proof their scheme had consequences. Fair enough. Just enough. Barely enough. But enough. Realizing that adult daughter had been secretly recording therapy sessions to use against me. I discovered my adult daughter had been secretly recording my private therapy sessions for 2 years to gather ammunition for a parental alienation case against me in her custody dispute. I'm 51 years old, divorced mother of one adult daughter, Sophia, who is 28. Sophia has a 4-year-old son, my grandson Mason. Sophia is going through a difficult divorce from her husband James, and they're fighting over custody of Mason. As her mother, I've been supporting Sophia emotionally through this painful process. 2 years ago, Sophia asked if she could attend some of my therapy sessions with me. "Mom, you've always said therapy helped you through your divorce from Dad. I'm going through the same thing now. Would Dr. Chen mind if I sat in on a few sessions? I think hearing your process might help me." I was touched by her request. My therapy with Dr. Chen had been crucial in processing my own divorce 15 years ago and maintaining my mental health since. If attending some sessions could help Sophia, I was happy to include her. Dr. Chen approved. "If you're comfortable having Sophia present for some sessions, that's your choice. We'll discuss your boundaries around what topics feel appropriate with her there." Sophia attended approximately 30 of my therapy sessions over 2 years. Not every session, but once or twice a month when she said she needed support or wanted to understand how I'd processed similar emotions during my divorce. During these sessions, I was vulnerable. I talked about my fears, past mistakes, regrets about my parenting when Sophia was young, ongoing anxieties about relationships, and my deepest insecurities. Dr. Chen created a safe space where I could process difficult emotions. Having Sophia there felt like mother-daughter bonding, sharing my growth process to help her through her own struggles. Sophia would thank me afterward. "Mom, hearing you work through these things helps me so much. I'm learning how to process my divorce in healthy ways." 3 months ago, James's attorney filed motions in their custody case, including exhibits that made my blood run cold. The exhibits contained verbatim quotes from my private therapy sessions, things I'd said in Dr. Chen's office that I'd never repeated to anyone outside those sessions. Quotes like, "I sometimes wonder if I was too focused on my own needs when Sophia was young. Maybe I wasn't as present as I should have been. I struggle with controlling tendencies in relationships. It's something I'm working on. There are days I feel like I failed as a mother. The guilt stays with me." These were private therapeutic reflections, statements made in the safety of Dr. Chen's office while working through complex emotions and past experiences. Now, they were in court documents, presented as evidence that I was an unfit grandmother who shouldn't have unsupervised access to Mason. James's attorney argued, "The child's maternal grandmother admits to being an absent parent, having controlling tendencies, and believing she failed as a mother. Given these self-acknowledged issues, we request that her access to the minor child be supervised to protect his well-being." How did James's attorney have word-for-word quotes from my therapy sessions? I confronted Sophia. "Your husband's attorney is quoting things I said in therapy, things I only said in Dr. Chen's office when you were present. How does James have this information?" Sophia's face flushed. "I don't know what you're talking about." "Sophia, these are exact quotes from sessions you attended. Only you, me, and Dr. Chen were in that room. How did James get them?" She wouldn't meet my eyes. That's when I knew. Sophia had been recording my therapy sessions. Every vulnerable moment, every private reflection, every therapeutic processing of past mistakes. She'd been recording it all to give to James for his custody case against her. But why would Sophia help James's case against herself? Unless they were working together. The truth emerged through further investigation and eventually Sophia's reluctant admission. She and James weren't actually fighting over custody. They were working together to limit my access to my grandson, and they'd manufactured the custody dispute to provide cover for gathering evidence against me. I hired an attorney who subpoenaed all evidence James's legal team had submitted. The recordings were extensive, over 40 hours of audio from my therapy sessions spanning 2 years. Every session Sophia attended, she'd recorded on her phone hidden in her purse. My attorney analyzed the recordings and cross-referenced them with the custody filings. Your daughter recorded your private therapy sessions, then selectively edited quotes out of context to make you appear unstable and unfit. But here's what's interesting. James's custody petition doesn't actually seek to limit Sophia's time with Mason. It only requests that your time with him be supervised. This isn't a typical custody dispute. Further investigation revealed the shocking truth. Sophia and James weren't actually getting divorced. They were still living together, sleeping in the same bedroom, operating joint bank accounts. The divorce and custody battle were completely fabricated. The real goal was limiting my access to Mason by painting me as an unfit grandmother who needed supervised visitation only. But why? Text messages between Sophia and James revealed their motivation. Sophia: got another recording from Mom's therapy today. She talked about her controlling tendencies again. Perfect ammunition. James: good. Build the case slowly. Make it look legitimate. Sophia: why are we doing this again? She's just trying to be a good grandmother. James: because she's too involved. Always wanting Mason to visit, calling constantly, questioning our parenting. We need boundaries, but she won't respect them unless a court forces her to. They'd faked an entire divorce and custody dispute to create a legal framework for limiting my contact with my grandson, using my own therapy sessions as ammunition to argue I was unstable and needed supervised access only. More messages showed they'd planned this for over 2 years. James: your mom goes to therapy weekly, right? Start attending her sessions. Record everything. We'll have plenty to use against her. Sophia: won't she think it's weird if I suddenly want to go to her therapy? James: tell her you want to learn from her process. She'll be flattered. She'll open up even more with you there. They'd manipulated my trust, exploited my vulnerability in therapy, and weaponized my private mental health treatment against me, all to reduce my time with my grandson without having to directly confront me about their boundaries. I was devastated. My daughter had violated my medical privacy, exploited my mental health treatment, and used my therapeutic vulnerability against me. And for what? To avoid a direct conversation about visitation boundaries? Dr. Chen was horrified when I told her, Sophia recorded our sessions? Without your consent or mine? That's a violation of medical privacy, therapeutic confidentiality, and possibly illegal depending on state recording laws. I consulted with privacy attorneys who confirmed, recording private medical appointments without consent of all parties violates medical privacy laws, potentially violates state wiretapping laws, and definitely violates therapeutic privilege. Your daughter committed multiple crimes to gather this evidence, my attorney explained, and she did it as part of a fabricated legal proceeding, the fake divorce. This is fraud on the court as well. I filed complaints with medical privacy authorities, violation of my rights to confidential medical treatment, state licensing board. Dr. Chen's office security had been breached by unauthorized recording. Family court. Fraud. The custody dispute was fabricated, and evidence was obtained through illegal recordings. Criminal authorities. Illegal recording of confidential medical appointments and fraud. I also filed for grandparent visitation rights and protective orders to prevent Sophia and James from using illegally obtained therapy recordings in any legal proceeding. The legal consequences for Sophia and James unfolded across multiple fronts. The family court system responded first and most severely. The family court judge was furious when presented with evidence of the fabricated divorce and custody dispute. You filed hundreds of pages of custody documents, requested emergency hearings, consumed court resources, all while living together as a married couple? And the sole purpose was to use fraudulently obtained therapy recordings to limit the grandmother's access to the child? The judge sanctioned both Sophia and James for fraud on the court. This is one of the most egregious abuses of the family court system I've encountered. You manufactured an entire legal proceeding to avoid having a direct conversation about visitation boundaries. All custody filings were dismissed with prejudice. Sophia and James were ordered to pay court costs and fines for frivolous litigation. Their attorneys, who'd been deceived about the fake divorce, withdrew representation and reported them to the state bar. The recordings of my therapy sessions were ruled inadmissible for any purpose. Evidence obtained through illegal recording of confidential medical appointments cannot be used in any legal proceeding. All recordings must be destroyed under court supervision. The court then addressed my grandparent visitation petition. Given Sophia and James's conduct, the judge granted me unsupervised visitation. The parents manufactured a false case to restrict the grandmother's access. They've shown willingness to commit fraud and violate medical privacy rather than communicate directly. I'm ordering regular unsupervised grandparent visitation. I was granted every other weekend with Mason, plus alternating holidays. More access than before their fake custody case. Criminal charges followed. Sophia was charged with illegal recording, violating state wiretapping laws by recording private medical appointments without consent of all parties. Medical privacy violations, unlawfully recording confidential therapy sessions. Fraud, participating in fabricated legal proceedings. Identity theft, using my private medical information without authorization. James was charged as co-conspirator on all counts. The prosecutor emphasized the violation. The defendants conspired to illegally record over 40 hours of confidential therapy sessions, then used selectively edited quotes in fabricated court filings. This represents serious violations of medical privacy, wiretapping laws, and court integrity. Dr. Chen filed civil suit for violation of therapeutic confidentiality and unauthorized recording in her medical office. The state licensing board investigated security protocols and required enhanced privacy protections. Sophia pled guilty to reduced charges, illegal recording and fraud, in exchange for avoiding trial. She received 12 months probation, mandatory counseling about boundaries and communication, fines, and community service. James received similar sentence as co-conspirator. Both were ordered to complete parenting classes focused on healthy communication and appropriate boundary setting with extended family. Mason's therapy began to process the confusion of having been used as a pawn in his parents' fabricated custody dispute. His therapist noted, "This child was told his parents were divorcing, experienced fake custody evaluations, and saw grandparents portrayed as dangerous, all as manipulation. The psychological impact is significant. My relationship with Sophia is permanently damaged. You recorded my therapy sessions, my most vulnerable moments, my private mental health treatment. You exploited my trust to use my own words against me. We just wanted boundaries with your involvement in Mason's life," Sophia said weakly. "You could have talked to me. Instead, you faked a divorce, manufactured a custody case, illegally recorded my therapy for 2 years, and tried to have my access to Mason supervised. That's not boundary setting, that's psychological warfare." Dr. Chen and I had to process the violation of our therapeutic relationship. The safe space we created was secretly recorded for 2 years. Your daughter heard your most vulnerable reflections and weaponized them. We need to rebuild trust in the therapeutic process. Extended family struggled to understand. Sophia faked her divorce? Recorded your private therapy? To avoid asking you to visit less often? That's insane. Mental health advocacy groups used the case to highlight therapy privacy. Recording someone's therapy sessions is profound violation. Using therapeutic vulnerability against them destroys the foundation of mental health treatment. Legal experts noted the precedent. This case demonstrates the intersection of medical privacy, wiretapping laws, and family court fraud. The grandmother actually ended up with more access than before the fake case. Do I forgive Sophia? Not yet. Maybe never. She violated my medical privacy, exploited my therapeutic vulnerability, and manipulated the court system to avoid a simple conversation. Can our relationship recover? Unknown. She's Mason's mother. I have to maintain some connection. But trust is destroyed. I see Mason regularly now, court-ordered unsupervised visitation. Sophia and James didn't limit my access. They increased it through their fraud. Ironic outcome. They manufactured a custody case to reduce my time with Mason. The court responded by legally guaranteeing me that time. Some betrayals backfire completely. Sophia and James's was one of them. They committed fraud and violated privacy for boundaries they could have requested directly. Cost them. Criminal records, fines, probation, legal fees, destroyed trust, mandated parenting classes. Gained them. Nothing. Lost them. Everything. I have Mason every other weekend now. Legal right to time with my grandson. More structured than before, but guaranteed. Sophia has criminal record and destroyed relationship with her mother. Fair trade? She made it. Therapy continues. Dr. Chen and I rebuilt our safe space. New privacy protections. New trust. Mason thrives despite being used as pawn. Resilient child. Getting therapy. Learning healthy family dynamics. Some parents can't set boundaries without fraud and privacy violations. Sophia and James proved that. They're paying for it. Legally, emotionally, relationally. I'm rebuilding. With Mason. With therapy. Without trusting Sophia. That's where we are. Not where we were. Where their choices led. They wanted boundaries. Got court orders instead. I wanted relationship. Got legal visitation rights instead. Nobody won. Everybody lost something, Mason especially. But we survive. We rebuild. We move forward. Despite them. Because of them. Around them. That's enough. It has to be. Stepson had been contaminating chemotherapy IV bags to make cancer treatment fail. I discovered my stepson, a hospital pharmacy technician, had been deliberately contaminating my chemotherapy infusions for 5 months to make my cancer treatment ineffective, ensuring the disease would progress while appearing I was receiving proper care. I'm 49 years old, diagnosed with stage 2 breast cancer 11 months ago. The prognosis was good. With surgery and chemotherapy, my oncologist projected 85% 5-year survival rate. I underwent lumpectomy successfully, then started aggressive chemotherapy to eliminate any remaining cancer cells and prevent recurrence. My husband Richard is 52, and his son from his first marriage, Tyler, is 26 and works as a pharmacy technician at the hospital where I received treatment. Tyler seemed supportive when I was diagnosed. "I work in the oncology pharmacy," he'd said. "I'll make sure your chemo is prepared correctly and administered on schedule. You're getting the best possible care." Richard was grateful. "Having Tyler work at your hospital is such a blessing. He can watch over you during treatment." I appreciated Tyler's concern and felt reassured having someone with medical knowledge looking out for me. Tyler would visit me during chemotherapy infusions, check on the IV setup, and ask nurses about my treatment progress. He seemed genuinely invested in my recovery. But 5 months into chemotherapy, my oncologist delivered concerning news. "Your tumor markers aren't declining as expected. The chemotherapy should be showing more effect by now. Let's run additional scans." The scans showed the cancer hadn't shrunk. It had actually grown slightly, despite 5 months of aggressive treatment. My oncologist was baffled. "You've received correct dosages of appropriate chemotherapy drugs on schedule. Your body should be responding. This level of treatment resistance is unusual for your cancer type." What does this mean? "We may need to try different chemotherapy drugs or increase dosage. Your cancer appears more aggressive than initial pathology suggested." I was devastated. I'd endured 5 months of brutal chemotherapy side effects: nausea, fatigue, hair loss, weakened immune system. Yet the cancer was growing despite treatment. My prognosis worsened from 85% survival to 60% as the cancer was upgraded to stage 3. Tyler seemed concerned. "Mom's cancer isn't responding to chemo? That's terrible. What's the next treatment plan?" Richard relied heavily on Tyler's medical knowledge. "What do you think about her case? You work with cancer patients daily." "Some cancers are just treatment resistant," Tyler would say. "Sometimes even proper chemotherapy doesn't work. Her body might not be responding to the drugs." My oncologist switched me to a different chemotherapy protocol, more aggressive drugs with worse side effects. "We need to hit this cancer harder. The first regimen didn't work, so we'll try combination therapy with higher doses." I endured another 3 months of even more brutal treatment. Still, my tumor markers didn't improve. Scans showed continued cancer growth despite maximum chemotherapy dosing. "I don't understand this," my oncologist said. "You're receiving optimal treatment. Your body is absorbing the drugs. We've confirmed blood levels. But the cancer keeps progressing as if you're not receiving treatment at all." Tyler suggested, "Maybe her cancer is just one of those aggressive types that doesn't respond to standard treatment. Some patients have naturally resistant cancers." My prognosis declined to 40% 5-year survival. Doctors discussed experimental treatments and clinical trials. I felt like I was dying despite receiving supposedly optimal care. Last week, a pharmacy director at the hospital contacted me. "We've discovered irregularities in some chemotherapy preparations. Several patients' medications may have been compromised. We're investigating and need to test samples from your recent infusions." Testing revealed horrifying truth. My chemotherapy bags had been contaminated with saline, diluting the active drugs to ineffective concentrations. For 8 months, I'd been receiving chemotherapy that was 40 to 60% weaker than prescribed because someone had been adding saline to my IV bags, making treatment ineffective while appearing I was getting proper doses. Pharmacy surveillance reviewed. Tyler had been accessing my chemotherapy bags before they were sent to infusion center, injecting saline to dilute the active drugs, then resealing the bags. I'd been receiving weakened, ineffective treatment for 8 months, while Tyler ensured my cancer would progress untreated. The pharmacy director's investigation uncovered the full scope of Tyler's sabotage and confirmed he'd been systematically contaminating my chemotherapy for 8 months with deliberate intent to make my cancer treatment fail. Hospital security reviewed pharmacy surveillance footage spanning the entire period of my treatment. Accessing chemotherapy preparations. Tyler had used his credentials to access the clean room where chemotherapy was prepared. On days I was scheduled for infusion, he'd locate my specific IV bags after they'd been prepared by other technicians, but before they were transported to the infusion center. Dilution process. Video showed Tyler injecting saline solution into my chemotherapy bags using syringes, diluting the active cancer-fighting drugs to 40 to 60% of prescribed strength. He'd carefully calculate amounts to avoid obvious changes in bag volume or appearance. Resealing bags. Tyler would reseal the contaminated bags so they appeared untampered. The diluted chemotherapy would then be transported to infusion center and administered to me, with everyone believing I was receiving full-strength treatment. Frequency. Tyler contaminated 23 out of 24 scheduled chemotherapy infusions over 8 months. The only infusion he didn't tamper with was one he wasn't working the day it was prepared. Pharmacy quality control tested stored samples from my infusions. Results confirmed. Infusion number 1-5. Chemotherapy concentration 55 to 65% of prescribed strength. Infusion number 6 through 12. Concentration dropped to 45 to 55% as Tyler became bolder. Infusion number 13 through 23. Concentration only 40 to 50% of prescribed levels. I'd been receiving essentially half-strength chemotherapy for 8 months because Tyler was diluting it with saline. No wonder the cancer wasn't responding. I wasn't receiving adequate treatment despite enduring all the side effects. Text messages between Tyler and his biological mother, Richard's ex-wife, revealed the motive. Tyler: diluted her chemo again today. Cancer markers are still rising despite treatment. Mother: good. Once she's gone, your father will come back to his senses. This marriage was a mistake. Tyler: doctors are baffled why the cancer isn't responding. They think she's just treatment resistant. Mother: keep it up. Natural causes. No one will ever know. Tyler and his mother had conspired to kill me through sabotaged cancer treatment. They wanted me dead so Richard would be free to potentially reconcile with his ex-wife. And they were using Tyler's pharmacy access to ensure my cancer would progress untreated. More messages showed long-term planning. Mother: how much longer until the cancer kills her? Tyler: hard to say. Maybe 6 to 12 months without effective treatment. Her oncologist is getting desperate, trying different drugs, higher doses. Doesn't matter since I'm diluting everything. Mother: what if they figure out the chemo is diluted? Tyler: they won't. Quality control only spot checks random samples. I'm careful. Her cancer progressing despite treatment looks like natural disease course. They'd researched survival rates and calculated how long I'd live with undertreated cancer. Tyler had been studying my treatment protocol to ensure he diluted drugs enough to make them ineffective, but not so much that testing would catch the tampering. Searches on Tyler's devices. How long does breast cancer patient live without chemotherapy? Chemotherapy dilution effects on cancer treatment. Detection methods for contaminated IV medications. Breast cancer stage 3 survival rates. The hospital immediately reported to law enforcement. Tyler was arrested at work, his pharmacy credentials revoked, and criminal investigation launched. Medical Review Board evaluated my case. This patient received inadequate chemotherapy for 8 months due to deliberate contamination by pharmacy technician. Her cancer progressed from stage 2 to stage 3, from 85% survival to 40% survival because she wasn't receiving effective treatment. The sabotage caused measurable, potentially irreversible harm. My oncologist was devastated. I couldn't understand why your cancer wasn't responding. I questioned my treatment choices, considered your cancer uniquely aggressive. Learning your stepson was sabotaging your chemotherapy. I'm so sorry. We should have caught this. How much damage has been done? Significant. 8 months of ineffective treatment allowed the cancer to progress when it should have been shrinking. We need to start completely new protocol with verified, uncontaminated chemotherapy. You'll need additional months of treatment and possibly radiation. Your prognosis is worse than it should be because of the sabotage. Richard was in shock when confronted with evidence. Tyler was contaminating your chemotherapy? My son was trying to kill you? Working with his mother? I filed for divorce immediately. Richard had been oblivious to the conspiracy, but his son had nearly killed me and I couldn't remain married into that family. The criminal case against Tyler proceeded on charges of attempted murder, assault, pharmaceutical tampering, and abuse of professional credentials. The evidence was overwhelming, and the harm was medically documented. Tyler was charged with attempted murder, deliberately sabotaging life-saving cancer treatment with intent to cause death. Aggravated assault, causing serious bodily harm through chemotherapy contamination. Pharmaceutical tampering, adulterating prescription medications intended for patient care. Abuse of professional credentials, misusing pharmacy access to commit crimes. His mother was charged as co-conspirator based on text messages showing she encouraged the sabotage and planned to benefit from my death. The prosecutor's case. The defendant used his position as hospital pharmacy technician to systematically contaminate his stepmother's chemotherapy for 8 months. He diluted cancer-fighting drugs to ineffective concentrations, ensuring her cancer would progress untreated. His motive was eliminating her from his father's life. His method was weaponizing medical access to commit murder disguised as treatment failure. Pharmacy experts testified, the defendant accessed chemotherapy preparations 23 times over 8 months, each time injecting saline to dilute active drugs to 40 to 60% of prescribed strength. Surveillance footage shows deliberate, calculated contamination. This wasn't accidental. This was systematic medical sabotage. Oncologists testified, chemotherapy effectiveness depends on precise dosing. Diluting drugs to half strength makes treatment largely ineffective. This patient's cancer progressed from stage 2 to stage 3, from good prognosis to poor prognosis, because she received 8 months of sabotaged treatment. The defendant caused measurable progression of life-threatening disease. Medical testing confirmed stored samples from 23 infusions all showed dilution consistent with saline contamination. The pattern matched exactly when Tyler was working versus rare days he wasn't. Text messages between Tyler and his mother showed premeditation, intent, and celebration of my declining health. The jury heard them discuss dilution schedules, cancer progression, and plans for after my death. My testimony. I endured 8 months of chemotherapy side effects, nausea, hair loss, immune suppression, fatigue. I suffered through brutal treatment believing it was saving my life. My stepson was ensuring it wouldn't work. He watched my cancer progress, saw me deteriorate, and continued contaminating my treatment. He tried to kill me slowly while pretending to support me. Hospital administration testified, the defendant violated every principle of pharmaceutical care. Patients trust that medications are prepared correctly. He betrayed that trust to commit attempted murder. Tyler's defense claimed he was trying to spare me suffering from harsh chemotherapy. My client believed the treatment was causing more harm than good and thought reducing dosage would improve quality of life. The prosecutor destroyed this. The defendant didn't reduce dosage through proper medical channels. He secretly contaminated chemotherapy without patient knowledge or physician approval. Text messages show he wanted the cancer to kill her so his father would be free. This was attempted murder, not misguided compassion. Medical ethicists. There's no ethical justification for secretly altering patient medications. If the defendant had genuine concerns about treatment, he should have raised them with oncology team. Instead, he sabotaged care while pretending to support it. The jury convicted on all counts. Tyler received 25 years in prison for attempted murder through medical sabotage. His mother received 15 years as co-conspirator. Both received permanent bans from healthcare work. I immediately started new chemotherapy protocol with pharmacy director personally verifying every preparation. Security protocols enhanced. Multiple checks, sealed preparations, chain of custody documentation. 3 months into verified, uncontaminated treatment, tumor markers finally dropping, scans showing cancer shrinking. My oncologist. This is the response we should have seen 8 months ago. The treatment is working now that you're receiving full-strength medication. Prognosis improving. Back to 70% 5-year survival after aggressive treatment of the progression Tyler caused. Not the 85% I would have had without sabotage, but better than the 40% I faced after 8 months of diluted chemotherapy. Richard and I divorced. He was horrified by Tyler's actions, but I couldn't remain connected to that family. Tyler and his mother had conspired to kill me. The family bond was irreparably broken. Extended family. Tyler contaminated your chemotherapy for 8 months? Trying to kill you so his parents might reconcile? That's psychotic. Medical community. This case shows vulnerability of pharmaceutical preparation. Enhanced security and verification protocols are now standard. Cancer advocacy groups. If treatment isn't working as what expected, question everything. This victim's cancer progressed because medications were sabotaged, not because her body didn't respond. Tyler's in prison. Chemotherapy properly prepared. cancer responding to treatment, life being saved despite his sabotage. Some betrayals involve contaminating life-saving medication. Tyler's was one of them. 25 years he'll serve. 8 months he sabotaged my treatment. 49 years I've lived, nearly lost to his conspiracy. Cancer shrinking now. Prognosis improving. Treatment working with verified medications. Everything he tried to destroy. Everything I'm fighting to save. That's enough. Teenage son had been secretly recording intimate moments to blackmail me into allowing his girlfriend to move in. I discovered my 17-year-old son had been secretly recording my intimate moments with my partner for 8 months, collecting footage he planned to use as blackmail to force me to let his girlfriend move into our home. I'm 45 years old, single mother to one son, Jordan, who's 17 and a senior in high school. I've been dating my partner Marcus for about a year now. He's 47, divorced with grown children, and we've built a caring, respectful relationship. Marcus stays over at my house 2 or 3 nights per week, though he maintains his own apartment. Jordan has met Marcus, they're cordial, and I thought my son had adjusted well to me dating someone after years of being single. 3 months ago, Jordan asked if his girlfriend Kayla could move into our house. Kayla is also 17, from a troubled home situation with neglectful parents. Jordan argued she needed a stable environment, and we had a spare bedroom. Jordan, I understand Kayla's situation is difficult, but having your teenage girlfriend move in isn't appropriate. You're both 17, still in high school, and living together at this age isn't something I can support. Kayla has nowhere safe to go. Her parents don't care about her. We could help her. There are other ways to help. Connecting her with social services, finding resources for teens in unsafe home situations. But I'm not comfortable with your girlfriend living here. You let Marcus stay over all the time. How is that different? Marcus is a 47-year-old man in an adult relationship with me. You and Kayla are minors. The situations aren't comparable. Jordan was angry, but seemed to accept my decision. Kayla continued staying with various friends, occasionally sleeping at our house when her home situation was particularly bad, but not living with us permanently. 2 weeks ago, Jordan approached me again. Mom, I really need you to reconsider letting Kayla move in. It's important. My answer hasn't changed. I'm sorry Kayla's struggling, but having her live here isn't the solution. What if I had something that would change your mind? What do you mean? What if I had information that would make you want to reconsider? Information you wouldn't want other people to know? The conversation felt wrong, almost threatening. Jordan, what are you talking about? Just think about it, Mom. I'm sure you'll decide that letting Kayla move in is the right thing to do. He walked away, leaving me confused and unsettled. 2 days later, Jordan sent me a video file through text message with the caption, "Still think Kayla can't move in?" I opened the video and felt my stomach drop. It was footage of Marcus and me in my bedroom, clearly filmed through my bedroom window from outside. The video showed us in intimate moments, private moments that should have been completely private within my own home. I immediately called Jordan into my room. Did you film this? Have you been recording me and Marcus through my bedroom window? He didn't deny it. I've been recording for 8 months. I have hours of footage. If you don't let Kayla move in, I'll send it to everyone. Your family, your co-workers, Marcus's ex-wife, everyone on social media. I'll make sure everyone sees what you do with your boyfriend. My 17-year-old son had been secretly recording my intimate moments for 8 months to blackmail me. He'd positioned cameras or filmed through windows, capturing private moments between Marcus and me, building a collection of footage he planned to use as leverage to force me to let his girlfriend move into our home. Jordan, recording people in private, intimate moments without their consent is illegal. What you're describing is a serious crime. And having those videos go public would ruin your reputation. Your choice, Mom. Let Kayla move in, or everyone sees what you've been doing with Marcus. I was horrified, violated, and furious. My own son had been surveilling my most intimate moments, violating my privacy in the most profound way, all to manipulate me into letting his teenage girlfriend live with us. The scope of Jordan's surveillance and his blackmail plan became clear as I investigated further while pretending to consider his ultimatum. I needed to understand the full extent of what he'd done before taking action, both to protect myself legally and to ensure I had complete evidence of his crimes. I told Jordan I needed a few days to think about letting Kayla move in, buying time to gather information. During those days, I discovered the disturbing extent of his surveillance operation. Hidden cameras in my bedroom. Jordan had installed tiny wireless cameras in my bedroom, one positioned on a bookshelf with a clear view of my bed, another hidden in a decorative object on my dresser. These cameras had been recording continuously for 8 months, capturing not just intimate moments with Marcus, but also my private moments when I was alone. Changing clothes, sleeping, everything that happened in what should have been my private space. Outdoor window filming. In addition to the hidden indoor cameras, Jordan had sometimes positioned himself outside my bedroom window with his phone to record through the window when cameras didn't capture the angles he wanted. Organized video library. On Jordan's laptop, I found folders meticulously organized by date containing hundreds of video files from the bedroom cameras. He'd been reviewing footage, selecting the most compromising clips, and organizing them into a blackmail collection he planned to distribute if I didn't comply with his demands. Distribution plan. Documents on his computer outlined his blackmail strategy in detail. If I refused to let Kayla move in, he'd send videos to my employer. I work at a university. He had emails ready to send to my department chair and dean, my family members. He'd compiled a contact list. Marcus's ex-wife. He'd found her email address. And planned to post clips on social media accounts he'd created specifically for this purpose. Timeline of surveillance. The cameras had been installed 8 months ago, shortly after I started dating Marcus, and about a month before Jordan first asked if Kayla could move in. He'd been planning this blackmail scheme for nearly a year, installing surveillance specifically to gather leverage for his eventual request. Text messages between Jordan and Kayla revealed she knew about the recordings and supported the blackmail plan. Jordan: I've got hours of footage of Mom and Marcus. If she doesn't let you move in, I'm sending it to everyone. Kayla: You really think that will work? Jordan: She'll have no choice. Either she lets you move in, or her reputation is destroyed. She'll definitely choose keeping the videos private. Kayla: What if she calls the police? Jordan: She won't. She'll be too embarrassed about people knowing we have the videos. She'll just agree to let you move in and we can be together. They'd planned this together. Jordan collecting footage, Kayla encouraging the blackmail, both believing I'd be too ashamed to report the surveillance and would simply comply with their demands. More messages showed Jordan had been sharing some of the footage with friends, violating my privacy not just for blackmail, but for entertainment. Jordan to friend: Check out this video of my mom, lol. Friend: Dude, that's your mom, that's messed up. Jordan: It's hilarious. Plus, I'm using it to blackmail her into letting Kayla move in. Friend: You're seriously blackmailing your own mom with sex videos? Jordan: Whatever works. She should have just said yes when I first asked. My son had been showing intimate videos of me to his friends, treating my private moments as joke material, while simultaneously planning to use them as blackmail leverage. I consulted with an attorney who specialized in privacy violations and blackmail cases. The attorney was horrified. Your son has committed multiple serious crimes: illegal surveillance, recording intimate moments without consent, possession and distribution of illegally obtained intimate images, extortion through blackmail, and potentially child pornography charges if any footage shows you in states of undress that meet legal definitions. Can he actually be prosecuted? He's 17, still a minor himself. Yes, these are serious felonies. While he's a minor, the severity of the crimes, especially the blackmail and distribution of intimate recordings, means he'll likely be charged. You also need to protect yourself. If that footage gets distributed, you're the victim of a crime, but you could still face professional consequences. We need to act immediately. I reported everything to police: the hidden cameras, the 8 months of surveillance, the organized video library, blackmail threats, the distribution to friends, and Jordan's detailed plan to send footage to my employer and family if I didn't comply with his demands. The criminal investigation and prosecution proceeded quickly, given the clear evidence of Jordan's crimes. Police seized his computer, phone, and the hidden cameras, finding overwhelming proof of illegal surveillance, blackmail planning, and distribution of intimate recordings. Jordan was charged as a juvenile with illegal surveillance, installing hidden cameras in my bedroom and recording without consent for 8 months. Invasion of privacy, recording intimate moments in areas where privacy was expected. Extortion, threatening to distribute intimate recordings unless I complied with his demands. Distribution of intimate images, sharing some footage with friends without my consent. Possession of illegally obtained recordings. Maintaining library of videos captured through illegal surveillance. Kayla was charged as co-conspirator for her knowledge of and encouragement of the blackmail scheme. The juvenile court prosecutor emphasized the calculated nature. The defendant installed hidden cameras in his mother's bedroom, recorded her intimate moments for 8 months, organized the footage into a blackmail collection, and threatened to distribute it to her employer, family, and social media unless she allowed his girlfriend to move into their home. This is systematic invasion of privacy for purposes of extortion. Digital forensics experts testified about the extent of surveillance. We recovered over 200 hours of video footage from the defendant's devices, all recorded via hidden cameras in his mother's bedroom. The defendant organized this footage by date and content, created specific folders for blackmail purposes, and prepared distribution packages he planned to send if his demands weren't met. Privacy law experts testified. Recording someone in intimate moments within their own bedroom without their knowledge or consent is severe invasion of privacy and illegal surveillance. Using those recordings for blackmail compounds the violation exponentially. The videos themselves were presented to the judge in chambers, not played in open court to protect my privacy, but reviewed to understand the nature of the material Jordan had recorded and threatened to distribute. My testimony described the violation. I believed my bedroom was private. I never suspected my own son had installed cameras recording my most intimate moments. Learning he'd been surveilling me for 8 months, that he'd shown footage to his friends, that he'd organized it all for blackmail purposes. I felt violated in a way I can't fully express. Marcus testified about his trauma. I was recorded without consent in intimate moments with my partner. The defendant's blackmail threat included sending footage to my ex-wife specifically to cause me harm. This invasion of privacy has affected my ability to feel safe in what should be private moments. Text messages between Jordan and Kayla showed planning and awareness they were committing crimes. Messages where Jordan discussed blackmailing mom with the sex tapes, and Kayla encouraged the scheme, were presented as evidence of conspiracy. Jordan's defense attorney argued for leniency. My client is a 17-year-old minor who made terrible decisions trying to help his girlfriend escape an unstable home situation. His methods were completely wrong, but his motive was concern for someone he cares about. The prosecutor rejected this. The defendant's motive wasn't altruistic concern. He wanted his girlfriend to live with him. That's not about her safety, it's about his desires. He spent 8 months conducting illegal surveillance, threatened to destroy his mother's reputation and career, and showed intimate recordings to friends for entertainment. This is calculated criminal behavior, not a misguided attempt to help someone. The juvenile court judge convicted Jordan on all counts. As a 17-year-old, he was sentenced under juvenile justice system. 18 months in juvenile detention, followed by probation until age 21. mandatory counseling for consent and privacy violations, registration on sex offender registry due to intimate recording distribution, and permanent restraining order from me. Kayla received probation, counseling, and community service for her role as co-conspirator. All footage Jordan recorded was ordered destroyed under court supervision. Police verified complete deletion from all devices, cloud storage, and any locations where Jordan had backed up files. Jordan's friends who'd received videos were contacted by police and required to delete all footage. Some faced charges for possession of intimate recordings they knew were obtained illegally. I changed all locks, removed Jordan's belongings to storage, and began the difficult process of reclaiming my violated sense of safety in my own home. The bedroom where I'd been secretly recorded was completely redecorated. New furniture, new layout, new everything, to try to disassociate the space from the surveillance. Marcus and I are in couples therapy, processing the violation and rebuilding our sense of intimate privacy. The knowledge that we were recorded without consent for 8 months has affected our relationship. We're working through it, but the damage is real. Extended family struggled to comprehend. Jordan recorded you in your bedroom? For 8 months? To blackmail you? That's incomprehensible. Privacy advocacy groups used the case to highlight intimate surveillance. Hidden cameras in bedrooms for blackmail purposes represent severe violations. This case shows even family members can be perpetrators. Technology experts discussed prevention. Check your private spaces regularly for hidden cameras. Even people you trust completely can betray that trust. Do I forgive Jordan? Not now. Maybe never. He violated my privacy in the most intimate way, for blackmail purposes, and showed footage to his friends. Will we have a relationship when he's released? Unknown. He'll be 19, almost an adult. The restraining order lasts until then. After that, it's complicated. Jordan's in juvenile detention. Kayla's on probation. I'm in therapy. Marcus and I are rebuilding. Some betrayals involve surveillance of intimate moments. Jordan's was one of them. He wanted his girlfriend living with us. Got juvenile detention instead. I wanted privacy in my bedroom. Lost it for 8 months. Reclaiming it now. 18 months he'll serve. 8 months he recorded me. 45 years I've lived, and learned my own son would violate me this way. Numbers that tell a story. Sentences that equal consequences. Years that changed everything. We survive, though. Despite the violation, beyond the surveillance. Without Jordan now. Privacy slowly returning. Safety gradually rebuilding. Trust shattered but healing. That's where we are. Where his choices led. Where we're recovering from. He recorded everything. Courts erased everything. I'm reclaiming everything. Appropriate ending. Just consequence. Deserved outcome. Living privately again. Loving carefully. Learning to feel safe. Everything he tried to destroy. Everything surviving anyway. That's enough. Discovering sister had been secretly drugging me to fake psychotic episodes and force institutionalization. I discovered my younger sister had been putting hallucinogenic drugs in my food for 4 months to induce psychotic symptoms and have me involuntarily committed to psychiatric facility, allowing her to take custody of my teenage daughter. I'm 46 years old, single mother to my daughter Natalie, who's 15. I've raised her alone since my divorce 8 years ago, maintaining stable employment as a software engineer and providing a good home for my daughter. My sister Jenna is 42, married with no children, and has always been close with Natalie, taking her for weekend visits, attending her school events, and maintaining a strong aunt-niece relationship. 4 months ago, I started experiencing disturbing symptoms I'd never had before. Visual hallucinations, seeing things that weren't there, shadows moving in peripheral vision, distortions of familiar objects. Auditory hallucinations, hearing voices, sounds that others couldn't hear. paranoid thoughts about being watched or followed, confusion about what was real versus imagined. The episodes were terrifying. I'd be working normally, then suddenly see spiders crawling across my desk that vanished when I looked directly at them. I'd hear whispers in empty rooms. I'd feel certain strangers were staring at me with malicious intent. Each episode lasted several hours, then symptoms would gradually fade, leaving me exhausted and questioning my sanity. I saw my doctor, describing the hallucinations and paranoia. He referred me to a psychiatrist who conducted evaluations and ran tests. The psychiatrist was concerned. "Your symptoms suggest possible psychotic disorder. Have you had any family history of schizophrenia or bipolar disorder?" "No, nothing like that. This started suddenly 4 months ago. Before that, I was completely mentally healthy." "Adult-onset psychosis can occur. We'll start you on antipsychotic medication and monitor closely." The medication didn't help. Episodes continued, sometimes several per week. I'd miss work during severe episodes, struggle to care for Natalie, and fear I was having a complete mental breakdown. My psychiatrist increased medication dosages, tried different drugs, and suggested possible hospitalization if symptoms didn't improve. Jenna seemed supportive. "You need to focus on getting better. Let Natalie stay with us while you're dealing with this. She shouldn't see you during these psychotic episodes." "I can still care for my daughter. The episodes are scary, but they pass." "What if you have an episode while she's home and you can't distinguish reality? She needs stable environment. Come stay with us temporarily until you're stabilized on medication." Natalie started spending more time at Jenna's house as my episodes worsened. Jenna would pick her up after school, keep her for dinner, bring her home late. "Just trying to help while you're struggling with your mental health." 3 weeks ago, I had the worst episode yet. Severe hallucinations, complete break from reality lasting over 12 hours. I saw creatures that didn't exist, heard voices commanding me to do things, believed I was being hunted by shadowy figures. Natalie called 911, terrified by my behavior. EMTs found me barricaded in my bedroom, incoherent, and convinced demons were trying to enter the house. I was taken to psychiatric emergency room, evaluated, and held for 72-hour observation. The psychiatrist discussed long-term hospitalization. "Your psychotic symptoms are severe and medication-resistant. You may need intensive inpatient treatment." Jenna visited me in psychiatric ward. "I think Natalie should come live with us permanently. You're too sick to care for her. I'm going to petition for guardianship. Temporary at first, but if you don't improve, permanent. It's what's best for Natalie." "I'll get better. I just need to find the right medication." "You've been trying medications for months and getting worse. Face reality. You have serious mental illness. Natalie needs stable guardian." After discharge, I noticed something odd. The severe psychotic episode had occurred after eating dinner Jenna had prepared and brought over. Said she wanted to help since I was too sick to cook properly. The pattern became clear. My worst episodes always occurred within hours of eating food Jenna provided. I started refusing food from Jenna, claiming my new psychiatrist recommended strict diet. For 2 weeks, I ate nothing Jenna prepared. My psychotic symptoms completely stopped. No hallucinations, no paranoia, no episodes. Then Jenna brought over morning coffee. I pretended to drink it but poured it out when she wasn't looking. Within hours, I had another severe episode. Hallucinations, voices, complete break from reality. Jenna was drugging my food to induce psychotic symptoms. The realization that Jenna had been deliberately causing my psychotic episodes through drugging led me to carefully document evidence before confronting her or involving authorities. I needed proof of what she'd been doing. I installed hidden cameras throughout my house, particularly in the kitchen where Jenna prepared or handled food when she visited. I also saved samples of every food or drink Jenna provided, storing them in sealed containers in a locked box. Within 1 week, cameras captured Jenna adding substances to my food on 3 separate occasions. Tuesday evening. Jenna brought over dinner she'd made for me. Video showed her in my kitchen, taking a small vial from her purse and adding liquid to my pasta sauce while I was in another room. She stirred thoroughly to mix it in. Friday morning. Jenna stopped by with coffee. Camera showed her adding powder from a capsule to my cup in the 30 seconds I was answering the door. Sunday afternoon. Jenna brought groceries to help out. While putting items away, she injected liquid into a yogurt container using a syringe, then carefully resealed it and placed it in my refrigerator. I ate none of these items, saving them instead for testing. I also began documenting my mental state, daily journal entries, video logs showing I was lucid and stable when not consuming anything Jenna provided. I took the food samples to a private laboratory for analysis. Results came back showing pasta sauce contained lysergic acid diethylamide, LSD, a powerful hallucinogenic drug. Coffee contained psilocybin, the active compound in hallucinogenic mushrooms. Yogurt contained synthetic cannabinoid compounds that cause psychotic symptoms. Jenna had been giving me hallucinogenic drugs designed to produce exactly the symptoms I'd been experiencing. Visual hallucinations, auditory distortions, paranoia, confusion about reality. I hadn't developed psychotic disorder. I'd been systematically poisoned with psychedelic drugs. Text messages between Jenna and her husband revealed the conspiracy. Jenna: gave her another dose in the pasta. She should have another psychotic episode by tonight. Husband: how much longer until we can petition for permanent guardianship? Jenna: psychiatrist is already recommending long-term hospitalization. Once she's institutionalized, we can argue she's permanently unfit to care for Natalie. Husband: what if they figure out she's being drugged? Jenna: they won't. Psychiatric patients claiming to be drugged sounds like more psychotic symptoms. Perfect cover. More messages showed they'd been planning this for months. Jenna to husband: I want to raise Natalie. She should be our daughter. If her mother is mentally ill and institutionalized, we can get permanent custody. Husband: how do we make that happen? Jenna: I researched hallucinogens that cause psychotic symptoms. If I give them to her regularly, she'll present as mentally ill. Doctors will diagnose psychotic disorder. Eventually, she'll be hospitalized. Then we petition for guardianship of Natalie. They'd researched which drugs would produce convincing psychotic symptoms, calculated dosing schedules, and planned to have me permanently institutionalized in psychiatric facility so they could take custody of my daughter. Searches on Jenna's devices. Drugs that cause hallucinations and paranoia. How to induce psychotic symptoms. Guardianship of minor when parent is mentally ill. LSD dosage for severe hallucinations. Getting someone committed to psychiatric hospital. She'd studied psychiatric symptoms to ensure the drugs she was giving me would produce medically convincing presentation of psychotic disorder. The plan was sophisticated. Induce symptoms that would lead to psychiatric diagnosis and medication trials. Then, when medication didn't work, because it couldn't counteract the drugs she kept administering, I'd be deemed treatment-resistant and require long-term institutionalization. I gathered all evidence. Hidden camera footage of Jenna drugging food, laboratory analysis showing hallucinogens in food samples, text messages discussing the drugging plan. My symptom journal showing episodes only occurred after consuming Jenna's food, and psychiatric records documenting my psychotic disorder that would now be revealed as drug-induced. I reported everything to police, filing charges for poisoning, assault, conspiracy to commit fraud, false psychiatric diagnosis, and attempted kidnapping, planned to gain custody through fraudulent means. I also informed my psychiatrist with all evidence. The psychiatrist was horrified. Your sister was drugging you with hallucinogens. Your psychotic symptoms were chemically induced? This explains why medication wasn't working. You don't have a psychiatric disorder. You were being poisoned. The criminal prosecution proceeded on multiple serious charges. Evidence was overwhelming. Video documentation of drugging, laboratory confirmation of hallucinogens in food, text messages planning the scheme, and medical testimony about drug-induced versus organic psychosis. Jenna was charged with aggravated assault, administering dangerous drugs without consent, causing severe psychological and physical harm. Poisoning, deliberately contaminating food with controlled substances. Fraud, creating false appearance of psychiatric illness to enable guardianship petition. Attempted kidnapping, planning to gain custody of minor child through fraudulent means. Conspiracy, planning and executing scheme with her husband. Her husband was charged as co-conspirator based on text messages showing he encouraged the drugging and planned to benefit from gaining custody of Natalie. The prosecutor emphasized the calculated cruelty. The defendant systematically poisoned her sister with hallucinogenic drugs for 4 months, inducing terrifying psychotic symptoms. She watched her sister deteriorate, saw her being hospitalized, and continued drugging her. The goal was having her sister declared mentally ill and institutionalized, so the defendant could take custody of her niece. Toxicology experts testified. The drugs found in the food samples, LSD, psilocybin, synthetic cannabinoids, are powerful hallucinogens that cause exactly the symptoms the victim experienced: visual distortions, auditory hallucinations, paranoia, confusion about reality. Administered repeatedly, they would create convincing presentation of psychotic disorder. Psychiatrists testified. Drug-induced psychosis is clinically indistinguishable from organic psychotic disorders during acute episodes. The defendant deliberately induced symptoms that would lead to psychiatric diagnosis. The victim was medicated for disorder she didn't have because she was being poisoned. The hidden camera footage showed Jenna methodically adding substances to food: powder, liquids, injections into sealed containers. The jury watched her deliberate contamination while pretending to help her mentally ill sister. Laboratory reports confirmed hallucinogens in multiple food samples at dosages that would cause severe psychotic symptoms. Text messages showed premeditation. I researched hallucinogens that cause psychotic symptoms, and eventually she'll be hospitalized. Then we petition for guardianship. My testimony described the terror. I thought I was losing my mind, seeing things that weren't there, hearing voices, unable to trust my own perception. I was terrified, being medicated for psychotic disorder, facing institutionalization. Learning my sister was deliberately causing these symptoms by drugging me. The betrayal is beyond words. Natalie testified. My aunt made me believe my mom was mentally ill. She convinced me mom couldn't take care of me anymore. She was planning to take me away from my mom by poisoning her. Medical records showed my treatment-resistant psychotic disorder completely resolved once drugging stopped. Current psychiatric evaluation. Patient shows no signs of psychotic disorder. Previous symptoms were entirely drug-induced. Jenna's defense claimed she was trying to help by giving me alternative treatments. My client researched natural remedies and gave them to her sister to help with stress. The prosecutor destroyed this. The defendant gave her sister LSD, psilocybin, and synthetic cannabinoids, Schedule I controlled substances, not natural remedies. She did this secretly, without consent, deliberately causing psychotic symptoms. Text messages show she planned to institutionalize her sister to take custody of her niece. This was systematic poisoning for child abduction. The jury convicted on all counts. Jenna received 18 years in prison. Her husband received 12 years as co-conspirator. Both received permanent restraining orders from Natalie and me. My psychotic disorder diagnosis was removed from medical records. Psychiatrists amended notes. Previous diagnosis was erroneous. Patient's symptoms were drug-induced by family member who was systematically poisoning her. Natalie and I are rebuilding. She's in therapy processing that her aunt tried to institutionalize her mother to gain custody. Our relationship strengthening after months of Jenna's manipulation. Extended family horrified. Jenna drugged you with hallucinogens for 4 months, trying to have you institutionalized so she could take Natalie? That's monstrous. Mental health advocates used case to highlight, not all psychiatric symptoms indicate mental illness. Drug-induced psychosis can mimic organic disorders. Thorough investigation needed when symptoms appear suddenly. Toxicology screening now standard when treating new-onset psychosis in previously healthy adults. Do I forgive Jenna? Never. She poisoned me, tried to steal my daughter, nearly had me institutionalized permanently. Can Natalie forgive her aunt? She's 15, processing that someone she trusted wanted to take her from her mother through psychiatric fraud. Jenna's in prison. I'm mentally healthy, never was sick, just poisoned. Natalie's home with her actual mother. Some betrayals involve inducing fake mental illness. Jenna's was one of them. 18 years she'll serve. 4 months she drugged me. 46 years I've lived, nearly lost to psychiatric institutionalization based on her poisoning. Numbers that matter. Prison time that equals justice. Years I'm reclaiming with my daughter. Living without hallucinations. Parenting without psychotic episodes. Knowing I was never mentally ill, just systematically poisoned by sister who wanted my child. Everything she tried to destroy. Everything that survived. Enough. Learning that cancer diagnosis was fabricated to manipulate custody arrangements. I discovered my ex-wife had faked a terminal cancer diagnosis to gain full custody of our children and alienate them from me during what she claimed were her final months. I'm 48 years old, divorced father of 2, Owen, 13, and Chloe, 11. My ex-wife Jennifer and I divorced 3 years ago after growing apart, but we'd maintained an amicable co-parenting relationship. We shared custody equally, alternating weeks, communicating well about the kids' needs and schedules. 8 months ago, Jennifer called me with devastating news. She'd been diagnosed with stage 4 ovarian cancer. The prognosis was grim. Doctors gave her 6 to 12 months to live. She was starting aggressive treatment immediately, but needed to prepare for the worst. I was shocked and heartbroken. Despite our divorce, Jennifer was the mother of my children, my partner for 15 years. The thought of her dying, of Owen and Chloe losing their mother, was devastating. I need to ask something difficult, Jennifer said through tears. I want the kids with me full-time for whatever time I have left. I want every possible moment with them. Can we modify the custody arrangement temporarily? How could I refuse? She was dying. Of course she should have maximum time with our children in her final months. Yes, absolutely. Whatever you need. The kids should be with you. We filed an emergency custody modification. The court granted Jennifer temporary full custody given her terminal diagnosis and need to maximize remaining time with her children. I was granted visitation, weekends only, and even that was often canceled because Jennifer wasn't feeling well after chemotherapy. Jennifer showed me medical documents confirming her diagnosis, oncology reports, treatment plans, prescription bottles. She'd shaved her head, claiming hair loss from chemotherapy. She looked pale and tired, which she attributed to aggressive treatment. The kids told me about accompanying her to doctor appointments and watching her rest after treatment. I supported her through this nightmare however I could. Took over all financial responsibilities for the kids, sent care packages, offered to drive her to appointments. She usually declined help. I have my sister supporting me through treatments, but thank you. The kids started becoming distant from me. When I'd pick them up for weekend visitation, they seemed reluctant to leave Jennifer. Owen said, "Mom might not have much time left. We want to stay with her." Jennifer encouraged this. "Kids, you should spend time with your father. I'll be here when you get back." But her martyred tone implied otherwise. like each moment away from her was time they'd regret when she was gone. 6 months into this nightmare, I ran into Jennifer's oncologist at a medical conference. I recognized Dr. Patricia Brennan from the oncology reports Jennifer had shown me. I approached Dr. Brennan. "You treated my ex-wife, Jennifer. I wanted to thank you for caring for her through her ovarian cancer treatment." Dr. Brennan looked confused. "I don't have a patient named Jennifer with ovarian cancer. Are you sure you have the right oncologist?" "Yes, Jennifer showed me reports with your name. Stage 4 ovarian cancer, aggressive chemotherapy protocol." "I think there's been a mistake. I haven't diagnosed anyone named Jennifer with ovarian cancer in the past year." I showed Dr. Brennan photos of the medical documents Jennifer had provided. Dr. Brennan examined them and her expression changed. "These are falsified. This isn't my letterhead. My signature is forged, and these treatment protocols don't match current ovarian cancer standards. Someone created fake medical documents." Jennifer had fabricated her terminal cancer diagnosis. The documents, the treatment, the prognosis, all lies to gain custody of our children and alienate them from me during her supposed final months. The realization that Jennifer had faked terminal cancer was so shocking I initially couldn't process it. But Dr. Brennan's certainty was absolute. The documents were forgeries, and Jennifer wasn't her patient. I needed to verify before taking action. I hired a private investigator to confirm Jennifer's medical status. Within 48 hours, he reported findings. No oncology appointments. Jennifer had not visited any oncology centers or cancer treatment facilities in the past 8 months. No chemotherapy. Hospital records showed no chemotherapy administrations to Jennifer. She'd never received the aggressive treatment she'd claimed was making her sick. No prescriptions. Pharmacy records showed no cancer medication prescriptions filled in Jennifer's name. The pill bottles she'd shown me were either old medications or over-the-counter items in prescription bottles. Medical document forgery. The oncology reports, treatment plans, and test results were all fabricated. Real oncologists' names and credentials were used, but the documents were created by Jennifer, not medical professionals. Hair loss staging. Jennifer had shaved her head herself to simulate chemotherapy side effects. Witnesses saw her at a salon having it done voluntarily, not due to treatment. She wasn't sick. She'd never had cancer. The entire terminal diagnosis was an elaborate lie to manipulate custody arrangements. I confronted Jennifer with the evidence. Her reaction confirmed everything. "You faked cancer? Terminal cancer? To get full custody of the kids?" She was defensive at first. "I don't know what you're talking about. My diagnosis is real." I spoke with Dr. Brennan. "She never diagnosed you with cancer. Your medical documents are forgeries. You haven't been to a single chemotherapy appointment. There is no cancer, Jennifer." Her defense crumbled. "Fine. I'm not sick. But the custody arrangement is better for the kids anyway. They need to be with their mother full-time." "So you faked dying of cancer to take the kids from me? Made Owen and Chloe believe they were losing their mother? They're better off with me. The fake cancer was just a way to make it happen faster than through traditional custody modification." Her complete lack of remorse was staggering. She'd terrorized our children with the belief they were about to lose their mother, alienated them from me during her supposed final months, and manipulated the entire court system with forged medical documents, all to gain full custody. I documented everything and immediately filed emergency motions with family court. Motion to vacate custody modification, requesting immediate return to shared custody since the modification was based on fraudulent medical information. Motion for contempt. Jennifer had committed fraud upon the court by submitting falsified medical documents. Motion for custody evaluation, requesting professional assessment of Jennifer's fitness given her willingness to fake terminal illness and psychologically harm the children. I also filed police reports for fraud, forgery of medical documents, and making false statements to the court. The family court judge was furious when I presented evidence of the fabricated cancer diagnosis. Ms. Jennifer filed emergency custody modification based on terminal illness that doesn't exist? She provided forged medical documents to this court. Emergency hearing was scheduled within 72 hours. Jennifer was ordered to appear and explain the fraudulent medical documentation. At the hearing, Jennifer attempted various excuses. I was confused about my diagnosis. I must have misunderstood the doctors. The judge wasn't buying it. You provided detailed oncology reports, treatment plans, and documentation of chemotherapy. This wasn't confusion. This was fabrication. Jennifer's attorney, who'd believed the cancer diagnosis was real, withdrew from representation. I cannot continue representing a client who's committed fraud on the court. Ms. Jennifer misrepresented material facts to me and used me to submit fraudulent documents. Medical experts testified that the documents Jennifer submitted were forgeries. Wrong formats, forged signatures, incorrect medical terminology. Dr. Brennan testified, "Someone used my name and credentials to create false cancer diagnosis documents. I never examined or treated Jennifer. This is medical fraud and identity theft of my professional credentials." The psychological impact on Owen and Chloe became clear through their statements to the court-appointed guardian ad litem. Owen: "Mom told us she was dying. I've been terrified for months. I stopped sleeping well because I was afraid she'd die during the night. Finding out she lied, I don't know how to feel." Chloe: "I've been saying goodbye to Mom in my head every day, trying to memorize everything about her before she died. I've been so sad. And it was all fake?" The family court's response was swift and severe. Jennifer faced immediate consequences across multiple legal fronts. The judge vacated the emergency custody modification immediately. This custody change was procured through fraud. The court relied on fabricated medical documentation. The modification is void. Custody was immediately returned to our previous arrangement, shared equally, alternating weeks. But the judge went further. Given Ms. Jennifer's demonstrated willingness to deceive this court, forge medical documents, and psychologically harm her children by faking terminal illness, I'm ordering immediate custody evaluation to determine if modification in the opposite direction is warranted. The custody evaluator met with everyone: me, Jennifer, Owen, Chloe, teachers, counselors, extended family. Her report was damning for Jennifer. Ms. Jennifer showed no remorse for faking terminal cancer diagnosis. She views the fraud as justified to achieve her desired custody outcome. She demonstrates willingness to cause severe psychological harm to her children, forcing them to prepare for her death when she was perfectly healthy, without appreciating the trauma inflicted. Ms. Jennifer's judgment regarding her children's well-being is severely impaired. The evaluator recommended I receive primary physical custody, with Jennifer having supervised visitation until she completed extensive psychological treatment. The children need protection from Ms. Jennifer's manipulative and psychologically abusive behavior. The court adopted the evaluator's recommendations. I received primary custody. Jennifer was granted supervised visitation only, 2 hours, twice weekly, with a court-appointed supervisor present. Criminal charges proceeded simultaneously. Jennifer was charged with fraud on the court, knowingly providing false information to obtain favorable custody ruling; forgery, creating fake medical documents using real doctors' names and credentials; child psychological abuse, deliberately causing emotional distress to Owen and Chloe by faking terminal illness; identity theft, using Dr. Brennan's professional credentials without authorization. The prosecutor emphasized the calculated nature. The defendant created elaborate fake medical documentation, shaved her head to simulate chemotherapy side effects, and maintained the deception for 8 months. This wasn't impulsive. This was systematic fraud to manipulate custody and deceive the court. Jennifer pled guilty to reduced charges, fraud and forgery, in exchange for the prosecution dropping child abuse and identity theft charges. She received 18 months in prison, 5 years probation, mandatory psychiatric treatment, and permanent restrictions on custody modifications. Owen and Chloe received trauma counseling to process the fake terminal illness and its psychological impact. Their therapist noted severe trust issues and anxiety. These children spent 8 months preparing for their mother's death. They experienced anticipatory grief, fear of abandonment, and traumatic stress. Learning it was fabricated creates additional trauma. They can't trust what their mother tells them anymore. Owen struggled most. How do I trust Mom ever again? She made me believe she was dying. I cried every night, planned what life would be like without her. And it was all lies to keep us away from Dad. Chloe had nightmares. I keep dreaming Mom really is sick. Then I wake up and remember she faked it. But what if something real happens and I don't believe it because she lied before? The therapeutic work focused on helping them understand the fake cancer wasn't their fault, rebuilding trust gradually, and processing the betrayal. Jennifer served 14 months of her sentence. Upon release, she entered the court-ordered psychiatric treatment program. Supervised visitation resumed, but both kids were hesitant. "We'll see Mom, but we don't want to be alone with her," Owen told the family therapist. "What if she lies again about something else?" Extended family was divided. Jennifer's sister, who'd supposedly supported her through treatment, admitted she'd known about the fraud. "Jennifer told me she was faking cancer to get full custody. I told her it was wrong, but I didn't report it. I thought she'd come to her senses." I cut contact with Jennifer's sister. "You knew she was terrorizing Owen and Chloe with a fake terminal diagnosis and said nothing? You're complicit in the abuse." My family rallied around the kids. "Your mother made a terrible choice. That doesn't mean she doesn't love you, but it means we need to protect you from her poor judgment." The broader community reacted with horror. She faked cancer? To manipulate custody? That's one of the most despicable things I've heard. Cancer advocacy groups condemned the fraud. Real cancer patients and families face genuine trauma. Faking terminal cancer diagnosis trivializes their suffering and exploits public sympathy for manipulation. Family law professionals used the case in ethics training. Always verify medical documentation in custody cases involving health issues. This case shows how thoroughly someone may fabricate illness to gain custody advantage. Do I forgive Jennifer? No. She terrorized our children with fake terminal illness, alienated them from me, and committed fraud on the court, all to gain full custody. Can our co-parenting relationship recover? Unlikely. Trust is permanently damaged. All communication goes through supervised exchange and court-approved platforms. Owen and Chloe are healing slowly. Living primarily with me, seeing Jennifer in supervised settings, rebuilding normalcy after 8 months of believing they were losing their mother. Some betrayals involve faking terminal illness. Jennifer's was one of them. She served time, lost custody, destroyed trust with her children, all for a custody advantage procured through cancer fraud. Owen and Chloe know their mother isn't dying, but they also know she lied about dying. That knowledge carries its own trauma. We're working through it. Therapy, stability, honest communication. Everything Jennifer's fake cancer denied them. She's out of prison now. Supervised visits, psychiatric treatment, slow rebuilding if the kids choose. But the damage remains. You can't fake dying without consequences. Jennifer learned that. Owen and Chloe suffered it. I'm helping them heal from it. That's where we are. Not where we should be, but where Jennifer's cancer fraud left us. Moving forward, one honest day at a time. No more fake diagnoses, no more lies, just truth. However painful, however inadequate, just truth. That's all we have left. That's all we can rebuild on. Jennifer's fake cancer killed something anyway. Trust, innocence, family unity. Some things die even when the cancer is fake. We're learning to live with those losses. Real losses from fake illness. That's Jennifer's legacy. That's our reality. Enough said. Adult daughter had been impersonating me online to destroy professional reputation. I discovered my adult daughter had been impersonating me on professional social media and academic forums for 18 months, posting inflammatory content and making offensive statements to destroy my reputation and force me to retire early from my university position. I'm 51 years old, tenured professor of sociology at a respected university where I've taught for 23 years. I've built a solid academic reputation through published research, conference presentations, and thoughtful contributions to scholarly discourse. My daughter Veronica is 27, recently graduated with a master's degree in communications, and has been struggling to find stable employment in her field for the past 2 years. 18 months ago, I started receiving complaints from colleagues about inflammatory posts I'd supposedly made on academic Twitter and LinkedIn. People would reference statements I had no memory of making, controversial opinions on sensitive topics, dismissive responses to other scholars' work, and aggressive arguments in comment sections. "I saw your thread about tenure reform yesterday," a colleague mentioned. "Pretty harsh criticism of junior faculty, not like you at all." "I didn't post anything about tenure reform. I haven't been active on Twitter this week." "It was definitely your account, your profile picture, your bio, your handle. You called untenured professors entitled and said they should stop complaining about workload." I checked my Twitter account. No such posts appeared in my timeline. Someone must have hacked my account and deleted the posts. But the incidents continued. Colleagues would reference posts, comments, and forum discussions I'd never made. Each time I'd check my accounts, finding nothing. I changed all my passwords, enabled two-factor authentication, and contacted platform support. But the mysterious posts persisted according to others, even though they never appeared when I logged in. My department chair called me in. "We've received multiple complaints about your online behavior. Faculty from other institutions are saying you're making offensive comments on academic forums, dismissing diversity initiatives, and attacking scholars who disagree with you." "I'm not making these posts. Someone must be impersonating me." "Your colleagues are seeing posts from accounts with your name, your photo, your institutional affiliation. If someone's impersonating you, they're doing it convincingly enough that respected academics believe it's you." My professional reputation started suffering. Invitations to speak at conferences were rescinded. Collaborative research projects fell apart as colleagues distanced themselves. Graduate students requested different dissertation advisors. The dean suggested I consider taking a leave to address these concerns. I hired a digital forensics expert to investigate. Within a week, discovered the truth. Someone had created duplicate accounts on Twitter, LinkedIn, ResearchGate, and various academic forums using slight variations of my username that looked identical at casual glance. These fake accounts had my photo, my bio, my institutional affiliation, everything copied from my real profiles. The impersonator would wait until I posted something, then immediately post inflammatory follow-ups from the fake accounts, making it appear I was having controversial exchanges with myself or making offensive statements. "Whoever's doing this has intimate knowledge of your field, your research interests, and your professional network," the forensics expert explained. "They're creating posts sophisticated enough to sound like they could come from you, but with inflammatory content that damages your reputation." The fake accounts were registered to an email address that traced back to Veronica's IP address. My own daughter had been impersonating me online for 18 months, systematically destroying my professional reputation. When I confronted Veronica with the evidence, she didn't deny it. "You have the tenure and reputation I'll never achieve. You got lucky, hired before the job market crashed. Now people like me can't even get adjunct positions while you have job security and academic standing. I wanted to level the playing field." She'd been sabotaging my career out of jealousy and resentment, creating fake professional personas to make me appear unstable, offensive, and unfit for academic work. Hoping I'd be forced to resign or retire, somehow creating opportunity for her own failed academic aspirations. The full extent of Veronica's impersonation campaign became clear through the digital forensics investigation and her own admission once confronted. She'd been systematically destroying my professional reputation across multiple platforms for 18 months, and the damage was extensive. The forensics expert compiled a comprehensive report. Fake accounts created. Veronica had created duplicate accounts on Twitter, @Prof. Sarah Morris versus my real @Prof_Sarah Morris. LinkedIn, Sarah Morris PhD versus my Sarah Morris PhD. ResearchGate, academia.edu, and 12 different academic forums where scholars in my field engage in professional discourse. Content strategy. Veronica would monitor my real accounts, wait for me to post legitimate academic content, then immediately post inflammatory responses from the fake accounts. To other users, it appeared I was making normal posts, then following up with offensive statements. She'd also initiate controversial threads from fake accounts, creating appearance I was starting fights with other scholars. Sophisticated mimicry. The posts were academically credible enough to fool experts in my field. Veronica had used her communications training and knowledge of my research to create content that sounded like my voice, but with inflammatory, career-damaging elements added. Timeline correlation. The fake account activity started 18 months ago, exactly when Veronica had been rejected for a tenure-track position she'd applied for at another university. Her resentment about her own failed academic career had motivated the impersonation campaign. Examples of damaging posts Veronica made while impersonating me. On diversity initiatives. Diversity hiring is just lowering standards to meet quotas. Merit should be the only consideration. Posted from fake account minutes after I'd shared an article supporting inclusive hiring practices from my real account. On junior faculty. Untenured professors complaining about workload should try working a real job. Academic entitlement is destroying the profession. Made colleagues think I was dismissive of legitimate labor concerns. On student mental health. Students claiming anxiety just want special treatment. Previous generations handled stress without accommodations. Directly contradicted my actual advocacy for student mental health support. On colleagues' research. Veronica had posted harsh criticisms of other scholars' work from the fake accounts, creating appearance I was attacking peers in my field. This research is derivative and poorly argued. Surprised it got published. Targeting articles by people I'd previously collaborated with. Each post was designed to alienate different professional constituencies, making me appear anti-diversity to progressive colleagues, anti-labor to junior faculty, insensitive to student advocates, and hostile to collaborators. Text messages between Veronica and a friend revealed her motivations and awareness of the harm. Veronica posted another inflammatory comment from Mom's fake account. People are starting to think she's lost it professionally. Friend, don't you feel bad destroying your mom's reputation? Veronica, she has what I worked for and couldn't get: tenure, respect, publications. If her reputation is destroyed, maybe she'll retire early and I can use her professional network. Friend, that's not how it works. Her retiring doesn't give you her job. Veronica, no, but if she's discredited, she can't gatekeep the field anymore. She won't be reviewing job applications, sitting on hiring committees, influencing who gets positions. Maybe someone like me will have a chance. She'd believed that destroying my reputation would somehow create academic opportunities for her. A fundamentally flawed logic that demonstrated both her resentment and her misunderstanding of how academic hiring works. More messages showed she'd been escalating the campaign. Veronica, Mom's department is getting complaints. Her chair called her in. The plan is working. Friend, what's your end game? What happens when she loses her job? Veronica, she retires in disgrace. Her professional legacy is ruined. She experiences the career failure I've been living with. Fair outcome. I documented everything and consulted with attorneys specializing in defamation, identity theft, and cybercrime. The legal assessment was clear. Veronica had committed multiple serious crimes. Your daughter engaged in identity theft, created fraudulent accounts impersonating you, posted defamatory content intended to damage your professional reputation, and caused measurable harm to your career. This is criminal. I also reported to university administration with full evidence. The dean was horrified. Your daughter has been systematically impersonating you online for 18 months? Creating fake accounts to post offensive content under your name? This explains all the complaints. The university's legal team got involved, concerned about institutional reputation and liability. They identified specific damages. 3 rescinded speaking invitations worth $15,000 in honoraria, 2 terminated collaborative research projects, 5 graduate students who'd requested different advisors, and measurable decline in my professional standing within the field. The legal consequences for Veronica proceeded on both criminal and civil fronts. The evidence was overwhelming, and the damage to my career was documented extensively. Criminal charges: identity theft, creating fake accounts using my name, photo, and professional credentials without authorization. Cyber harassment, systematically posting inflammatory content designed to harm my reputation over 18 months. Defamation, making false statements while impersonating me that damaged my professional standing. Wire fraud, using electronic communications to perpetrate fraud, impersonation scheme. Computer fraud, unauthorized creation of accounts using my identity. The prosecutor emphasized the calculated nature. The defendant spent 18 months systematically impersonating her mother online, creating sophisticated fake accounts on professional platforms. She posted inflammatory content designed to destroy her mother's academic reputation, motivated by jealousy of her mother's tenured position. The campaign caused measurable professional harm, lost speaking opportunities, terminated collaborations, damaged relationships with colleagues. Digital forensics experts testified. We traced all fake accounts to the defendant's IP address and devices. The accounts were created deliberately to impersonate the victim, using slight username variations that appeared identical at casual glance. The content strategy was sophisticated, waiting for victims' real posts, then adding inflammatory follow-ups, creating appearance the victim was making controversial statements. Academic colleagues testified about the professional damage. I rescinded a conference speaking invitation after seeing what I believed were offensive posts from Professor Morris's account. Learning those were fake posts from her daughter's impersonation accounts is shocking. Her professional reputation was seriously damaged by this fraud. The university's testimony documented measurable harm. Lost research collaborations worth hundreds of thousands in grant funding, students requesting different advisors, declined invitations, and reputational damage within the field. Platform representatives from Twitter and LinkedIn testified, "The defendant violated our terms of service by creating fraudulent accounts impersonating another user. We've removed all fake accounts and are cooperating with law enforcement." Veronica's text messages showed premeditation and malicious intent. Mom has what I worked for and couldn't get: tenure, respect, publications. If her reputation is destroyed, maybe she'll retire early. She experiences the career failure I've been living with. Fair outcome. Her defense attempted to frame it as frustrated commentary rather than impersonation. My client was expressing frustration about academic hiring through online posts. She didn't mean to damage her mother's reputation. The prosecutor destroyed this. The defendant created elaborate fake accounts specifically designed to look like her mother's real accounts. She posted inflammatory content timed to appear as follow-ups to her mother's real posts. Text messages show she intended to destroy her mother's reputation and force early retirement. This was systematic identity theft and defamation, not frustrated commentary. The jury convicted on all counts. Veronica received 3 years in prison for identity theft and cyber harassment, probation, restitution for my lost professional opportunities, and mandatory technology restrictions. Civil lawsuit resulted in additional damages for defamation and tortious interference with professional relationships. All fake accounts were permanently deleted. I worked with platforms to verify my real accounts and prevent future impersonation. The university issued statement clarifying the impersonation and restoring my professional standing. Professor Morris was victim of sophisticated identity theft by family member who created fake accounts to post inflammatory content. The offensive posts were not made by Professor Morris. Her professional standing is fully restored. Colleagues who distanced themselves apologized. "We thought those posts were really from you. Learning your daughter impersonated you to destroy your reputation, we're so sorry we believed it." Speaking invitations were reissued. Research collaborations resumed. Graduate students returned to my advising. Professional reputation is being rebuilt, though 18 months of damage takes time to fully repair. Veronica's relationship with me is permanently destroyed. "You tried to ruin my career out of jealousy, impersonated me for 18 months, posted offensive content in my name. That's unforgivable." Extended family struggles. Veronica sabotaged your academic reputation for 18 months because she couldn't get a tenure-track job? That's pathological jealousy. Academic. Communities used the case to highlight impersonation risks. Verify unusual posts before assuming they're genuine. Sophisticated impersonation can fool even close colleagues. Cybersecurity experts. Check for fake accounts impersonating you. Search your name on platforms where you have presence. Report impersonation immediately. Do I forgive Veronica? No. She systematically destroyed my professional reputation over 18 months out of resentment. Can our relationship recover? No. She proved she'd rather destroy my career than accept her own path differs from mine. Veronica's in prison. Fake accounts deleted. Professional reputation rebuilding. Career recovering from her sabotage. Some betrayals involve impersonation. Veronica's was one of them. She wanted my academic standing destroyed. Got prison instead. I wanted professional respect. Lost it temporarily. Reclaiming it now. 3 years she'll serve. 18 months she impersonated me. 23 years I've built my career, nearly destroyed by jealous daughter. Numbers that tell the story. Prison time that equals consequences. Years I'm recovering. Professional standing restored. Reputation healing. Veronica imprisoned for identity theft. Everything she tried to destroy. Everything I'm rebuilding. That's enough. That's justice. That's where we are. Despite her impersonation, beyond her sabotage, without her now. Teaching again, publishing again, respected again. Everything she couldn't take permanently. Everything surviving her attack. She impersonated me. Courts identified her. Justice imprisoned her. Fair ending. Just consequence. Appropriate outcome. Living authentically. Working genuinely. Being myself, not her fake version. That's victory. That's recovery. That's enough. Brother-in-law was secretly switching prescription medications to cause organ failure. I discovered my brother-in-law had been systematically replacing my blood pressure and heart medications with look-alike pills for 9 months, causing progressive heart damage he planned to present as natural disease progression, requiring me to move in with him and my sister. I'm 48 years old, divorced father of 2 adult children who live independently. I have hypertension and a heart condition that require daily medication to manage. Conditions I've controlled successfully for over a decade with proper treatment. I take 4 different medications twice daily: blood pressure medication, beta blocker, cholesterol medication, and a mild diuretic. My cardiologist monitors me regularly, and my conditions have been stable for years with excellent medication compliance. I live alone in my own house, work full-time as a middle school teacher, and maintain an active, independent life. My sister Ellen and her husband Craig live about 20 minutes away. Craig is a pharmaceutical sales representative. He has extensive knowledge of medications, how they work, and access to pharmaceutical samples through his job. Ellen and Craig have been hinting for the past year that I should move in with them. You're living alone with heart problems. What if something happens when no one's around? You should live with family who can monitor your health. I'm managing my conditions perfectly well. My doctor says my heart health is stable. I don't need to give up my independence. Craig was particularly insistent. Heart conditions can deteriorate suddenly. You're in denial about needing help. Eventually, you'll have a cardiac event that forces you to accept assistance. 9 months ago, my heart health started mysteriously declining. My blood pressure readings at doctor visits were dangerously high despite taking my medications faithfully. My cardiologist was confused. Your blood pressure should be controlled on these medications. Are you sure you're taking them as prescribed? Every day, twice a day, exactly as directed. I've never missed doses. Let's increase your dosage and see if we can get better control. The dosage increases didn't help. My blood pressure remained dangerously elevated. Then I started experiencing other symptoms: irregular heartbeat, chest pain, dizziness, extreme fatigue. My cardiologist ran extensive tests and delivered troubling news. Your heart function has declined significantly in the past 9 months. The left ventricle isn't pumping efficiently. You're developing heart failure. How is that possible? My heart was stable for 10 years. Now suddenly it's failing despite medication. Sometimes heart disease progresses despite optimal treatment. We'll need to adjust your medication regimen and monitor you closely. You may need to consider lifestyle changes. Possibly can't live alone anymore if heart function continues declining. Craig heard about my diagnosis through Ellen and immediately renewed his push for me to move in with them. See? Your heart is getting worse. You can't live alone with advancing heart failure. Move in with us, where Ellen can monitor you and I can manage your medications. I work in pharmaceuticals. I understand how all this works. I can manage my own medications. I've been doing it for a decade. Clearly not well enough if your heart is failing despite treatment. You need professional oversight. My heart function continued declining over the following months. More chest pain, more irregular rhythms, more alarming test results. My cardiologist started discussing heart transplant evaluation. If your function continues declining at this rate, you may need to be listed for transplant. I was terrified. How had I gone from stable heart patient to potential transplant candidate in less than a year? Last month, I was reorganizing my bathroom cabinet and dropped my medication bottles. As I picked them up, I noticed something odd about my blood pressure medication pills. They looked slightly different from the ones I remembered. Same size and shape, but the color seemed marginally off, and the texture wasn't quite right. I took one pill to my pharmacist. Does this look right to you? It's supposed to be my blood pressure medication. The pharmacist examined it carefully. This isn't your blood pressure medication. This looks like... I'm not sure what this is. Let me test it. The test results were shocking. My blood pressure medication was actually a sugar pill, a placebo with no active pharmaceutical ingredients. Someone had replaced my actual medication with fake pills. The discovery that my blood pressure medication had been replaced with placebos led to immediate testing of my other medications. The results revealed the full scope of the sabotage. Blood pressure medication, lisinopril, replaced with sugar pills containing no active ingredients. I'd been taking these twice daily for 9 months without receiving any actual blood pressure treatment. Beta blocker, metoprolol, replaced with pills containing a stimulant compound that actually increased heart rate and blood pressure, the opposite of what the medication should do. Cholesterol medication, atorvastatin, replaced with placebos. No cholesterol control for 9 months. Diuretic, hydrochlorothiazide, replaced with salt tablets that actually increased fluid retention. Again, opposite of intended effect. Someone had systematically replaced all 4 of my cardiac medications with either placebos or substances that worsened my conditions. No wonder my heart health had declined so dramatically. I hadn't been receiving treatment for 9 months, and some replacement pills actively harmed me. I contacted my cardiologist immediately with this information. She was horrified. "You've been taking fake medications? No actual blood pressure control for 9 months? That explains everything. The uncontrolled hypertension, the declining heart function, all of it. You weren't being treated while your conditions progressed unchecked. Can the heart damage be reversed?" "Some of it, yes. If we get you back on actual medications immediately, your blood pressure will stabilize and heart function should improve. But 9 months without treatment has caused damage that may be permanent." "Who had access to replace your medications?" The only person with both pharmaceutical knowledge to identify look-alike pills and regular access to my home was Craig. He had a key to my house. I'd given it to Ellen years ago for emergencies, and Craig obviously had access to it. He visited occasionally to check on me, times when he could have accessed my bathroom cabinet and switched my medications. I installed hidden cameras throughout my house, particularly focused on areas where I stored medications. Within a week, the cameras captured Craig entering my home using Ellen's key while I was at work. He went directly to my bathroom, removed my medication bottles from the cabinet, and replaced pills with lookalikes he'd brought with him in a pharmacy bag. The video showed him carefully counting pills to ensure bottles appeared full, then disposing of my actual medications in his pocket to remove them from the house. He'd been doing this systematically. Every few weeks, he'd replace a week's worth of medications with fakes, ensuring I never received proper treatment. Text messages between Craig and someone named RT revealed the conspiracy. Craig replaced his blood pressure meds again today. Used the sugar pills that look identical. He'll never notice the difference. RT: how much longer until his heart fails completely? Craig: cardiologist says he's developing heart failure. Another few months without real medication, and he'll be too sick to live alone. Then he'll have to move in with us. RT: what if they figure out his medications were replaced? Craig: they won't. Everyone thinks his heart disease is just progressing naturally. No one suspects medication tampering. I'm a pharmaceutical rep. I know exactly which fake pills look enough like real ones to fool him. RT was identified as Rachel Torres, Craig's co-worker at the pharmaceutical company and his mistress. They'd been having an affair for over a year, and text messages showed they'd planned to move in together once I was living with Ellen. More messages revealed their reasoning. Rachel: when does he move in with you and Ellen? Craig: once his heart gets bad enough that he can't live alone. Shouldn't be much longer. 9 months without real blood pressure medication is causing significant damage. Rachel: then you move in with me? Craig: exactly. I'll tell Ellen I need to take a job in another city. You and I can be together, and Ellen will be too busy caring for her brother to question it. They'd planned to destroy my heart health through medication sabotage, force me to move in with Ellen, then use my presence as excuse for Craig to relocate for work and move in with Rachel. I was being medically sabotaged so Craig could abandon my sister and be with his mistress without suspicion. I gathered all evidence: hidden camera footage of Craig replacing medications, the fake pills analyzed by pharmacists showing no active ingredients or wrong compounds, text messages discussing the medication tampering and heart failure plan, medical records showing my sudden decline starting exactly when the sabotage began, and expert testimony about how medication replacement would cause my symptoms. I reported everything to police, filing charges for attempted murder, medication tampering causing organ damage, assault, pharmaceutical fraud, and conspiracy. The criminal prosecution moved quickly, given the video evidence and clear documentation of systematic medication tampering designed to cause heart failure. Craig was charged with attempted murder, deliberately replacing life-sustaining medications with placebos or harmful substitutes, knowing this would cause serious heart damage or death. Aggravated assault, causing severe bodily harm through medication tampering over 9 months. Pharmaceutical fraud, illegally obtaining and distributing prescription medications and substitutes. Burglary, repeatedly entering my home without permission to commit medication tampering. Rachel was charged as co-conspirator based on text messages showing she knew about the medication tampering, encouraged it, and planned to benefit from the resulting living arrangement changes. The prosecutor emphasized the calculated nature. The defendant used his pharmaceutical knowledge to systematically replace the victim's cardiac medications with placebos or harmful substitutes. He did this for 9 months, causing progressive heart damage that nearly required transplant. His motive was forcing the victim to move in with the defendant's wife, allowing the defendant to then abandon his wife and move in with his mistress. Cardiologists testified about the medical damage. The victim went from stable cardiac patient to heart failure candidate in 9 months. This decline was caused by lack of actual medication. His blood pressure went uncontrolled, his heart rate was poorly managed, and his cholesterol rose unchecked. Additionally, some replacement pills contained substances that worsened his conditions. 9 months of this created significant heart damage. Pharmacologists testified. The defendant replaced medications with look-alike pills that contained either no active ingredients or wrong substances. Blood pressure medication replaced with sugar pills. Beta blocker replaced with stimulants that increased heart rate. Diuretic replaced with salt tablets. This wasn't random. This was calculated to cause maximum cardiac harm. The hidden camera footage showed Craig entering my home, accessing my medication cabinet, and systematically replacing pills. The jury watched him carefully counting bottles, swapping medications, and disposing of my actual pills. Pharmaceutical experts testified. As a pharmaceutical sales representative, the defendant had knowledge of medication appearances, access to samples and lookalikes, and understanding of which substitutions would cause most harm while avoiding immediate detection. My testimony described the terror. I went from healthy, stable cardiac patient to heart failure candidate in less than a year. I thought my heart disease was progressing despite optimal treatment. Learning my brother-in-law was deliberately replacing my medications, causing the very heart failure he kept saying proved I needed to live with him, was devastating. Text messages between Craig and Rachel showed planning and awareness. 9 months without real blood pressure medication is causing significant damage. Once his heart gets bad enough that he can't live alone, I'll tell Ellen I need to relocate for work. You and I can be together, and Ellen will be too busy caring for her brother to question it. Ellen testified against Craig. My husband destroyed my brother's heart health to create an excuse to abandon me and be with his mistress. He was going to saddle me with caring for a heart failure patient he deliberately created, then leave me to be with another woman. The fake medications were analyzed and presented. Sugar pills replacing blood pressure medication, stimulant compounds replacing beta blockers, salt tablets replacing diuretics, all calculated to worsen cardiac conditions. Craig's defense attempted to argue he was trying to wean me off medications. My client believed the victim was over-medicated and tried to gradually reduce dosages. The prosecutor destroyed this. The defendant completely replaced medications with placebos and harmful substitutes. He didn't reduce dosages. He eliminated treatment entirely and added substances that worsened conditions. Text messages show he knew he was causing heart damage and planned for it. Medical experts testified, there's no legitimate medical reason to replace prescribed cardiac medications with placebos. This was sabotage, not treatment modification. The jury convicted Craig on all counts. He received 15 years in prison for attempted murder through medication tampering. Rachel received 5 years as co-conspirator. Ellen divorced Craig immediately, providing testimony against him that secured his conviction. I was placed on actual medications immediately after discovering the tampering. My cardiologist monitored me closely. Your heart function is already improving. Blood pressure is controlled, irregular rhythms resolving. You should recover most of the lost function over the next year. Some damage is permanent, but you're not going to need a transplant. Extended family was horrified. Craig replaced your heart medications? Caused heart failure? So he could abandon Ellen and be with his mistress? That's evil. Pharmaceutical industry instituted new controls. This case shows how pharmaceutical knowledge can be weaponized. We're implementing better tracking of samples and look-alike medications. Medical safety advocates used the case. Always verify medications look correct. Report any changes in appearance. Medication tampering can cause serious harm or death. Do I forgive Craig? Never. He deliberately destroyed my heart health for 9 months to facilitate abandoning my sister. Can I trust medications again? That's harder. I now get prescriptions filled at pharmacy, verify appearance with pharmacist every time, and store them in locked container only I can access. Ellen and I are rebuilding our relationship after she testified against Craig. She had no knowledge of his medication tampering scheme. Craig's in prison. Rachel's serving time. I'm recovering. Heart function improving. Medications verified and effective. Life returning to normal. Some betrayals involve medical sabotage. Craig's was one of them. He wanted to destroy my heart to abandon my sister. Got prison instead. I wanted stable heart health. Lost it for 9 months. Recovering it now. 15 years he'll serve. 9 months he sabotaged my medications. 48 years I've lived. Nearly lost my life to his scheme. Numbers that tell the story. Prison time that equals justice. Years I'm reclaiming. Living with verified medications. Healing heart damage. Rebuilding trust. Everything he tried to destroy. Everything I'm recovering. That's enough. That's victory. That's justice. Despite him, beyond him, without him. Heart healing. Medications verified. Craig imprisoned. Perfect ending to his failed sabotage plot. He replaced medications. Courts replaced his freedom. Fair trade. Living well. Loving verified pills. Learning to feel safe. Everything he tried to take. Everything surviving anyway. That's where we are. Where his choices led. Where justice brought us. Some brothers-in-law help family. Craig tried to kill me. He's paying for it. I'm recovering from it. Fair, just, appropriate. That's enough. Spouse was secretly feeding me allergens to induce anaphylaxis and claim life insurance. I discovered my wife had been deliberately exposing me to severe allergens for 6 months, inducing increasingly dangerous allergic reactions to eventually trigger fatal anaphylaxis she could claim was accidental. I'm 52 years old, married for 18 years to my wife Linda, who is 49. We have no children, a mutual decision we made early in our marriage. I have severe, well-documented allergies to shellfish and tree nuts that can cause anaphylactic shock, potentially fatal allergic reactions requiring immediate epinephrine injection and emergency medical care. I've lived with these allergies my entire adult life, managing them carefully through strict dietary avoidance and always carrying an EpiPen. Linda has known about my allergies since we first started dating. For 18 years, she's been careful about food preparation, checking ingredient labels, and ensuring cross-contamination didn't occur in our kitchen. My allergies were never an issue in our marriage, just a medical reality we both managed responsibly. 6 months ago, I started experiencing allergic reactions with increasing frequency. Minor reactions at first, mild throat swelling, hives, slight breathing difficulty. Each time, I'd use my EpiPen if symptoms progressed, then go to the emergency room for monitoring. The ER doctors would treat me, run tests, and confirm I'd been exposed to either shellfish protein or tree nut compounds. Have you been eating anything different? New restaurants? Changed products? The allergist asked after my 3rd ER visit in 2 months. No, I'm extremely careful about what I eat. I always check ingredients. I don't understand how I keep getting exposed. The reactions are becoming more severe each time. The most recent one was nearly full anaphylaxis. We need to identify the exposure source before you have a fatal reaction. I became hyper-vigilant about everything I ate, checked every label multiple times, avoided restaurants entirely, only ate food I'd personally prepared from verified safe ingredients. Yet the reactions continued. Linda seemed supportive and concerned. She'd drive me to the ER during reactions, stay with me through treatment, and help me try to identify what might be causing the exposures. Maybe you're developing new allergies, or cross-reactivity with something you used to tolerate. The reactions kept intensifying. What started as mild symptoms progressed to severe throat swelling, breathing difficulty requiring oxygen, and blood pressure crashes. Each ER visit became more serious. Doctors warned me, if you can't identify and eliminate the allergen source, the next reaction could be fatal. 2 weeks ago, I had the worst reaction yet, full anaphylactic shock requiring multiple doses of epinephrine, intubation, and 3 days in ICU. I nearly died. The allergist reviewing my case was baffled. You're describing near-perfect allergen avoidance, yet you're having the worst reactions of your life. Something's very wrong here. After discharge, I became paranoid about food, started preparing everything myself, using only ingredients I'd purchased personally and verified safe. For 5 days, I had no reactions. Then, Linda made dinner one night. A simple pasta dish with marinara sauce she'd made from scratch, using ingredients I'd verified safe myself. Within 30 minutes of eating, my throat started swelling. I recognized the onset of allergic reaction and reached for my EpiPen. As I injected the epinephrine, I noticed Linda's expression. She wasn't concerned or panicked like she'd been during previous reactions. She looked disappointed. The EpiPen stopped the reaction before it progressed to full anaphylaxis. I didn't need ER visit this time. But Linda's reaction bothered me. Why had she looked disappointed that the epinephrine worked? I secretly installed cameras in our kitchen the next day. The footage I captured 3 days later was horrifying. Linda preparing my lunch, taking a jar from a high cabinet I never accessed, and adding something to my food. The jar was labeled walnut extract. Linda had been deliberately adding allergens to my food for 6 months, causing the escalating allergic reactions that had nearly killed me. She was poisoning me with the very substances she knew could trigger fatal anaphylaxis. The discovery that Linda had been systematically poisoning me with allergens I'm deathly allergic to required careful evidence gathering before I could confront her or involve authorities. I needed to understand the full scope of what she'd been doing and why. I continued acting normally while collecting evidence through hidden cameras and investigating Linda's activities. Over the next week, I documented systematic allergen exposure. Linda had been adding small amounts of walnut extract and shellfish powder to my food approximately twice per week for 6 months. She'd start with tiny amounts that caused mild reactions, gradually increasing the doses to intensify symptoms. The escalation explained why my reactions had progressed from minor to near fatal over time. Source of allergens. The walnut extract and shellfish powder were stored in our kitchen's high cabinet in containers labeled as harmless cooking ingredients. Linda had created her own allergen supply specifically for poisoning me, grinding walnuts into fine powder and reducing shellfish into concentrated form that could be easily added to food without detection. Dosage calculation. Notes on Linda's laptop showed she'd researched allergen dosages extensively. She'd calculated how much to add to my food to cause reactions severe enough to require ER visits, but not immediately fatal, building toward a final, accidental fatal dose that would appear to be natural progression of my allergy severity. Life insurance. I discovered Linda had taken out a $2 million life insurance policy on me 3 months before the poisoning began. The policy had a 2-year contestability period, meaning if I died within 2 years of policy issue, the insurance company would investigate thoroughly. Linda's plan appeared to be triggering fatal anaphylaxis after the contestability period ended, making it appear I'd accidentally consumed allergens and died from my documented severe allergies. Timeline strategy. Documents showed Linda planned to continue inducing increasingly severe reactions for another 18 months, until the life insurance contestability period ended. Then, she'd administer a fatal dose. I'd die from anaphylactic shock, and it would appear accidental, given my documented history of escalating allergic reactions. Text messages between Linda and someone named DM revealed additional shocking information. Linda: gave him another dose of walnut extract today. Reaction wasn't as severe as I hoped. He used EpiPen before it got serious. DM: you need to be patient. Can't rush this or it will look suspicious. Linda: I know. Building the pattern of escalating reactions takes time. Just frustrated it's not happening faster. DM: the life insurance contestability period ends in 16 months. Keep giving him small exposures until then. Document all the ER visits. Then the final dose won't be questioned. Linda: what if he figures it out before then? DM: he won't. Everyone thinks his allergies are just getting worse with age. Natural progression. No one suspects you're causing it. DM was identified through further investigation as David Martinez, Linda's co-worker with whom she'd been having an affair for over a year. They'd planned my murder together, using my documented severe allergies as the weapon. More messages showed they'd researched how to induce fatal anaphylaxis. DM: you need to give him enough allergen that even the EpiPen won't stop the reaction. That's when it becomes fatal. Linda: how much is that? DM: based on his weight and severity of documented reactions, probably 3 to 4 times the amount you've been giving him. But don't do that until after contestability period. Need the insurance company to not investigate. Linda: so, 16 more months of small doses, then the big one? DM: exactly. He dies from what looks like accidental allergen exposure. You collect $2 million. We can be together without divorce complications. They'd planned my death in detail, calculating dosages, timing the fatal exposure to avoid insurance investigation, and viewing my severe allergies as convenient murder weapon that would make my death appear accidental. I gathered all evidence: hidden camera footage of Linda adding allergens to my food, the walnut extract and shellfish powder containers from the high cabinet, text messages planning my murder, life insurance policy documents, and my medical records showing the escalating reactions that matched Linda's poisoning timeline. I consulted with an attorney who specialized in attempted murder cases. The attorney was horrified. Your wife has been systematically poisoning you with substances she knows can kill you. She's documented your escalating reactions through repeated ER visits. She and her lover have planned to eventually administer a fatal dose. This is premeditated attempted murder. Can she actually be prosecuted? It's hard to prove she added allergens to my food. You have video evidence of her adding walnut extract to your food. You have text messages where she and her lover discuss the poisoning plan in detail. You have the allergen containers hidden in your kitchen. You have the insurance policy taken out before the poisoning began. The evidence is overwhelming. The criminal case against Linda and David proceeded on charges of attempted murder, conspiracy to commit murder, poisoning, assault, and insurance fraud, planning to fraudulently collect insurance proceeds from a murder they committed. Linda was charged with attempted murder, systematically poisoning me with allergens she knew could cause fatal anaphylaxis, with intent to eventually administer fatal dose. Aggravated assault, repeatedly causing severe allergic reactions requiring emergency medical treatment. Poisoning, deliberately adding toxic substances, allergens I'm severely allergic to my food without my knowledge. Insurance fraud, taking out life insurance policy before beginning poisoning, planning to collect proceeds after murdering me. David was charged as co-conspirator on all counts based on text messages showing he planned the murder with Linda, researched dosages, and intended to benefit from the insurance proceeds. The prosecutor's opening statement was damning. The defendants spent 6 months systematically poisoning the victim with allergens they knew could kill him. They documented his escalating reactions through repeated ER visits, building a pattern that would make his eventual murder look like accidental allergen exposure. They planned to administer a fatal dose after the life insurance contestability period ended, making the death appear natural while collecting $2 million. Medical experts testified about the poisoning progression. The victim experienced escalating allergic reactions over 6 months, from mild symptoms to full anaphylactic shock requiring ICU admission. This progression wasn't natural disease course. It was induced through increasing allergen exposure. The final reaction nearly killed him. Allergists testified. Shellfish and tree nut allergies don't typically worsen this dramatically in adulthood without increased exposure. The victim's escalating reactions were consistent with increasing allergen doses, not natural allergy progression. The hidden camera footage was played in court, showing Linda deliberately adding walnut extract from a hidden jar to my food while I was out of the room. The jury watched her carefully measure amounts, stir it into my meal, then serve it to me with no indication anything was wrong. Toxicology testing of the walnut extract and shellfish powder confirmed. These substances contain concentrated allergen proteins at levels that would trigger severe reactions in someone with documented allergies. They're not cooking ingredients. They're poison to someone with these allergies. My testimony described the terror. I thought my allergies were naturally worsening. I became hypervigilant about food, avoided everything risky, and still kept having reactions. I nearly died in ICU from anaphylactic shock. Learning my wife was deliberately poisoning me, using my allergies as a murder weapon, was devastating. Text messages between Linda and David were read in court, showing detailed planning. Give him small exposures until contestability period ends, then the final dose. He dies from what looks like accidental allergen exposure. You collect $2 million. Calculate dosage that even EpiPen won't stop. The insurance policy was presented. $2 million policy taken out 3 months before poisoning began, naming Linda as sole beneficiary. Insurance fraud investigators testified, the timing is significant. Policy obtained, contestability period noted, poisoning began immediately after. This was planned insurance fraud through murder. Linda's defense attempted to argue the allergen additions were accidental. My client may have accidentally cross-contaminated food with allergens without realizing. The prosecutor destroyed this. The defendant stored concentrated allergen extracts in hidden containers. Text messages discuss giving him doses and planning the final dose. Video shows deliberate addition to food. This wasn't accidental. This was attempted murder. David's defense claimed he was just having an affair and wasn't actually involved in murder planning. Text messages show he discussed the situation with Linda but didn't actively participate. Evidence showed David researched fatal allergen dosages, calculated timing, and planned to benefit from insurance proceeds. The jury convicted him as full co-conspirator. Both were convicted on all counts. Linda received 25 years in prison for attempted murder and insurance fraud. David received 20 years as co-conspirator. Both faced restitution for medical costs and permanent restraining orders. I divorced Linda while she awaited sentencing. The divorce was uncontested. She had no defense after criminal conviction. Extended family struggled to comprehend. Linda poisoned you? With allergens she knew could kill you? For life insurance? That's monstrous. Allergy advocacy groups used the case to highlight severe allergies can be weaponized. This case shows how documented medical conditions can be exploited for murder that appears accidental. Life insurance investigators implemented new protocols. Large policies followed by escalating medical emergencies. Merit investigation. even before contestability period ends. Do I forgive Linda? Never. She spent 6 months poisoning me, nearly killed me, and planned my murder. Can I trust food again? That's harder. Therapy helps. Living alone means I control everything I eat. Dating? Not yet. Trust is shattered. The person who should have protected me from allergen exposure was deliberately exposing me. Linda's in prison. David, too. I'm alive despite their plan. That's the outcome. Some betrayals involve using medical conditions as murder weapons. Linda's was one of them. She wanted $2 million and freedom to be with David. Got 25 years in prison instead. I wanted a loving marriage. Got attempted murder instead. 18 years we were married. 6 months she poisoned me. 25 years she'll serve. Numbers that tell the story. Prison sentences that equal justice. Years that can't be recovered. But I survived. Despite the allergens. Despite the plan. Despite everything. Living allergen-free now. Checking every ingredient. Trusting no one with my food. Everything she tried to take. Everything I kept. Life. Health. Freedom from her. Victory over her plan. She calculated dosages. Courts calculated sentences. Both precise. Both final. Appropriate ending. Just consequence. Deserved outcome. Living despite Linda's allergen poisoning. Thriving despite her murder plan. That's enough. That's victory. That's justice. She's imprisoned. I'm free. Fair trade for attempted murder. Every day alive is proof her plan failed. Every safe meal is proof she's gone. Some spouses honor in sickness and in health. Linda tried to create sickness for death and wealth. Failed completely. Paying completely. Gone completely. I remain. Alive. Safe. Beyond her reach forever. That's the ending. Not what I wanted, but what her choices earned. Justice served. Life preserved. Future reclaimed. Despite her. Beyond her. Without her. Perfect conclusion to her failed murder plot. Adult children were poisoning family dog to frame me for animal abuse. I discovered my adult children had been systematically poisoning our family dog over 6 months to create veterinary records of neglect and abuse they could use in court to prove I was an unfit parent and gain custody of their younger sibling. I'm 44 years old, divorced single mother of 3 children. My oldest 2, Caleb, 24, and Whitney, 22, are adults living on their own. My youngest, Mia, is 13 and lives with me full-time. Our family dog, Bailey, is an 8-year-old golden retriever we've had since she was a puppy. Bailey has been healthy, well cared for, and beloved by all of us for her entire life. My relationship with Caleb and Whitney has been strained since my divorce from their father 3 years ago. They sided with him during the separation, believed his narrative that I was responsible for the marriage ending, and have maintained minimal contact with me since. They see Mia regularly, taking her for weekend visits, attending her school events, maintaining their sibling relationship despite their fractured relationship with me. 6 months ago, Bailey started experiencing mysterious health problems. She'd have episodes of vomiting, diarrhea, lethargy, and loss of appetite. I'd rush her to the veterinarian, they'd run tests, treat her symptoms, and she'd recover. Then, 2 weeks later, another episode would occur. Our veterinarian, Dr. Marcus Chen, became increasingly concerned. Bailey keeps presenting with symptoms consistent with toxic exposure or poisoning. Are there any household chemicals she could be accessing? Any plants she might be eating? I've checked everything. My house is dog-proofed. I can't figure out what's causing these repeated episodes. The pattern is unusual. She'll be fine for a week or two, then suddenly very sick again. It's almost like she's being exposed to something intermittently rather than continuously. Dr. Chen ran comprehensive tests, blood work, imaging, toxicology screens. Some tests showed traces of substances that shouldn't be in Bailey's system: antifreeze components, rat poison compounds, medications toxic to dogs. But the levels were always low enough that Dr. Chen couldn't definitively prove poisoning versus accidental environmental exposure. I was terrified and confused. Bailey was my constant companion, Mia's beloved pet, and watching her suffer through these repeated episodes was heartbreaking. I spent thousands on veterinary care, changed her diet multiple times, removed every possible toxin from my home, and monitored her obsessively. Despite my efforts, the episodes continued. Every 2 to 3 weeks, Bailey would become violently ill. Each time I'd take her to Dr. Chen, who'd treat her symptoms and document another incident of toxic exposure of unknown origin. Then, Caleb and Whitney filed a petition for emergency custody of Mia. The petition claimed I was an unfit parent based on pattern of animal abuse and neglect, as evidenced by repeated poisoning of family dog, documented by veterinary records. They submitted Dr. Chen's medical records for Bailey showing 6 months of toxic exposure incidents, arguing that someone who'd repeatedly poisoned the family dog was unsafe to care for a 13-year-old child. I was shocked and horrified. I've been desperately trying to save Bailey from these mysterious poisoning episodes. I've spent thousands on veterinary care. How can they claim I'm abusing her? My attorney reviewed the custody petition and veterinary records. They're using Bailey's poisoning episodes as evidence of your unfitness as a parent. The vet records show repeated toxic exposure over 6 months. They're arguing you're either deliberately poisoning the dog or so neglectful that you can't protect her from repeated poisoning. Either way, you're unfit to care for Mia. The custody hearing was scheduled for 2 weeks out. I was terrified that 6 months of veterinary records documenting Bailey's mysterious poisoning would be used to take Mia away from me. Then I discovered the truth. I was cleaning Mia's room when I found a small bottle hidden in her closet. Antifreeze in a travel-size container. When I confronted Mia about it, she broke down crying. Caleb and Whitney gave it to me. They told me to put small amounts in Bailey's water bowl every few weeks when you weren't looking. They said it was medicine to help Bailey, but it was making her sick instead. I didn't know what to do. They're my older siblings and I trusted them. The revelation that Caleb and Whitney had been using Mia to poison Bailey was devastating on multiple levels. They'd manipulated their 13-year-old sister into harming the family dog to build a child custody case against me, based on fabricated animal abuse. I immediately contacted my attorney with this information. We needed to act quickly. The custody hearing was in less than 2 weeks, and Caleb and Whitney's petition was based entirely on the veterinary records of Bailey's repeated poisoning that they had actually orchestrated. My attorney advised documenting everything. We need Mia's statement about Caleb and Whitney giving her antifreeze and instructing her to poison Bailey. We need the bottle she found. We need to connect this to the custody petition timeline. I sat with Mia and a child advocate present to ensure her statement was properly documented. She explained the full scope of what her older siblings had done. Caleb and Whitney started asking me about 6 months ago if I wanted to live with them instead of Mom. I said no. I love living with Mom. Then they started saying Mom wasn't a good parent, that she was neglectful and mean. I didn't understand because Mom's always been great to me. About a month after that, they gave me a small bottle and told me it was special medicine for Bailey. They said Bailey needed it because Mom wasn't taking care of her properly. They told me to put just a little bit in Bailey's water bowl every 2 or 3 weeks when Mom wasn't watching. They said it would help Bailey feel better. I did what they said because they're my older brother and sister and I trusted them. But after I'd put the medicine in Bailey's water, she'd get really sick. I'd feel terrible watching her throw up and act so tired. I asked Caleb and Whitney if the medicine was supposed to make Bailey sick, and they said it was normal, that she'd feel worse before feeling better. This happened probably 8 or 10 times over the past 6 months. Every time I gave Bailey the medicine, she'd get sick within a few hours. I started to suspect something was wrong, but Caleb and Whitney kept saying it was helping her. They also told me not to tell Mom about giving Bailey medicine because Mom wouldn't understand and might stop the treatment. Last week, Caleb told me they were going to help me get away from Mom soon. He said they were going to court to prove Mom wasn't a good parent so I could come live with them. I didn't understand how they could prove that. Mom's always been wonderful to me. Now I realize they were using Bailey being sick as proof that Mom was a bad parent. But they were the ones making Bailey sick through me. The child advocate was horrified. These adults manipulated their 13-year-old sister into poisoning the family dog to create veterinary records they could use in a custody case? That's child endangerment, animal cruelty, and fraud on the court. We collected additional evidence. The antifreeze bottle Mia had hidden in her closet was sent for fingerprint analysis. It had Caleb's fingerprints on it, confirming he'd given it to Mia. Text messages between Caleb and Whitney revealed their planning. Caleb: Mia gave Bailey the antifreeze again yesterday. Should see another vet visit within 48 hours. Whitney: Good. We need at least 10 documented poisoning incidents before we file for custody. Want the vet records to show a clear pattern of neglect. Caleb: We're at 8 incidents now. 2 more and we file the petition. Mia's doing great. She has no idea she's building our custody case. Whitney: Do you think the judge will buy it? That their mom is poisoning or neglecting the dog? Caleb: We have months of vet records showing repeated toxic exposure. Either she's poisoning the dog herself, or she's so neglectful she can't protect it. Either way, she's unfit to parent a 13-year-old. The messages confirmed everything. Caleb and Whitney had deliberately planned to poison Bailey using Mia as their unwitting accomplice, creating veterinary documentation they'd use to argue I was an unfit parent in their custody petition. More messages showed they'd researched which substances would make Bailey sick without killing her. Whitney: Antifreeze in small doses will make the dog sick enough for vet visits, but won't be fatal. Perfect for our purposes. Caleb: How many times can we poison the dog before it dies? Whitney: Research says small intermittent doses can go on indefinitely. The dog will keep getting sick and recovering. Each incident creates a vet record. They'd calculated how to harm Bailey repeatedly to build their custody case without actually killing her, treating our family dog as a tool to manufacture evidence of my supposed unfitness. We filed emergency motions with family court. Motion to dismiss custody petition. Based on fraud, the petitioners had deliberately created the evidence of animal abuse by poisoning the dog themselves. Motion for protective order. Requesting Caleb and Whitney have no contact with Mia given they'd manipulated her into committing animal cruelty. Motion for sanctions. Requesting penalties for fraud on the court and abuse of the custody petition process. I also filed police reports for animal cruelty, child endangerment, using Mia to poison Bailey, and conspiracy to commit fraud. The legal response was immediate and severe. The family court judge who'd been assigned to hear Caleb and Whitney's custody petition was furious when presented with evidence they'd fabricated the animal abuse claims that formed the basis of their petition. Caleb and Whitney were charged with multiple crimes: animal cruelty, systematically poisoning family dog over 6 months, causing repeated illness and suffering; child endangerment, manipulating their 13-year-old sister into poisoning the dog, exposing her to toxic substances and psychological harm; contributing to delinquency of a minor, instructing Mia to commit acts of animal cruelty; fraud on the court, filing custody petition based on fabricated evidence they deliberately created; conspiracy, planning and executing the scheme together over 6 months. The prosecutor emphasized the calculated cruelty. The defendants spent 6 months poisoning their family dog, using their 13-year-old sister as the instrument of poisoning. They did this specifically to create veterinary records documenting toxic exposure they could then attribute to their mother in a custody petition. They manipulated a child into harming an animal to manufacture evidence for a fraudulent legal proceeding. Dr. Chen, our veterinarian, testified, "I treated Bailey for repeated toxic exposure over 6 months. The pattern was unusual. She'd be healthy for weeks, then suddenly present with poisoning symptoms. I suspected deliberate poisoning but couldn't identify the source. Learning that the patient's adult children were having their younger sister poison the dog to create these medical records is unconscionable." Toxicology experts testified about the substances found in Bailey's system. The dog was exposed to antifreeze, rat poison components, and other toxic substances in doses calculated to cause illness without death. This wasn't accidental exposure. This was deliberate, repeated poisoning designed to create a pattern of medical incidents. Child welfare specialists testified about the harm to Mia. The defendants manipulated their 13-year-old sister into poisoning the family dog she loves. They told her it was medicine when it was actually poison. She watched the dog suffer after following her siblings' instructions. The psychological impact of learning she was tricked into harming her beloved pet is severe. Mia's therapist testified, "This child is traumatized by learning she was the instrument of Bailey's suffering. Her siblings exploited her trust to make her commit animal cruelty. She feels guilt, betrayal, and profound confusion about how the siblings she trusted could use her this way." The text messages between Caleb and Whitney showed premeditation and callous disregard for both Bailey's suffering and Mia's well-being. The jury heard them discuss poisoning schedules, calculating doses, and celebrating successful vet visits that built their custody case. The custody petition was dismissed with prejudice. The family court judge issued a scathing order. The petitioners fabricated the evidence forming the basis of their custody petition by poisoning the family dog and manipulating their minor sister into being the poisoning agent. This is fraud on the court and abuse of the custody petition process. The petition is denied, dismissed, and the petitioners are permanently barred from filing any future custody petitions regarding the minor child. The judge also granted my motion for protective orders. Caleb and Whitney are prohibited from any contact with Mia until she turns 18. They've demonstrated willingness to manipulate her into criminal activity to serve their custody goals. The minor child needs protection from their influence. The jury convicted Caleb and Whitney on all counts. Caleb received 3 years in prison for animal cruelty and child endangerment. Whitney received 2.5 years. Both received probation, restitution for Bailey's veterinary costs, mandatory animal cruelty and parenting education, and permanent restraining orders from Mia and me. Bailey recovered fully once the poisoning stopped. Dr. Chen monitored her closely for lingering effects but confirmed, "The dog is healthy now. No more toxic exposures since the defendants were arrested. She should have normal life expectancy." Mia is in intensive therapy processing the betrayal and her unwitting role in Bailey's poisoning. "I loved Bailey. I trusted Caleb and Whitney. They made me hurt Bailey and I didn't know. How do I forgive myself?" Her therapist works with her on understanding she was a victim. "You were 13 years old. Your adult siblings lied to you and manipulated you. You believed you were giving medicine. You're not responsible for their deception." Extended family struggled to comprehend. Caleb and Whitney poisoned the family dog? Used Mia to do it? To build a fake custody case? That's psychotic. Animal welfare organizations use the case in cruelty prevention training. This demonstrates premeditated animal abuse. Defendants systematically poisoned a dog over 6 months, not out of hatred for the animal, but as a tool to manufacture custody case evidence. Child advocacy groups highlighted the manipulation. Using a minor child to commit criminal acts, even when the child doesn't know the acts are criminal, is severe abuse. These defendants exploited their sister's trust and love. Do I forgive Caleb and Whitney? Never. They tortured our family dog and traumatized their little sister to try to take custody from me based on abuse they committed. Can Mia forgive herself? That's the harder question. She's 13, struggling with guilt over harm she didn't know she was causing. Will Caleb and Whitney have relationship with Mia when they're released? The restraining order lasts until she's 18. After that, it's her choice. Right now, she never wants to see them again. Bailey's healthy, Mia's in therapy, Caleb and Whitney are in prison. I have full custody without threat of fraudulent petitions. Some betrayals involve using children to poison pets. Caleb and Whitney's was one of them. They wanted custody through fabricated abuse records, got prison records instead. Mia wanted to help Bailey with medicine, gave her poison unknowingly. Learning that destroyed her. Bailey wanted to be healthy, is now, without her family poisoning her for custody schemes. Fair outcomes? Nothing fair about traumatized child and poisoned dog, but justice was served. 3 years Caleb serves, 2.5 for Whitney. 6 months they poisoned Bailey. 13 years Mia has been alive, her whole life manipulated by siblings who'd use her for custody fraud. Numbers that add up to betrayal. Prison sentences that equal consequences. Years that can't be recovered. But we survive. Bailey, Mia, and me. Despite Caleb and Whitney, beyond their scheme, without them now. Dog healthy, child healing, mother vindicated, siblings imprisoned. That's where we are. Where their choices led, where justice brought us. Some families poison relationships. Caleb and Whitney poisoned a dog to poison mine with Mia. Failed completely. Cost them everything. Gave us freedom from their manipulation. Appropriate ending. Just consequence. Deserved outcome. Living without them. Better already. Healing slowly. Bailey runs freely. Mia laughs sometimes. I breathe easier. Everything they tried to destroy. Everything that survived. That's enough. Spouse had been faking Alzheimer's symptoms for 2 years to justify committing me. I discovered my husband had been deliberately acting like he had Alzheimer's disease for 2 years, documenting fake symptoms to build a case for having me committed to a psychiatric facility for delusional disorder when I questioned his diagnosis. I'm 46 years old, married for 22 years to my husband Robert, who is 48. We have one son, Trevor, who's 19 and away at college. Robert and I had what I thought was a solid marriage. Comfortable routine, shared interests, mutual respect built over 2 decades together. 2 years ago, Robert started exhibiting what appeared to be early signs of dementia. He'd forget conversations we'd just had, misplace items around the house, seem confused about appointments or plans we'd made together. At first, these were minor incidents I attributed to stress from his demanding job as a financial analyst, but the incidents increased in frequency and severity. Robert would ask me the same question multiple times in an hour, seemingly forgetting he'd already asked. He'd put items in bizarre places, car keys in the freezer, his wallet in the bathroom cabinet, his phone in the vegetable drawer. He'd miss important meetings he'd scheduled, claiming he had no memory of setting them up. I grew increasingly concerned and urged him to see a doctor. After months of my pushing, he finally agreed to see a neurologist. Dr. Patricia Hendricks ran comprehensive tests, cognitive assessments, brain scans, blood work, the full diagnostic protocol for suspected dementia. The diagnosis was devastating: early onset Alzheimer's disease. Dr. Hendricks showed me brain scans indicating abnormalities consistent with Alzheimer's, prescribed medications to slow progression, and recommended we start making long-term care plans. I was heartbroken. My 48-year-old husband had a degenerative brain disease that would progressively steal his memories, his personality, and eventually his ability to care for himself. I researched Alzheimer's extensively, joined caregiver support groups, rearranged my work schedule to be home more, and prepared emotionally for the difficult journey ahead. Over the following 18 months, Robert's symptoms appeared to worsen on the expected trajectory. More memory gaps, increased confusion, occasional disorientation about time and place. I documented everything in a caregiver journal, tracked his medications, and attended follow-up appointments with Dr. Hendricks, who confirmed the disease was progressing as anticipated. Then, I started noticing inconsistencies. Robert would seem very confused during our morning routine, but would later in the day demonstrate perfect recall of complex information related to his work. He'd forget my sister's name one day, but have detailed discussions about his job projects the next. The memory problems seemed selective and inconsistent with the progressive, indiscriminate nature of Alzheimer's. I mentioned these observations to Dr. Hendricks. Sometimes Robert seems very impaired, but other times he's completely lucid and remembers intricate details. Is this pattern normal for Alzheimer's? Dr. Hendricks seemed uncomfortable. Alzheimer's can have variable presentation day to day, but the inconsistencies you're describing are unusual. Let me schedule additional testing. Before those tests could happen, I made a discovery that changed everything. I was looking for our insurance documents in Robert's home office when I found a notebook hidden in a locked drawer. I'd found the key months earlier while cleaning. The notebook contained detailed logs of memory symptoms Robert had been faking. Tuesday 3:15, pretended to forget conversation about dinner plans. Asked 3 times what we were eating. Patricia seemed concerned and documented in caregiver journal. Friday 3:18, put car keys in freezer on purpose. When Patricia found them, acted confused about how they got there. She's now convinced the confusion is worsening. Monday 3:21, asked Patricia who her sister was, pretending not to recognize the name Emma. Patricia was very upset. Good emotional response that will look authentic to doctors. Page after page of fabricated symptoms, calculated performances, and notes about my reactions. Robert had been faking Alzheimer's disease for 2 years, documenting his deception in meticulous detail. But the notebook contained something even more disturbing: a plan for the next phase. Robert intended to report me to psychiatric authorities for delusional disorder, claiming I refused to accept his Alzheimer's diagnosis and was becoming paranoid and delusional about him faking his illness. He'd built 2 years of medical documentation of his supposed Alzheimer's, documentation that would make me look delusional if I claimed he wasn't actually sick. The full scope of Robert's deception became clear as I read through the entire notebook. He'd planned this elaborate fraud for years, and the goal was having me committed to a psychiatric facility while he maintained control of our lives and assets. The notebook contained disturbing details. Symptom performance schedule. Robert had carefully planned which memory symptoms to display on which days, varying them to seem authentic while ensuring they were documented by me in my caregiver journal. Monday, forget breakfast plans. Wednesday, misplace wallet. Friday, forget sister's name. Make sure Patricia sees and documents each incident. Dr. Hendricks' collusion. Robert had somehow convinced Dr. Hendricks to provide false Alzheimer's diagnosis and fabricated test results. Notes in the notebook referenced Patricia H. on board with plan, provided diagnostic documentation as discussed. Medication deception. The Alzheimer's medications Dr. Hendricks prescribed weren't actually being taken by Robert. He'd been disposing of them while telling me he took them daily, maintaining the appearance of following treatment protocol while experiencing no actual medication effects. Caregiver journal weaponization. Robert had deliberately performed symptoms he knew I'd document in my caregiver journal. That journal, which I'd kept meticulously to track his supposed disease progression, would be used as evidence of my delusions when he claimed I'd invented the entire Alzheimer's diagnosis due to my own mental illness. Commitment plan. The final section detailed Robert's strategy for having me involuntarily committed to psychiatric facility. After 2 years of documented Alzheimer's diagnosis with medical records and caregiver journals, I'll report Patricia for delusional disorder. She'll claim I'm faking Alzheimer's, which will sound paranoid and delusional given extensive medical documentation. Her insistence that my neurologist confirmed disease is fabricated will seem like serious mental illness. Psychiatric evaluation will likely result in involuntary commitment for treatment of delusional disorder. While she's institutionalized, I'll have legal authority over decisions and can maintain the life I want without her interference. Robert had spent 2 years building an elaborate framework to make me look mentally ill if I questioned his fake diagnosis. Every symptom he performed, every doctor's visit, every entry in my caregiver journal, all of it was designed to create documentation that would support committing me to psychiatric facility when I inevitably questioned whether his Alzheimer's was real. Text messages between Robert and someone named P.H., presumably Dr. Hendricks, confirmed the collusion. Robert: Patricia's documenting all the fake symptoms in her caregiver journal. Perfect evidence for later. P.H.: Good. The more documentation of your Alzheimer's we have, the more delusional she'll appear when she claims you're faking. Robert: When should we move to phase 2? P.H.: Give it 2 full years. That's enough medical history to make her claims seem paranoid. Then file the involuntary commitment petition based on her delusional belief that you're faking a neurologist-confirmed diagnosis. They'd planned my psychiatric commitment as the culmination of a 2-year fraud, where Robert pretended to have Alzheimer's specifically so he could later claim I was delusional for questioning the diagnosis. But why? What was Robert's motive for this elaborate scheme? Further reading revealed his reasoning. Robert wanted to leave our marriage, but didn't want to deal with divorce proceedings, property division, or social judgment for abandoning a spouse caring for his Alzheimer's. If I were committed to psychiatric facility for delusional disorder, he could position himself as the devoted husband, caring for both his own Alzheimer's and his wife's mental illness, while actually having me institutionalized and maintaining full control over our marital assets and life. Decisions. Even more disturbing, messages referenced another woman. Once Patricia's committed, I can be with Claire without the divorce complications. Patricia will be institutionalized for delusional disorder. I'll be the sympathetic husband, dealing with his own Alzheimer's and his wife's mental illness. And Claire and I can be together without divorce scandal. Robert had been planning to have me committed to psychiatric facility based on fake Alzheimer's diagnosis, all so he could be with another woman without going through divorce. I photographed every page of the notebook, saved all text messages between Robert and P.H., and documented the unused Alzheimer's medications I found hidden in Robert's office. Then, I contacted an attorney specializing in medical fraud and psychiatric abuse. The attorney was horrified. Your husband has conspired with a neurologist to fake Alzheimer's disease for 2 years, building medical documentation specifically to use as evidence that you're delusional when you question his diagnosis. This is conspiracy to commit fraud, medical malpractice, and attempted false imprisonment through wrongful psychiatric commitment. The legal and criminal response to Robert's elaborate fraud was swift and comprehensive. Multiple agencies and professional bodies investigated once I provided the notebook, text messages, and evidence of the conspiracy. Robert was charged with conspiracy to commit fraud, planning and executing elaborate medical deception with Dr. Hendricks' collusion, attempted false imprisonment, planning to have me wrongfully committed to psychiatric facility based on fabricated evidence, medical fraud, faking illness to obtain fraudulent diagnosis and prescriptions, witness tampering, manipulating me into creating evidence through caregiver journal that would later be used against me. Dr. Patricia Hendricks was charged with medical fraud, providing false diagnosis and fabricated test results. Conspiracy. Collaborating with Robert to build fake medical documentation for use in psychiatric commitment scheme. Medical malpractice. Violating fundamental medical ethics by participating in scheme to wrongfully institutionalize patient's spouse. Prescription fraud. Prescribing medications for non-existent condition. The prosecutor emphasized the calculated cruelty. The defendant spent 2 years faking Alzheimer's disease, carefully performing symptoms his wife would document as a concerned caregiver. He did this specifically to create medical records he could later use as evidence she was delusional when she questioned his diagnosis. His goal was having his wife involuntarily committed to psychiatric facility so he could avoid divorce while pursuing relationship with another woman. Medical ethicists testified about the profound violations. The defendant and Dr. Hendricks created a scenario where the victim couldn't question the fake diagnosis without appearing mentally ill. Every time she documented symptoms in her caregiver journal, thinking she was helping track her husband's disease progression, she was actually building the evidence that would be used to institutionalize her. Psychiatrists testified about the commitment plan. If this scheme had succeeded, the victim would have been involuntarily committed to psychiatric facility based on delusional disorder, her supposed delusion being that her husband was faking Alzheimer's. Given 2 years of medical documentation of his diagnosis, her claims would have appeared paranoid. She could have been institutionalized indefinitely. The notebook was entered as evidence, page after page of Robert's documented fake symptoms, performance schedule, and plans for my commitment. The jury read his clinical notes about which symptoms to perform and how to ensure I documented them. Text messages between Robert and Dr. Hendricks showed clear conspiracy. Planning the fake diagnosis, discussing how to create convincing medical documentation, coordinating the timeline for moving to Phase 2, my commitment, and celebrating the success of their deception. My caregiver journal was presented. 2 years of detailed documentation of Robert's symptoms that I'd kept thinking I was tracking his disease progression. Every entry Robert had deliberately performed became evidence of how thoroughly he'd manipulated me. Brain scans and test results. Dr. Hendricks had shown me as evidence of Alzheimer's were examined by independent neurologists. These scans show normal brain structure with no signs of Alzheimer's or any dementia. Dr. Hendricks either fabricated these results or showed this patient scans from a different person while claiming they were her husband's. Robert's defense attempted to claim he'd actually believed he had Alzheimer's, and the notebook was his way of tracking symptoms. My client was confused by his own potential illness and kept notes to understand what was happening. The prosecutor destroyed this. The defendant's notebook explicitly states he's pretending and faking symptoms. He writes about how his wife's emotional reactions will look authentic to doctors. He discusses plans to use his fake diagnosis to have his wife committed. There's no ambiguity. This is documented, premeditated fraud. The jury convicted Robert on all counts. He received 5 years in prison for conspiracy and attempted false imprisonment, restitution for my legal fees and therapy costs, and permanent restraining orders. Dr. Hendricks was convicted of medical fraud and conspiracy. She received 4 years in prison, permanent loss of medical license, and prohibition from ever practicing medicine again. The woman Robert had been planning to be with, Claire, ended their relationship immediately when she learned about the scheme. "You were going to have your wife committed to psychiatric facility so we could be together? That's psychotic. We're done." I filed for divorce while Robert was awaiting sentencing. The divorce was uncontested. Robert had no defense and no public sympathy. I received everything in the settlement. Trevor, our son, struggled to understand. "Dad faked Alzheimer's for 2 years? To have you committed? So he could be with another woman?" I don't even know who he is. Neither do I, honestly. The man I thought I knew wouldn't do this. I don't know who your father actually is. Support groups for caregivers were horrified. You spent 2 years caring for someone you believed had Alzheimer's, rearranging your life, joining support groups, preparing for his decline, and he was faking it the entire time? Medical fraud investigators used the case in professional training. This demonstrates the extreme: a physician colluding with patient to build false medical documentation for use in wrongful psychiatric commitment. It represents catastrophic breach of medical ethics. Psychiatric rights advocates highlighted the danger. This case shows how medical documentation can be weaponized. If the scheme had succeeded, this woman would have been institutionalized based on delusion that was actually truth about her husband's fraud. Do I forgive Robert? Never. He spent 2 years systematically deceiving me, planning my psychiatric commitment, and building a framework to make me appear mentally ill. Can I trust medical professionals again? That's harder. Dr. Hendricks violated everything medicine should be. I'm in therapy processing that betrayal alongside Robert's. Life has resumed some normalcy. Work, friends, hobbies I'd neglected while caregiving for Robert's fake Alzheimer's. Trevor visits when he's home from college, though our relationship is strained by his father's imprisonment. Robert sends letters from prison. I don't read them. His attorney forwards them. I burn them. Some betrayals involve faking terminal illness. Robert's involved faking degenerative brain disease to justify institutionalizing me. 2 years of fake symptoms. 2 years of my caregiver documentation. 2 years building toward psychiatric commitment. All because he wanted to avoid divorce while being with another woman. He's paying for it. Prison, lost family, lost reputation. I'm recovering from it. Therapy, rebuilding, learning to trust again. Fair outcome? Nothing about this is fair. But it's just. Robert pretended to lose his mind to steal mine. Courts took his freedom for trying. Appropriate consequence, deserved punishment, adequate justice. Living free while he's imprisoned. Living sane while he's known for trying to commit me falsely. That's enough. Not healing, not closure, but enough. Some marriages end in divorce. Ours ended in fraud prosecution and attempted false imprisonment. Not what I chose. What Robert chose. What Robert's paying for. 5 years he'll serve. 2 years he faked Alzheimer's. 22 years we were married. Math that adds up to betrayal. Numbers that equal fraud. Years that meant nothing. He's gone. I'm here. That's the outcome. Despite his scheme, beyond his fraud, without his fake Alzheimer's. Alive. Free. Sane. Vindicated. Perfect ending to his failed commitment plot. He wanted me institutionalized. Got institutionalized himself instead. Ironic. Just satisfying. That's enough. Adult daughter was secretly replacing insulin with saline to induce medical crisis. I discovered my adult daughter had been systematically replacing my insulin with saline solution for 3 months to cause diabetic emergencies that would force me into assisted living, where she could control my care decisions. I'm 50 years old, type 1 diabetic since childhood, managing my condition successfully for over 40 years with insulin therapy and careful monitoring. I'm healthy, active, work full-time as a research librarian, and live independently in my own home. My daughter Vanessa is 29, married with 2 young children, and lives about 30 minutes away. Type 1 diabetes requires precise insulin management. Too little insulin causes dangerously high blood sugar, potentially leading to diabetic ketoacidosis, DKA, a life-threatening condition. I've managed my diabetes meticulously for decades, checking blood sugar regularly, adjusting insulin doses accordingly, maintaining stable control. My endocrinologist has always commended my excellent disease management. 4 months ago, Vanessa started pushing me to move into an assisted living facility. Mom, you're 50 with a serious chronic illness. What if you have a diabetic emergency when you're alone? You need to be somewhere with 24/7 medical supervision. I've managed type 1 diabetes for 42 years without incident. I know my body, I monitor carefully, and I have excellent control. I don't need assisted living. You're getting older. Diabetes complications increase with age. We'd all feel better if you had professional oversight. I appreciate the concern, but I'm not ready to give up my independence. My diabetes is well controlled and doesn't interfere with my daily life. Vanessa seemed frustrated but dropped the subject. I thought she'd accepted my decision to remain independent. 3 months ago, my diabetes control suddenly destabilized. Despite taking my normal insulin doses, my blood sugar readings were dangerously high, consistently 300 to 400 milligrams per deciliter, when they should have been 80 to 120 milligrams per deciliter. I increased my insulin doses as my endocrinologist recommended, but the high readings persisted. I started experiencing symptoms of hyperglycemia, excessive thirst, frequent urination, fatigue, blurred vision. These were symptoms I hadn't experienced regularly in years because my diabetes had been so well controlled. My endocrinologist was baffled. Your insulin regimen should be controlling your blood sugar. Have you changed anything about your diet, exercise, or medication routine? Nothing. I'm doing everything exactly as I have for years. I don't understand why my control has suddenly deteriorated. We adjusted my insulin doses multiple times, trying to bring my blood sugar under control. Nothing worked. My readings remained dangerously high, despite taking significantly more insulin than I'd ever needed before. 2 weeks ago, I experienced severe diabetic ketoacidosis, my first DKA episode in over 20 years. My blood sugar was over 500 milligrams per deciliter. I was vomiting, confused, struggling to breathe. I called 911 and was rushed to the emergency room where I spent 3 days in intensive care recovering. Vanessa visited me in the hospital every day, acting concerned and supportive. Mom, this is exactly what I was worried about. Your diabetes is becoming uncontrolled. You can't live alone safely anymore. After you're discharged, you need to move into assisted living, where medical staff can monitor you. I don't understand what's happening. I've never had control problems like this. Something's wrong. You're getting older. Diabetes progression is natural. You need professional care now. After discharge, I went home determined to figure out why my diabetes had suddenly become uncontrolled after 40 years of excellent management. I reviewed every aspect of my routine, looking for changes that could explain the deterioration. Then, I noticed something odd about my insulin vials. I keep my insulin in the refrigerator, storing opened vials separately from unopened ones. The vial I was currently using seemed lighter than it should be, as if some liquid had been removed and replaced with something else. I took the vial to a pharmacy and asked them to test it. The pharmacist called me 2 hours later with shocking results. This vial contains saline solution, not insulin. Someone has replaced your medication with salt water. Someone had been systematically replacing my insulin with saline, causing my blood sugar to spike dangerously high because I wasn't actually receiving insulin, just injecting harmless salt water while believing I was treating my diabetes. The realization that someone was sabotaging my diabetes medication was terrifying, but I needed to identify who had access to my home and my insulin before confronting anyone. I installed hidden cameras throughout my house, particularly focused on the kitchen where I kept my insulin in the refrigerator. Within 3 days, the cameras captured everything. Vanessa had a key to my house. I'd given it to her years ago for emergencies. The footage showed her letting herself into my home while I was at work, going directly to my refrigerator, removing my current insulin vial, and taking it to my kitchen counter. The video clearly showed Vanessa's process. She'd draw insulin from my vial using a syringe, discard the insulin in the sink, then refill the same vial with saline solution from a bottle she brought with her. She'd carefully measure the amounts to ensure the vial appeared to have the same volume of liquid, making the replacement undetectable through casual observation. She'd shake the vial gently to ensure the saline mixed properly, then return it to its exact position in my refrigerator. The entire process took less than 10 minutes. She'd been doing this systematically, replacing my insulin every few days to ensure I was consistently injecting saline instead of actual diabetes medication. I had footage of Vanessa doing this on 6 different occasions over the past month. Each time, she'd enter my house with her key while I was at work, replace my insulin with saline, and leave before I returned home. No wonder my blood sugar was uncontrolled. I hadn't received actual insulin in months. Text messages between Vanessa and her husband revealed the full scope of the plan. Vanessa: replaced mom's insulin again today. Her next endocrinology appointment is Friday. Bet her blood sugar readings are going to be terrible. Husband: how much longer are you going to keep doing this? Vanessa: until she has another diabetic emergency serious enough that the doctors recommend assisted living. Her last DKA was close. She was in ICU for 3 days. One more episode, and they'll say she can't live independently. Husband: you're literally causing diabetic emergencies by replacing her insulin with saline. What if you kill her? Vanessa: I'm being careful with the timing. She checks her blood sugar regularly and will call 911 if it gets too high. The goal is scary medical crisis, not actual death. Once she's in assisted living, we can control her care decisions and eventually transition her to memory care when the time comes. Husband: this seems extreme just to get her into assisted living. Vanessa: she's stubborn and won't go voluntarily. This way, medical professionals will recommend it, and she'll have to agree. Plus, once she's in assisted living, we have more authority over her health care and living situation as her primary emergency contacts. They'd planned this for months. Vanessa would sabotage my insulin to cause diabetic emergencies, medical professionals would recommend I couldn't live independently, and Vanessa would position herself as the concerned daughter advocating for assisted living while secretly being the one who'd caused the medical crises in the first place. More messages showed Vanessa had researched diabetic ketoacidosis specifically to understand how to induce it through insulin deprivation. Vanessa: DKA happens when there's not enough insulin in the body. If I replace her insulin with saline consistently, her blood sugar will spike and trigger DKA. It's dangerous, but usually treatable if caught in time. Husband: you're playing with your mother's life. Vanessa: she'll be fine. She monitors her sugar obsessively and will get medical help before it's truly life-threatening. A few scary hospital stays will convince everyone she needs supervised care. My daughter had been deliberately causing diabetic emergencies, potentially life-threatening medical crises, to manipulate me into assisted living. She'd studied diabetic ketoacidosis to understand how to induce it, systematically replaced my insulin with saline for months, and caused my recent ICU hospitalization through deliberate medical sabotage. I gathered all evidence: hidden camera footage of Vanessa replacing my insulin, the saline-contaminated vial that should have contained insulin, text messages discussing the sabotage plan, and my medical records showing the sudden onset of uncontrolled diabetes that correlated exactly with when Vanessa began the insulin replacement. I contacted police and filed reports for attempted murder. DKA can be fatal. Assault, deliberately causing medical emergencies, and tampering with pharmaceutical products. I also reported to Adult Protective Services, even though I'm only 50. This was elder abuse methodology applied to someone with a chronic illness. My attorney advised immediate action. Your daughter has been poisoning you, not with traditional poison, but by replacing life-sustaining medication with inactive substitute. That's attempted murder. DKA kills people. The criminal case against Vanessa proceeded on multiple serious charges. The evidence was overwhelming, and the prosecutor emphasized the calculated, potentially lethal nature of her actions. Vanessa was charged with attempted murder, deliberately depriving a type 1 diabetic of insulin, knowing this would cause life-threatening diabetic ketoacidosis. Aggravated assault, causing severe bodily harm through systematic medication tampering. Pharmaceutical tampering, replacing prescription medication with inactive substitute. Reckless endangerment, creating situations where death or serious injury was likely. Elder abuse, using manipulation tactics designed to force assisted living placement. Though I'm 50, the methodology matched elder abuse patterns. The prosecutor's opening statement was damning. The defendant systematically replaced her mother's life-sustaining insulin with saline solution for 3 months. The defendant's mother is type 1 diabetic. Without insulin, she will die. The defendant knew this. She researched diabetic ketoacidosis, understood she was creating life-threatening medical emergencies, and did it anyway. Her motive was forcing her mother into assisted living to gain control over her care and living situation. Medical experts testified about the severity. Endocrinologist. Type 1 diabetics produce no insulin naturally. External insulin is literally life-sustaining. Replacing it with saline is equivalent to removing a ventilator from someone who can't breathe independently. The defendant created conditions where her mother's body couldn't regulate blood sugar, leading to dangerous hyperglycemia and ketoacidosis. Emergency physician who treated my DKA. This patient was in severe diabetic ketoacidosis when admitted. Blood sugar over 500, blood pH dangerously acidic, dehydrated, vomiting, altered consciousness. DKA has 2 to 5% mortality rate even with treatment. The defendant created this condition deliberately by replacing insulin with saline. Toxicologist. Testing the vial the defendant was using confirmed it contained saline, not insulin. Chemical analysis showed this was medical-grade saline solution identical to the product visible in surveillance footage of the defendant performing the replacement. The surveillance footage was played in court, showing Vanessa entering my home with her key, removing my insulin, carefully replacing it with saline at my kitchen counter, and returning the contaminated vial to my refrigerator. The jury watched her methodically sabotaging my diabetes medication while I was at work, unaware my daughter was literally removing my ability to manage my life-threatening chronic illness. Text messages between Vanessa and her husband were read in court, showing premeditation, understanding of the danger, and explicit goal of causing diabetic emergencies to force assisted living. One more DKA episode and they'll say she can't live independently. The goal is scary medical crisis, not actual death. Once she's in assisted living, we have more authority over her health care. My medical records documented the timeline. 40 years of excellent diabetes control, followed by sudden deterioration starting exactly when surveillance showed Vanessa began replacing my insulin, culminating in severe DKA requiring ICU admission, the first DKA episode I'd had in over 2 decades. My testimony described the terror. For 42 years, I've managed type 1 diabetes successfully. Suddenly, inexplicably, my blood sugar was dangerously high despite taking insulin, or what I believed was insulin. I increased my doses, followed medical advice, and couldn't understand why nothing worked. I ended up in ICU with life-threatening DKA, confused about what had gone wrong. Learning my daughter had been replacing my insulin with saline, deliberately causing the medical crisis that nearly killed me, was devastating. Diabetes advocacy groups provided expert testimony. Type 1 diabetes is manageable with proper insulin therapy. What the defendant did, replacing insulin with saline, is equivalent to removing life support. Without insulin, type 1 diabetics develop ketoacidosis, go into coma, and die. The defendant created this situation deliberately. Vanessa's defense attempted to argue she had good intentions. My client was concerned about her mother living alone with a serious chronic illness. Her methods were misguided, but her motive was ensuring her mother's safety. The prosecutor destroyed this. The defendant didn't ensure safety, she created danger. She researched how to induce diabetic ketoacidosis, systematically replaced life-sustaining medication with saline, and caused medical emergencies requiring ICU admission. Text messages show she understood the risk of death and proceeded anyway. This wasn't concern. This was attempted murder to force assisted living placement. Medical ethicists testified. Forcing someone into assisted living by deliberately causing medical crises is antithetical to patient autonomy and medical ethics. The defendant's goal was controlling her mother's living situation by making her appear too sick to live independently. Sick because the defendant was actively sabotaging her health. The jury convicted on all counts. Vanessa received 8 years in prison for attempted murder and pharmaceutical tampering, followed by probation and permanent restraining orders from me. Her husband, who knew about the insulin replacement but didn't report it, was charged as accessory and received probation and community service. Vanessa's children, my grandchildren, were placed temporarily with their paternal grandparents while Vanessa serves her sentence. I have supervised visitation rights, but haven't exercised them yet. How do I explain to young children that their mother tried to kill their grandmother? My diabetes control returned to normal immediately once I resumed using actual insulin instead of saline. My endocrinologist was stunned. Your sudden, uncontrolled diabetes that required ICU admission resolves completely once you're using real insulin again. This confirms the medication tampering caused everything. Extended family was horrified. Vanessa replaced your insulin with saline? Deliberately caused diabetic ketoacidosis? To force you into assisted living? That's attempted murder. The diabetic community rallied around my story. Type 1 diabetics depend on insulin for survival. Replacing it is removing life support. This case shows the vulnerability of people dependent on medications. Medication safety advocates used my case to highlight tampering risks. Patients must be able to trust their medications. Family members with access to homes may tamper with prescriptions. This case demonstrates the potentially fatal consequences. Do I forgive Vanessa? No. She tried to kill me. Slowly, deliberately, repeatedly, by replacing my insulin and causing diabetic emergencies. Can our relationship recover? No. She studied how to induce ketoacidosis, implemented a months-long plan to sabotage my medication, and caused ICU admission, all to force me into assisted living. I'm healthy now, diabetes controlled, using verified insulin from pharmacy directly, stored in locked medication safe. Vanessa no longer has access to my home or my medications. Some betrayals involve replacing life-sustaining medication. Vanessa's was one of them. She wanted control through forced assisted living, got prison instead. I wanted independent living with managed diabetes. Have it, with locked medication storage. 8 years she'll serve. 42 years I've managed diabetes successfully, except the 3 months she sabotaged my insulin. Fair outcome, just consequence, appropriate punishment. Living independently, managing diabetes, using real insulin. Daughter imprisoned for trying to kill me by replacing it. That's where we are, where her choices led, where justice brought us. Some daughters can't accept mother's independence. Vanessa proved that. Some mothers survive daughters' murder attempts. I proved that. She's paying for pharmaceutical tampering and attempted murder. I'm living with restored health and verified medication. Fair trade. Just ending. Appropriate conclusion. Insulin works when it's actually insulin. Who knew? Everyone except Vanessa, apparently. She learned the hard way. 8 years in prison hard. I'm alive despite her sabotage. Free despite her control attempts. Healthy despite her medication tampering. That's enough. That's victory. That's justice. She tried to kill me with saline. Courts killed her freedom with conviction. Appropriate exchange. Fair result. just outcome. Living well is the best revenge. Living at all is victory when someone replaced your insulin. Both achieved, both deserved, both mine now. Despite Vanessa, beyond Vanessa, without Vanessa. Alive, independent, insulin-sustained, daughter-free. Perfect ending to her failed murder plot.